Light, please, Your Lordship.
One second. It will mark nine. Yes. Nine articles. Yes. Yes, Mr. Dhruvo.
Light, please, Your Lordship. I beg to mention item number 28, my lord.
28.
28, my lord. Case diary has not been received, my lord. We are on interim, my lord.
Okay. Mr. D. Bora. Heard Mr. D. Bora, learned counsel for the. What did you say? 28.
28, my lord.
D. Bora, learned counsel for the petitioner. And Mr. D.P. Goswami, learned APP for the state. Mr. D.P. Goswami submits that the case diary is not available and as such has prayed for some time. Prayer is allowed. List this matter.
There is an interim order also.
Makes this matter on 19th of August,
Fine.
2026. The interim order passed delay shall continue until the next returnable date.
19, no?
Obliged, my lord. May I present, Lordship? Lordship, I beg to mention item number 27, Lordship.
27. Okay.
Lordship, diary is not available.
Diary not there. Okay.
Lordship, today is 7 occasion, Lordship. Diary has not come.
Acha, where it should come from?
South Salmara.
What is the place?
South Salmora,
South Salmara.
South Salmara. So why it has not come, Mr. Goswami?
Lordship, we have intimated several times, Lordship.
Okay,
So,
Mr.
Lordship will try to produce that.
There is an
Mr.
interim
D.P. Goswami, learned additional public prosecutor submits that the case diary is not available. Full stop. The learned counsel appearing for the petitioner submits that the case diary has been called on a number of occasions and it is the seventh time that the case diary has not been received. As such, it is directed that on the next date, if the case diary is not received, then this court will take um, uh, um, necessary steps for production of the same. List this matter on 6th of August or 7th?
7.
7th of August,
interim
2026.
order.
Interim order,
Yeah.
interim is there.
Lordship.
Okay, then we can give a longer date. List this matter on
17th.
17th of August, 2026. Okay, interim order passed earlier shall continue until the next return will be.
Obliged.
Yes.
Please, Your Ladyship, I beg to mention item number 24, Your Ladyship. In this
24.
the report from the IO was called for. However, the same has not been received.
Acha. 24, right?
This one.
Okay. You are for the NCB or you are for the central government? No. Acha. Miss
P. Upadhyay.
P. Upadhyay, learned counsel for the petitioner submits that the what report had not come.
Yes.
Report from the IO. Okay, has submits that the report from the IO had not been received, and the same is conceded to by the learned APP for the state. As such, list this matter.
Any date next week, Your Ladyship.
And list this matter on 7th of August, 2026 for production of the report.
May I please, Your Ladyship? Ladyship, I beg to mention item number 15. We have already circulated the adjournment slip. May
Okay.
let the case may be called up for in the 3rd or 4th week of August, Lord.
You are Mr.
A. Hazarika.
Mr. A. Hajarika appearing for on behalf of Mr. Z. Kamar. No. You are for the respondent.
Lordship.
Appearing on behalf of Mr. K. N. Chaudhary, learned senior counsel for the respondent, and a prayer is made for adjournment of the said matter, which is not objected to by the learned counsel appearing for the petitioner. You have objection?
Yes, my lord, not objection. My lord, senior counsel has a small submission to make. Senior counsel Z. Kamar. When the matter gets called up, we have no objection to the adjournment, but a small submission needs to be made. So
Okay, let the matter be called up then.
Okay.
Okay, this is not 5, it's 15. You wait for some time. Okay, not required.
May it please your ladyship, I'm mentioning for item number 21.
Mm.
I would like to respectfully request for a pass over as I have another matter in another court, court number 7.
You don't want to do it today?
No, today itself, my lord.
Acha. Okay, the learned counsel appearing for the petitioner, Miss
Bokali Kasho.
K. Catherine.
No, Bokali Kasho.
Miss Bokali Kasho, prays for an adjournment. And yes, prays for an adjournment and further prays the matter may be listed on when?
No, my lord, today itself, but pass over. Maybe after
Today
that.
itself?
Yes, yes.
Okay, I'll get it. You come and then I'll take it up.
Okay, okay. Thank
Na-
you.
na- na-
Obliged.
May it please, Your Lordship. Lordship, I beg to mention item number 38, Your Lordship.
38. Yes.
Matter may be adjourned for the day, Lordship.
We have received the case diary also.
Case diary is
There are
received?
some difficulty,
Achha.
Lordship.
Okay. Mr.
A.K. Kanu.
A.K. Kanungo, learned counsel for the A.K. Kanu.
Lordship.
Mr. A.K. Kanu, learned counsel appearing for the petitioner, submits that the conducting counsel has some personal difficulty and has prayed for some time. Mr. D.P. Goswami, however, submits that the case diary is received. As such, this court directs that the case diary be retained till the next date and the matter be fixed on 6th of August,
Lordship.
okay, 2026.
I'm on interim, Lordship.
The interim order passed earlier shall continue until the next
Okay.
return. date.
May I please your lordship, I beg to mention item number 26, CD is not received. Please fix it for the, direct for the CD report.
Okay. Mr. D.P. Goswami, learned APP for the state, submits that the case diary has not been received and as such has prayed for some time. The learned counsel for the petitioner has also prayed for an accommodation. List this matter on when?
Seven. It's a BA.
List this matter on 10th of August.
Lordship, 10th of August. Obliged.
I'd like to mention item number 34, Lord.
34 years.
Seeking of precedent.
Okay.
I'm on
Either
interim.
intern, Lord.
Heard Mr.
Al Islam.
R. Islam, learned counsel for the petitioner. Mr. D.P. Goswami submits that the case diary is not received and as such has prayed for some time. Prayer is allowed. List this matter on
19th of August.
19th of August. You are on interim.
Interim is
19th of August 2026. Interim order passed earlier shall continue until the next returnable date.
May it please your lordship. Lordship, I beg to mention item number 19.
Hmm.
Lordship, a new wakalatnama to be filed over here, lordship. So.
Wakalanama on behalf of the respondent.
Yes.
No.
lordship, Nandusha,
Nandu Shah, he is the petitioner.
petitioner, lordship.
And Mayuri Bhuya appears for this.
Yes, lordship, but senior counsel will be appearing for this, so they told me to file a new wakalatnama for this.
For a senior counsel, you need not need a wakalatnama.
Not senior advocate.
Acha, acha, acha.
lordship.
Okay. Otherwise, Mayuri Bhuya is no longer appearing.
No, I'm.
Oh, you are Mayuri
Yes,
Bhuya.
lordship.
Okay. Miss Mayuri Bhuya, learned counsel for the petitioner, submits that that in the instant matter, wakalatnama is required to be filed by other advocates and as such has prayed for some time. Prayer is allowed. List this matter on
Lordship, 5th August,
5th of August 2026.
humble, lordship, God bless. There, please, lordship, I wish to mention item number 39. lordship. The agenda-
39.
The focus call for that is not received, Lordship.
Acha. Heard Miss
PO the good.
P. Odhikari, learned counsel for the petitioner. Mr. D.P. Goswami submits that the report that has been called for in this matter has not been received and as such has prayed for some time. Prayer is allowed. List this matter on. When do you want the matter? When can you bring the report?
It's from Zamuna Mahudai. 10th or 9th?
Okay. 10th of August 2026, the interim order passed earlier shall continue until the next returnable date.
Hey, please, your lordship. So I'm praying for listing of it on criminal petition, man. Next week, and it's
Okay. Next weekend. হেৰি এই মাইকটো ইপিনে আনি দিয়কচোন, এই কেমেৰাত বৰ বেয়া দেখি বা এই কেমেৰাটো সন্মুখত আনক না, এটা কাম কৰক না, এইটো ইয়াতো মানিব নোৱাৰি ন, অকমান নাহে নাহিব, আহিব টেন দিয়কচোন, আহিব, বহুত ৱায়াৰ আছে তলত। ये अजीब सा लगता है वो, नहीं पहले वायर तो घुसी ना जाए नहीं, अखन ये पे ना एन बोली सुनो, नहीं जाएगा, जाएगा तो नहीं है, वायर नीचे बहुत है। यस ओके এটা ঠিক আছে यस हो जाओ 1
May I please, Lordship? Lordship, affair is at page 10, my lord.
when was he arrested?
My lord, he is arrested on the 3rd of July, my lord.
3rd of July.
My lord. My lord, what happened in this case, my lord? As the mother of the girl caused the affair, and as per her statement, my lord, her daughter is of 18 plus years, and the petitioner kidnapped her girl, my lord.
Acha, where is the FIR?
Here is page 10, my lord. I requested that you study about
Okay, I'll read it myself. What is the accused? Wasim Khan.
Wasim Khan, my lord.
Acha, again that Hindu-Muslim triangle.
My lord, that's the problem, my lord. My
Mm.
lord, actual fact is that, my lord, both were in a love relation, my
It
lord.
seems so.
My lord, and police recovered the girl within the same day, my lord.
Mm.
And my lord, kindly page annexure 7, my lord, page 34, my lord. There are some sensitive messages, my lord. I can't read in open board, my lord. If your lordship permits me, I will read, my lord.
Mm.
The girl already knew that he's a Muslim guy, my lord.
Mm.
Well, both were come in a relationship and go to a hotel, my lord. And after that, the mother of the girl lodged the affair.
They are not, they are not Assamese.
My
The,
lord, the boy is from Jharkhand, my lord.
acha, acha.
My lord, he's a meritorious student, my lord. I have annexed his
He is what?
meritorious student, my lord. He's a
Oh, meritorious student.
meritorious student, my lord.
Okay, but it seems there is a, and there is no POCSO involved.
No, my lord.
And-
18 plus, my lord, as per her mother
Huh.
statement. And girl, my lord, already confessed before the, my lord, police, my lord, that she come herself, my lord.
Hmm.
And the message is clear, my lord.
Hmm.
A statement is required on victim statement, Lordship.
Mm-hmm.
Victim statement is required, Lordship. What?
He said that she herself stated before the
My lord,
police that
before
she
the
went
police,
on her own.
already, my lord,
But that is not before us, Lordship.
Yes. Where is that? Her statement?
What is
Uh,
the statement?
not enclosed, my lord, before the police, my lord.
Mm.
We have not received the same yet, my
So we
lord.
have to go through the statement of the victim girl, Lordship.
If your lordship,
Where is the rejection order of the trial court, of the lower court?
my lord, page 45, my lord.
On what reasons it was rejected?
My lord, they both used fake Aadhaar card, my lord. They both.
Acha.
Before, because, my lord, going into a hotel, my lord, they both used for fake Aadhaar card. That's the only reason, my lord.
Because they have to show that they are married.
lord.
Because of that or what?
Probably, my lord.
He is shown as a Hindu.
Uh-huh.
He was shown as projected as a Hindu guy. Lordship.
Uh-huh.
My lord.
Acha, he
And
was
they-
shown as a Hindu boy.
Lordship.
Hindu boy. My lord, but the girl already knew it, my lord. Fact.
Hmm.
So I pay for case jail or short date. We'll try to put it and victim statement, Lordship.
It's a crystal clear case, my lord. Nothing is there in the affair also, my lord. And her statement is already can perish in
And for-
her message, my lord.
Page 49, Lordship. In the rejection order, Lordship.
Hmm.
Admittedly, my lord, both were used fake ID, my lord. Boys also is 24 years, my lord.
She is also 18 plus.
She is also 18 plus, my lord. Very simple case, my lord.
And he is a boy of Lordship. Not a state, Lordship.
Ah,
Jharkhand.
Jharkhand.
Jharkhand,
That is why they spoke in Hindi.
my lord. She used the word like, my lord, Amin, Inshallah, my lord, in her message, my lord.
Okay, heard, Mr.
M.H. Soikia, my lord.
M.H. Saikia, learned counsel for the petitioner, and Mr. D.P. Goswami, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Dispur PS case number 476 of 2026, registered under section 319, subsection 2, 87 of the BNS 2023. The FIR dated 3/7/2026,
My lord.
lodged by the mother of the victim, reveals that her daughter, which was aged more than 18 years, left her residence to meet her friend in a nearby area. However, nearby area, but the informant further stated that she tried to contact her daughter and her daughter was untraced till the next day morning. Full stop. At this, the informant informed the police officials of Dispur police station, and the police apprised her, A na thake, APPRISED, apprised her that the police had traced her daughter along with the petitioner. Full stop. The informant further stated that the petitioner had abducted her daughter and kept her at a different place. And also that the petitioner had physically and mentally tortured her. Full stop. It is also stated that the petitioner had produced a forged Aadhaar card in order to show that he is a Muslim, and in order to show he is a Hindu person instead of a Muslim individual. The learned counsel for the petitioner submits that the petitioner and the victim and the daughter of the informant had a love relationship, and out of the same, the daughter of the informant had gone with the petitioner on her own volition. Full stop. He also submits that the daughter of the informant knew that the petitioner was from a Muslim community, as her messages with the petitioner demonstrated. The Mr. D.P. Goswami, learned APP for the state, submits that it is stated in the FIR that the petitioner had forged his Aadhaar card to show that he is a boy of Hindu community. Upon consideration of the he also submits that the petitioner had abducted the daughter of the informant and had kept her in a separate place with an ill motive, as has been stated in the FIR. Upon consideration of the submissions made by the learned counsels, and more so in view of the fact that the daughter of the informant is above 18 years of age, and she went out herself to meet her friend at 8:30 p.m. on 8:30 p.m. on 2/7, right?
2/7.
On 2/7/2026. And also due to the fact that the messages exchanged between the petitioner and the daughter of the informant shows that they are in relationship, this court finds it fit that the petitioner be released on bail on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount to the satisfaction of the CJM, this Kamrup,
Kamrup Metro Malur.
Kamrup Metro, under the following conditions. The petitioner will not approach the daughter of the informant at any point of time. The petitioner will appear before the investigating officer as and when called for. The petitioner will not, no charge sheet, right?
My lord.
The
no,
petitioner will not influence the witnesses connected with their case. 4, the petitioner will not leave his place of residence without the permission of the CJM Kamrup M.
Well.
Petition is disposed of.
They applied, my lord. Item 2.
Great legal.
Hmm.
In this case, the accused was arrested on 2/7/2026, Lordship.
Huh.
And 20.
What is the offense? 305A is what?
Yes, Lordship, thief, Lordship.
Theft.
Theft.
324 is?
24 is the mischief causing loss or damage the amount of rupees 20.
Okay. So his name was there in the FIR? Where is the
No,
FIR?
on suspicion ground logic, on the place of occurrence logic, one motorcycle was recovered logic. And
Ah.
which was registered one Rajesh Chaudhary.
Mm.
Logic. On
Ach-
suspicion
Okay,
ground,
let me go through the FIR.
Space 8 logic.
Page eight.
Space 8.
Oh, theft at Assam Gramin Bank.
Yes.
Mm.
And logic
So
has
how did he
space,
come in?
space
Hmm?
15 logic ground of arrest logic.
Where
This
is that?
the clear logic. The one Rajesh Chaudhary logic is the main logic.
No,
On
how did he come into picture?
Space 15 logic.
15.
Space 15.
Forwarding.
Forwarding. Ground of arrest.
Where is that? Which paragraph?
And paragraph logic in the middle place.
What is his name?
His
Amit
name is
Devnath.
With Devnath.
Where is the allegation against him?
No, there is no allegation. Lordship.
Only thing is that on para 6 lordship, the recovery of the vehicle along with the oral, documentary and other evidences collected during the investigation provides reasonable grounds to suspect the involvement of Rakesh Chaudhary, alias Rahul Chaudhary, and the other persons in the commission of the offense.
No, where are you reading? During the investigation, second paragraph.
Lordship,
4 accused persons were identified.
yes, Lord.
Vehicle was recovered.
Yeah.
Amit Devnath, Kartik Borman, Rahul Chaudhary in the commission of the offense. Further investigation is okay. Where did you get Deepak Chaudhary's or what name you said? Rakesh Chaudhary?
Para number 6 lordship.
Of grounds of
arrest.
arrest.
Lordship.
The recovery of the vehicle
And other
along
persons
with,
in the commission.
along with oral document and other evidence collected during the reasonable grounds of the involvement of Rakesh Chaudhary.
And other persons.
And and this Amit Devnath was there in second paragraph itself. Involvement of the so and so further
Yes.
reveal the involvement of Amit
Yes, sir.
Devnath.
Okay, then maybe call for also.
Only on suspicion ground. Lordship.
How many days he was inside?
Yes, Lordship.
How many days
Yes,
he has
sir.
been inside?
28 days.
Huh?
28 days.
28 days.
Yes.
You have short date.
Lordship, many terms and conditions. Lordship.
But theft in
28
the
days.
bank.
Bank lordship, yes.
And he broke the lock of few almiras. He could not get, I think, any cash.
That's why.
Yes, sir.
I think fix a short date lordship will try to polish the case. Jai.
Hmm.
Next week any date.
The stolen property was recovered.
Yes, Lord.
All of them.
All of them.
As per the forwarding
As per
some
forwarding report.
some
report was
Remaining
recovered.
stolen property.
Yes.
as per the
Many
forwarding,
terms and conditions.
further
Lordship.
investigation is in progress for recovery of the remaining stolen
Mhm.
property, collection of additional evidence and collection of legal
Mm.
penalties. So remaining stolen property was there also.
That vehicle was registered in the name of Rakesh
Rakesh
Chaudhary.
Chaudhary. That was used on the commission of the offense. Lordship.
It is only suspicion as far
Yeah.
as Amit Devnath is concerned.
Concern. And 28 days, Lordship. Any terms and conditions, Lordship. Maybe release on bail, Lordship. Any terms. and-
What other what is the ground for rejection by the trial or whatever court?
That is not annexed here. Lordship.
No.
Not annexed.
No.
Rejection order you have not annexed. Why? You should have annexed the rejection order.
First time.
I think it is provided in the Gauhati High Court rules. You have to annex. Or it is provided only in respect of Gauhati High Court bail orders.
Yes.
The
No,
Gauhati High Court
other-
rule
no.
says what? He has to annex
Against
the
the previous bill orders also.
previous,
Rejection orders.
even by other courts.
Lordship.
Okay. Heard Mr. M.A.
Yes,
Mandal.
Yes.
Learned counsel for the petitioner and Mr. D.P. Goswami, learned additional APP for the state. By this application, the petitioner has prayed for bail in connection with Fokiragram PS case number 26 of 2026, registered under section 305, within bracket capital A, 324, within bracket capital, within bracket 4, BN of BNS 2023. Or along with section 317.4 of BNS. The FIR dated, what is this date here? 2/7/26 or what? 2/7/26. Oh, no. Forwarding is 2/7. The FIR dated 1/7. No, 29/6. The FIR dated 29/6/2026. On the basis of which the petitioner was arraigned as an accused person and was arrested, was lodged by the officials of, by an official of Assam Grameen Bank, Chitila branch, wherein it was inter alia stated that a few unknown miscreants entered the said bank through the back door and they tried, and the said miscreants tried to break cash vault, but were unable to do so. But they removed some documents and had also broke 2 numbers of Godrej lock. Full stop. It is also stated that the CCTV camera was found missing inside the said bank. The police, on receipt of the Ejahar, investigated, and during the investigation, they arrested the petitioner along with others on suspicion of their involvement in the said offense. The police in the forwarding report had stated that a vehicle was used during commission of the offense and that the vehicle was owned by one Rakesh Chaudhary. It is also stated in the said report that there are other persons involved in the crime and that petitioner is one of them, and as such he was arrested. Learned counsel for the petitioner submits that the petitioner was arrested only on suspicion and that no concrete material were found against him. Materials were found against him. Mr. D.P. Goswami, learned APP for the state, submits that the petitioner was suspected of having committed the crime along with others, and that the case diary would reveal the entire gamut of the case. Upon consideration of the submissions made by the counsel and on perusal of the forwarding report, it is seen that the petitioner was arrested only on the basis of suspicion and that further investigation is in progress. And that it was stated that further investigation is in progress. It is further seen that the petitioner has been inside for almost a month, and as such, this court, almost a month, and that his interrogation is over. And as such, this court deems it fit to enlarge the petitioner on bail on furnishing of a bail bond of rupees so and so to the satisfaction of CJM Kokrajhar under the following conditions. Petition is disposed of. Yes, Mr. Hajrika.
Regular bail application diary may be called for at this stage.
Hmm?
Diary may be called from.
Okay, what is 178/79?
Well, if there is a
Recovery
allegation
of
that some fake
fake currency.
currency has been recovered.
Oh,
from
fake
them.
currency. Okay, let the case diary come. Heard Mr. P. Hajrika, learned counsel for the petitioner, and Mr. D.P. Goswami, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Laluk PS case number 132 of 2026, 26 registered under section 178, 179, 180, 61 to 111 to small b of BNS 2023. Call for the case diary. List this matter on, this is from where?
It is from Laluk, Lakhimpur.
Laluk. Laluk is where?
Lakhimpur.
Lakhimpur. So list this matter on, what, 7th of August? Or it will be late? 7th of August.
That we lost.
Mm.
20 years boy lordship is in my lord the judicial custody for my lord the
20 years boy.
Application is my lord the vehicle, my lord motorcycle was stolen and that was recovered lordship. My lord, it is not my lord the organized crime lordship.
Huh.
It was allegedly recovered from the position of the petitioner.
So
on
cases
vehicle.
of theft.
So, oh, lordship.
Theft.
Yeah.
Okay, where is the
Thank you,
FIR?
lordship, oh, my lord, this days, my lord, CD will, my lord, reveal the recovery of such, my lord.
Okay, let me see. I can also give bail, provided the
Yeah, this case
circumstances are conducive. So where is the FIR?
Affair is at page 9.
You are only praying for CD or what?
No, lordship.
Acha, acha.
At least.
Where is the FIR?
Two lines.
FIR is of 3 line. Page 9.
Yes,
3 line FIR.
yes, lordship.
Oh, unknown. Most important, my glamour bike was stolen by unknown theft from the house of my brother-in-law. Shohid. Many searched many times but not traced out.
My lord, at page 16.
Stealing from somebody's bike. Okay, where is the forwarding?
Forwarding at page 18, lordship. It is not stated, this is organized that in.
So it was seized. The
Recovered from
bike
his-
was recovered
From his
Yes.
position.
His from his.
from his possession.
Yes,
Yeah.
From the
I'm-
possession of Baharul Ali. Baharul Ali is the
Lordship.
petitioner.
Has
He has
allegedly
broken the
recovered.
number plates and stolen bike.
Oh, bearing chassis number plate of the bike broken by the apprehended
To
person. So
decimate the identity of the vehicle.
From his.
he had made
possession,
every
my lord,
attempts to.
From his possession allegedly recovered, lordship. So, my lord, at this stage, my lord, my lord, further detention may not be necessary, lordship. Because lordship already recovered, my lord, if CD is covered, something will be repeated. My lord,
CD may be called for lordship because.
My lord, so at this stage, it may be granted bail, lordship.
This is BA.
That concept, yeah,
Yes.
So what is CDN at this stage?
already 24 days.
Already, if at all bail,
Yeah,
bail,
my-
no CD.
Young boy, lordship, on, my lord, it is not stated in the, my lord.
But the stealing of bike of someone else, I mean, imagine the
Yes.
kind of tension that the other person had, and you had tried to even change the number plate.
Releasing him and another do the another same thing again and again.
You have been inside for how many days?
For 24 days.
24 days.
Not organized crime, my lord.
Not organized crime, okay. Until. So you were not given,
Rejection order also.
Young boy, lord, 20 years, lordship.
acha, until we complied with.
Already got lessons.
He had cut the wire of the vehicle and after joining, he had started it. That means.
Yes. He is experienced holder.
Yes.
That is right, but
Okay, he was inside the jail for so many days. He should not indulge in such activity again, but who will see?
my lord.
There will be no police personnel behind him every time. Okay. Heard Mr. Ahmed, learned counsel for the petitioner, and Mr. D.P. Goswami, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Hajo PS case number 300 of 2026, registered under section 305 within bracket small a. What is this small a?
Yeah.
Of BNS 2023. The FIR in connection with which the petitioner has been arraigned as a accused person and was arrested was lodged on 2/7/2026, stating inter alia, lodged on 2/7/2026, wherein it was stated that the bike of the informant was stolen by unknown thief from the house of his brother-in-law. The police, after registration of the case, during investigation, had recovered the said bike from the possession of the petitioner and arrested the petitioner, and that the petitioner is in judicial custody for a period of 24
days.
4 days till date. Learned counsel for the petitioner submits that the petitioner is of 20 years of age and that it is not an organized crime, and also that he has been inside the jail for quite some days. Full stop. The learned APP for the state submits that the bike was found in possession of the petitioner, and it is also seen that there is attempt made to change the number of the said bike. He also had pointed out that the accused, that the petitioner is a habitual thief, as he could start the bike without the keys, as has been stated in the forwarding report. Upon consideration of the submissions made by the learned counsels for the parties, more so due to the fact that the bike has been recovered, and also that the petitioner has been inside the jail for almost a month, this court finds it fit to enlarge the petitioner on bail, on furnishing of a bail bond of rupees 20,000 with translation of this to the satisfaction of CJM.
Learned judicial magistrate first class Haju.
Learned judicial magistrate first class Haju under the following conditions. The petitioner, at a condition that if the petitioner is found indulging in such activities, the court, the learned court would be at liberty to cancel the bail.
Obligers.
Yes.
So this is an interesting matter where the victim as well as the informant both were taken into custody, Your Lordship.
Victim and what?
The informant as well as the victim who has been made an accused in this person, he is also being arrested as well as the informant also being arrested, Your Lord.
Now accused is no longer accused.
Accused is the victim.
Oh,
There are two
accused.
FIRs, Your Lord.
Acha.
Lordship, they kindly go through the FIR at page 20.
And what are these offenses? 329, 296?
329(4) is the trespass.
Acha.
The 326 is a public obscenity. The 117(2) voluntary causing grievous hurt. And 74 is the criminal force against women.
Acha.
And 35 is common intention. And non-believable section is only 74.
Acha.
Now-
Where is the FIR? I did not get the facts, so I want to
Yes, Lordship. Firstly, the FIR was lodged by the petitioner, Your Lordship.
Acha.
And that FIR is at page 20, which was registered first as Sat of years 84.
Page 20.
Page 20.
There is a cross FIR also.
Yes, Lord.
Page 20.
Page 20.
This is by the petitioner.
This is by the petitioner.
Earlier at point of time.
Yes, it was registered as Satgaon PS 84 and the cross was registered as 85,
Oh.
which we have come for bail.
Acha. Acha, show me the FIR against you.
Yes, that the lordship will file at 13, 1-3.
Okay, I'll read it myself. Wait.
Yes.
Sahadat Hussain Talukdar.
Yes.
There has to be a separate story.
Yes, Lordship. The story is there in my affair, Lordship.
Sahadat Hussain and wife
Yes.
had chased them
Now,
in
Lordship,
their own house and then struck him by.
I have annexed the pictures here, Lordship.
Acha, struck me. The husband has lodged. No, the
No.
wife.
The wife is already been allowed to go on bail by the police.
Acha, wait. On my leg. In the evening also he came. He parked his vehicle in the one of his land.
Now, Lordship, may kindly go through my affair. This is at page 20, Your Lordship. Please.
1 minute. I'm just going through. Mofizuddin is the wife of the informant. Daughter.
Mofizuddin is the husband of the informant.
No, daughter. Mofizuddin is the father of the informant.
Of the Mofizuddin. Yes, informants.
Father.
Yes, yes.
He's a person. He's a person.
Why is this tussle with the both the families?
They have a land dispute, Your Lord. They are saying that our property belongs to them. And that reason they have trespassed our land, Your Lordship. I have annexed the pictures at 27. Page 24, from the page 27, Your Lordship.
So, any injuries?
Yes, they have beaten the child. Two children of the petitioner was locked inside the room. They have locked it. I have annexed the photograph. They have broke everything in their house. More than 1 lakh has been property has been destroyed, and the section that is registered against them is.
So it's basically a land dispute
Yes.
between the two parties.
324(5) is mischief that caused property loss more than 1 lakh. That is registered against the informant.
And same allegation against the petitioner also. He was assaulted by.
Now
and
they,
the minor child
Instead
was
of going to
assaulted
the authorities, they started.
Yes.
they have trespassed into our land, not we have gone to their land, Your Lordship. And these pictures clearly suggest they have.
And the
destroyed-
other party said that you had trespassed on their land
is-
and then.
That is the being to be in the safe side, they have lost their.
So let the CD come.
Yes, the injury part was there. So minor girl was assaulted
Now,
by.
Lordship, till then, Your Lordship, he doesn't deserve.
What till then? This is bail application.
Yes, Lord, interim may be given to him, Your Lordship, because he doesn't deserve to be in the jail, Your Lordship. He is the
Fix a
victim.
short date, let the case diary come.
He is the victim.
What
itself.
interim in bail application?
Short date,
He may be
what is the case diary?
Go interim,
Next
he may be
week,
allowed, Your Lordship, till the next step, he may be allowed to go on interim.
Again, he will surrender. Now, interim in bail application, okay, on some health grounds and all. But here, let me see the CD.
Lordship, the pictures clearly shows this is their compound. They have trespassed into their land. They have cut down all the trees. They have destroyed
So
their
he has been
vehicles.
inside for how many days?
I have been
8
inside for
days.
21 to 9 days today.
Let the case diary come.
Lordship, kindly
Okay,
keep,
heard Mr. Diullah,
Assam.
S. Ahmed, learned counsel for the petitioner, and Mr. D.P. Goswami, learned APP for the state. Call for petitioner has prayed for bail in connection with Satgaon Police Station case number 85 of 2026, registered under section 329, subsection 4, 296, 117(2), 74, and 35 of the BNS Act 2023.
Lordship, one simple submission at page 33, Your Lordship.
Mm.
This is the Baniwara Khatun who has, this is the informant in my case. You can
No, I've
see-
seen the
Yes, yes,
pictures.
He is coming with an axe and all inside my.
No, I'm not in favor of any one party. Both of them should have gone to the authorities instead of
They
taking
have
arms
gone.
in their own hands.
He was being noticed. He went to the police station for cooperation and he
But
was
this
being
lady,
arrested there.
but this lady is who? Sahadat's wife.
Oh, Lordship.
in the photograph?
This is the lady, is the Mofidin's wife, the Bani, no,
Okay.
the daughter of the, that is the informant.
Mofiduddin.
Yes, he is in the picture there in with the,
Okay,
and all.
let the case diary come. We are not sure who had attacked whom.
Please,
So,
Lordship, please-
both of them had said. Of course, the one FIR is prior in point of time, but then
Let the CD come.
It's clearly depicted that
I
they.
call for the CD. List this matter on. You
But
bring
they-
the CD soon, Mr. Goswami. Where Sadgaon only. List bring the CD. Call for the CD. List this matter on 5th of August.
Lordship.
Next Wednesday. Today is Wednesday. Next Wednesday.
Obliged.
May please, Lord.
Mm.
The regular bailiff is, 32 days behind the bar, my lord.
Mm.
It is absolutely false, as a harm, my lord. The petition is absolutely innocent, my lord.
A petitioner always says that he is innocent.
Madam, kindly see. This is was missing on 19/4 at about 12 AM, my lord. And on the very day, when the nephew of the Yazarkari informed to the.
Acha, show me the FIR. Show me the.
Missing.
Acha, show me the FIR.
FIR under
FIR is
section
based
103
on-
murder.
Junabali. Oh, 103 is there. Somebody has been killed.
He is absolutely suspected after 32 days, my lord, the allegation brought against the petitioner, my lord.
Acha, what is his name? Junabali.
Munabali, man.
Where is the FIR?
FIR is based to us, man.
Okay, I'll see the FIR. Wait.
So many,
There are so many accused. Junabali, Murtaz, Ziaur. Okay.
four numbers of.
That my elder brother, Nabir, was
number
at stayed at
five, five.
Jalukbari for his business.
He has 4 children, my lord, and leaving the.
Wait, I'm reading the FIR. Just a minute. The translation is really horrible.
Not SME particular is, my lord,
It is.
18, man.
The petitioner stayed with the accused number 1, Mumtaz Begum.
Montas Begum.
Initially, they started the business together, or whatever, they stayed together. Thereafter, there was a quarrel.
Right.
And then Mumtaz and the accused separated themselves, right?
My lord,
And the accused number 1 was staying alone while leaving my brother. What brother? My elder brother. Okay, my elder brother was staying there. His, okay, informant's elder brother was staying with the accused number 1.
number 1.
And then later on, there was a quarrel and they separated.
Right.
And then on so and so date, the nephew informed that his brother died. Brother was not found. And they are suspecting that all the 4 had.
Yes.
And it is also suspected that accused number 1 had illicit relationship with 2 and 3.
2 and 3.
She had relationship with the brother of the informant. She had relationship with 2 and 3.
This is the false allegation, but after 32 days, it is brought in the petition.
Let the case may come, not admit to respect of the case.
But one thing is there because the brother was found missing and then his dead body was found in the afternoon, 6 p.m. And then they were just the allegations
injury
were on the basis of suspicion.
some injury was there in the dead body.
So many injuries. Initially, it was said that he was given some ORS. Yes, and he became senseless.
Person was given the.
But because the
It is from-
petitioner,
it is from Jalukbari, Lordship, given a short date from Jalukbari only.
okay, let the case diary come. A person has died.
Yes, Lordship.
Right. Okay. Heard Mr. B. Islam,
Man.
learned counsel for the petitioner, and Mr. D.P. Goswami, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Jalukbari PS case number 197 of 2026 under section 61, subsection 2, 103, subsection 1 of the BNS 2023. Call for the case diary. List this matter on, this is from where?
Jalukbari.
Jalukbari only. List this matter on 6th of August. 6th of August.
It is short that maybe.
6th is too short. Next Thursday.
The 29.
Huh?
It is 29. 3rd of August is Monday. So 6 is okay, Lordship.
Okay, 4th of August. Try 4th of August. Hmm.
Under this petitioner, father and the 12th plus reading son, they are arrested on 25.
105 is there. Somebody has died.
Yes, yes. In fact, died, in fact, there is an altercation. Someone or out of that, was a victim, received minor injuries. She was medically examined and released. After 2 days, because of some other reason, he was admitted in a hospital and he's expired in the evening, So in that way, this section is added now. That reason is that.
Homicide.
Yes, yes.
Acha, show me the FIR.
Yes, madam. You
What?
kindly come to page.
Sunil Das,
Yes.
or what?
Das, madam, he is the father and petition number 2. He is 19 years old, madam, class 12 reading student, madam.
Because Das is the son of Sunil Das.
Because son of Sunil Das.
Mm.
You also will kindly come to page 12, madam.
Mm. Okay, I'll read it myself. But one day after.
Yes, 24th. Incident took place on 23rd.
I also that incident was occurred on 22nd, madam.
Acha, 1 second.
Yes.
Maybe that stomach ache is because of the injuries.
My lord, had it been any previous assault, my lord, he could not have been discharged, my lord. He was medically examined and released, my lord. Had it been there any severe assault, my lord, he could not have been discharged, my lord. He was discharged from the police station itself after medical examination. And this is here, my lord.
That will reflect on the PM report, Lordship.
I saw, my lord, here you also will see in the today on 24/5/2026 in the morning hours, suddenly my husband suffers severe stomach pulse, vomiting. As such at 9:30 a.m. admitted in the Zuhal Medical. So in fact, 24th, my lord, he was admitted again. Incident was of 22nd, my lord. So after exactly 2 days.
No,
So-
incident was on 22nd, okay.
Yes, your
No, 23rd.
Yes, in fact, my lord, that is the night hours after 12 midnight, my lord. So that is the reason the date has been, my lord, given as.
Whatever it is,
1:30
1:30 a.m.
Yes.
on
Yes.
23rd.
23rd.
Yes, 23rd.
So 1:30 a.m. assaulted in front of somebody's house.
Your lordship will kindly.
He
come-
must have
Yes,
a call from his house or what?
your lordship will kindly come to the, my lord, forward.
Okay, let the case diary come.
Yes.
Things are not very clear.
In
At
fact,
1:30, how that deceased person was outside the house of Sanjit?
your lordship kindly.
He
come
must
to,
have
my
been
lord-
called.
My lord, your lordship
Might be
kindly come to page 19, my lord. This is clear, my lord.
Hmm.
How this has happened.
Hmm.
That is the ground of arrest at serial number 5, my lord.
Hmm.
As per the statements of the witness, it is alleged that one Sanjeev Das, son-in-law of the deceased Sushil Pal, had been maintaining an illicit relationship with another woman, namely so-and-so, for a long time. Due to the said relationship, Pinky Pal, wife of Sanjeev Das and daughter of the deceased Sushil Pal, had been residing at her parental house for the last 1 week. On 22/5/2026, at about 10 p.m., a quarrel took place. So this is the incident when it started. Took place between Sanjeev Das, Kamala Ravi Das, and the family members of Pinky Pal regarding the said matter, during which accused Sushil Das was also present. Somehow, my lord, I was there, my lord. The family members questioned Sunil Das and made allegations against him in connection with the matter. In fact, Sunil Das, he was asked for their relation, my lord. It's not, my lord, anyway I am connected with.
Acha, it is there in the grounds of arrest, but
Yes,
let
yes.
me see the CD. I'll
Your lordship
fix
may
it.
have it, but my lord, if there was any, my lord, grievous assault, he would not have been discharged, my lord. That is my lord, my understanding, my lord.
Where it is from? Which place?
That is from Juhat, my lord.
Okay, heard Mr. J.C. Bora, learned counsel for the petitioners, and Mr. D.P. Bora, D.P. Goswami, learned AP for the state. By this application, the petitioners have prayed for bail in connection with Jorhat PS case number 160 of 2026, registered under section 118, 2, 105, 351, 2, and 35 of BNS 2023. Call for the case diary. List this matter on 10th of August.
Yes. Can it be on 7th, my lord? 65 days stays on today, my lord.
Acha. 7th of August 2026. Okay. Yes, Ms. Ghosh.
Lordship,
Unusual to see you in bail matters. Mhm. So what is this offense?
opposite 75-2, Lordship.
75-2 is what?
Yes,
What is that? 75?
sexual harassment.
Sexual harassment.
Harassment.
Minor girl?
Not
No.
minor, adult. And domestic help, at that time, wife is also present in the house. Minor daughter of the petitioner also is there in the house, and other persons were there in the house.
Okay, Imtaz Rahman.
Yes, Lordship.
Show me the FIR.
FIR is at page 19, Lordship. Vernacular is at page 21, Lordship.
Translation is okay.
Translation, only one later on came through, is not assistant, he should have been deputy, but in the FIR form, it's written as assistant manager.
Okay. Like to state that I am Sukanti Kyat. Okay, he attempted to sexually assault her, touched her private parts.
Yes.
This is what the allegations.
Allegation, Lordship. It's an allegation. And Lordship, bail was rejected by the, when he was produced by the trial court, Lordship, which I have annexed, Lordship, is at page 35, Lordship. And Lordship, 183 statement of prosecution witnesses, most of them are over. I have annexed.
What about the victim statement before the magistrate?
It already recorded, Lordship.
What did she say?
Reflected in page number 37, Lordship.
You have annexed the
Yes,
statement?
yes, yeah, no, not statement.
Acha.
Statement is kept in a seal cover. Lordship. But I have annexed the order of the learned trial court. Order dated 27/2026, Lordship, page 37.
Where is the rejection order you said?
Rejection order is at page 35, Lordship. On production, this bail application was made.
Okay, on conditions, let him be on bail. This is BA.
BA lordship.
He has been inside for?
Although it's shown as 20th of July, but he was kept from 19th.
19th of July.
19th of July, Lordship. Incident happened, Lordship. There is delay also in lodging the FIR. Incident happened on 18th at 8 a.m. as per the FIR, Lordship. But the FIR was lodged on 5 p.m. on 19th, Lordship. And the concerned police station where the FIR is lodged is hardly 4 to 5 kilometers from the
No,
place of-
initially she had informed it to the president and the committee
Yes, yes,
members.
Lordship, that
So
is-
perhaps that took some time.
I came to know, Lordship, before the internal committee also a complaint has been lodged under the sexual harassment of women at workplace,
Okay.
prevention, prohibition and redressal.
Okay,
The
heard
victim
his,
statement was recorded, Lordship, after present the case, there is learned trial court rejected the prayer.
that is there. But then it's okay,
But
bail.
Other witnesses also, I have a next Lordship, page 38,
Mm.
also being recorded under 183 statement.
Okay, heard Ms. D. Ghosh, learned counsel for the petitioner, and Mr. D.P. Bora, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Hari Singha.
Yes,
Hari Singha Police Station, case number 16 of 2026, registered under section 75(2) of BNS 2023. The FIR in connection with which the petitioner was arraigned as an accused and arrested was lodged by the victim herself on 19/7/2026, by which it was stated that the victim was working as a permanent worker at Majuli Tea Estate, and that on 18/7/2026 at around 8 a.m., while she was working at the bungalow of the petitioner called her to his bedroom and asked her to give a head massage. Full stop. She further stated that while she was massaging his head, the petitioner had touched her private parts, and when she resisted, he attempted to sexually assault her. The learned counsel for the petitioner submits that the petitioner submits that the what are your submissions? That her statement was what are your submissions?
First thing, Lordship, her statement is already recorded, and the most of the witnesses, their statement under 183 is already recorded. So, and investigation is
Okay, submits that the
the
petitioner has been arrested on
20.
27/2026, and that he is behind the bars since 19th, you said.
Yes, 19 he was in the.
And that he is behind the bars since 19th July 2026. She also submits that the statement of the victim was recorded under section 183 of the BNSS, and also the statement of other witnesses. Full stop. She submits that investigation has been conducted to quite an extent, and that the petitioner be released on bail. Mr. D.P. Goswami, learned APP for the state, however, submits that there are allegations against the petitioner to the effect that he tried to sexually assault the victim in his house, and that in his house, full stop. Upon consideration of the submissions made by the learned counsels for the parties, it is seen that the petitioner was inside the jail for quite some time, and that it is reflected in the orders of the which court orders of the SDJM Udalguri, that statements of the victim as well as other witnesses were already recorded under section 183 of the BNSS. And as such, this court deems it fit to enlarge the petitioner on bail on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount to the satisfaction of SDJM
SDGM.
Udalguri.
Udalguri.
SDGM Udalguri under the following conditions. Say, Budiba. He will appear before the investigating officer as and when called for. He will not influence the witnesses connected with the case. He will not tamper with the evidence. He will not leave the place of residence without the permission of the SDGM Udalguri. Petition is disposed of. Yes.
Lordship, in this matter, Lordship, I have mentioned the PRC number wrongly, my lord. So I may be allowed to withdraw with a liberty to file a fresh.
Okay. Mr. H. Ali, learned counsel for the petitioner, submits that there are some mistakes in filing the instant application, and as such, he prays that the instant application be withdrawn with the liberty to file a fresh one. Prayer is allowed. Petition is closed.
Hello.
Yes, please, your lordship.
Mm.
I am the FIR named accused Razi
Mm.
Ali alias Ajizul Haq. The
Acha.
case has been registered under by sanctuary case number 147.
Okay,
of the-
14 is the FIR?
Yeah, the FIR is in case number 14.
14. I'll just read it, wait. The name of the petitioner is Rajiv Ali, Ajizul Haq.
Yes.
Rajiv Ali. So he was attacked and he suffered injuries. You have mentioned the injuries here.
No, lordship, there is no Alice section relating to her. Although even though it is mentioned in the contents of the FIR, there is no any section relating to heart.
But what have you annexed? You have annexed some medical certificate. What is this?
Lordship, previously a scuffle took place between me and.
No, the medical certificate is of the accused,
Yes, yes, Lord.
Ajizul Haq.
Yes, yes, Lord. Prior incident, 4 to 5 days prior incident.
He was attacked. Petitioner was attacked.
Lordship, although the police has registered the case under the serious offense punishable under section 109 of the BNS on the elusive person given by the informant alleging an attempt to kill him. Here it is pertinent to point out that the informant himself has stated that he could not make out the reason and purpose behind the alleged act.
That I have seen.
Yes. Also, there is no alleged action relating to her. It raises serious doubts regarding the existence of any prior circumstances or motive from which the intention of the accused.
Yes, intention is, of course, it will come later. But as far as the attacking by the petitioner is concerned, that is said. And let me see the injury report also.
Also, injury was there also.
A grievous injury as per the police. It is registered under 126(2). 126(2) is what?
Restraint.
Full restraint.
Wrongful.
And 109 is attempt to murder.
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 Let the case diary come.
The case diary comes.
And also,
AB, right?
AB.
I would like, actually, there is a different story behind.
Okay, that will come out. But then we are only with the FIR.
The injury part was there also.
And the lower court has also rejected on finding sufficient materials against you.
Yes.
So let me see the CD interim.
The injury was there also. How much injury is injury report is required also. Going to the FI injury was
What do
there.
you say on interim?
In terms of the CD come after day after also consider absolute.
Not under of my family. And I have to look after my old parents.
The allegations is serious, but
There is continuous threatening from the other side.
What is the other story? Have you pleaded?
Yes. Lord.
Where is this written? 7. So the petitioner was beaten up earlier
Yes.
by the same informant. What was the reason of this market?
Actually, he wanted to create a syndicate in that locality. He's also
Wanted to create a
syndicate.
syndicate.
He's also related to transportation. The complainant is also, or the informant is also related to transportation business. And along with certain other person, he wanted to create a syndicate in that locality.
But in the medical certificate that you have annexed, it doesn't show that those injuries were by way of hitting, ray, chest, and view. This is X-ray. Then these are injections. We cannot say that this was due to assault.
There was a scuffle, my lord.
Let the case diary come, okay? Heard, Miss
My
G. Borua, learned counsel for your name, please. G. Borua. G. Borua, learned counsel for the petitioner, and Mr. D.P. Goswami, APP, the learned APP for the state. By this application, the petitioner has prayed for bail in connection with Changsari Police Station case number 147 of 2026, registered under section 126 to 109(1) of the BNS 2023.
lordship, medical report of the informant may also be called.
Call for the case diary along with the medical report. List this matter where Changsari when?
It's from Kamrup, Lordship. 7th.
7th of August, next Friday. 7th of August 2026.
Kindly may allow for timing 11 and 12. Because in this council he is lagging.
After some time.
11 and 12.
11 and 12. Okay.
13.
11 and 12. 13 to Matan.
This is an heavy, my lord. FIR is page 14, my lord. Page 13 is the FIR. Case is that, my lord, the informant and the FIR accused number 1 got developed some romantic relationship with a promise to marry, my lord.
Okay, where is the
marriage
FIR?
did not happen. They eventually led this present case, my lord. However, the crime accused got interim bail by this honorable court.
Acha, where is the
petitioner
FIR shown?
number 1 is the mother of that accused number 1, and
Okay.
petitioner number 2 is the cousin brother of petitioner accused number 1.
Acha, FIR is at page 13?
Page 13.
Okay, let me first
Yes.
make out the case. It's a long FIR.
Yes.
Long affair.
What is the petitioner's
The
name?
interim order
Nisima Begum Haq and
and Hifa Sami Arif,
Nisima Begum Haq is the mother of
mother of the prime accused.
Hafiz Sami.
Hafiz Sami is the cousin brother. Cousin, the aunt's son.
Main accused has been enlarged.
Yes.
This
On
page
interim bail.
18, Lordship.
Page
Page
18
18
is
is
the
the-
interim order.
Okay, I'll see the FIR first, wait. He is an advocate.
Yes, my lord. Practicing at
Sipsagar. Nishima Begum Haq. So, mother of Hifaz Sami.
not mother of the
Petitioner
prime
number 1 is the mother of Hifaz. Petitioner number 2.
Not. Petition number 1 is the mother of the accused number 1, that is the prime accused.
Numan Rizvi.
Yes.
See the contents of the FIR.
Yes.
The Numan Rizvi Haq, by profession an advocate, his brother, Hifaz Sami, and
Yes.
his mother, Nisima.
Yes.
As if these two are brothers and mother. This mother has 2 sons.
No, no.
Acha.
FIR, she written that much. Actual fact is that the Hifas Sami.
And FIR is by the mother of the victim.
No, victim herself.
Victim herself, okay.
She also a law student, my lord.
Nisima
okay.
Begum is the wife of Nizamuddin Haq, and Hifaz Sami Arif is the son of Arif Ahmed.
Acha.
That boy is already granted interim.
Against Hifaz Sami, that repeatedly used highly offensive, derogatory, and abusive language against me. That allegation against Hifaz. And Nisima Begum's allegation, he managed to obtain my father's contact number.
And what about mother? The primary accused mother has managed to obtain my father's contact number.
Yes.
Views and
False allegations
insults. My
against us.
parents were completely unaware of the honor. Okay, heard Mr. Whose name should I put? Yes, what is her name?
You.
Huh?
You.
Yu Khan, heard learned Mr. Yu Khan, learned counsel for the petitioner, and Mr. D.P. Goswami, learned APP for the state. By this application, the petitioners have prayed for bail in connection with Jalukbari PS case number 264 of 2026, registered under section 117, 2, 142, 351, 3, 69, 79, 89 of BNS 2023. The FIR, yes, Mr. Kamar, you are there for that matter, where you wanted to say something. Okay, after this we can take it up. Okay. By the FIR, on the basis of which the petitioners are arrayed as accused persons, was lodged by the victim, stating inter alia that she had a relationship with the main accused person, namely Numal Rizvi Haq, Numan, Numan, Rizvi, Haque, Haq, and that the said accused person had abused her both physically and mentally, and has refused to marry her. Full stop. The informant had further alleged, the informant had further leveled allegation against the brother of the, he is the cousin brother, against the cousin brother of the main accused person, as well as the mother of the main accused person. Full stop. She stated that that petitioner number 1, who is the mother of the main accused person, had hurled abuses about, hurled false allegations about her, and had stated and had informed the same to her father. And that petitioner number 2, the cousin brother of the main accused, was also alleged to have scolded her with filthy language. The learned counsel for the petitioner submits that the main accused person is Numan Rizvi Haq, and he has been enlarged on bail by which court?
By this honorable.
By this court. By
Interim
this court.
Interim bail.
By this court, which he has annexed in the instant petition. He further submits that false allegations are being leveled against the petitioners by the informant. Mr. D.P. Goswami, learned additional public prosecutor for the state, submits that specific allegations were made against the petitioners to the extent that both of them have insulted her and had caused her serious mental trauma. Upon consideration of the submissions made by the learned counsels, more so in view of the fact that The main allegations were against the main accused person, who has been already enlarged on bail. This court finds it fit that the petitioners be also enlarged on bail, also enlarged on pre-arrest bail, on furnishing of a bail bond of rupees 20,000 each, with one local surety each of the like amount to the satisfaction of arresting authority, under the following conditions. He should appear before the investigating officer as and when called for. He will not temper, he will not influence, they korba. They will not influence, and they will not leave the place of residence without the permission of the arresting authority. Petition is disposed of. No, disposed of. These are mother and brother.
They are from Sibsagar, and the case is registered in Gauhati, so they reside in Sibsagar. So that without prior permission, that cannot.
Prior permission of the CJM Sibsagar. CJM Sibsagar, huh? Prior permission of CJM Sibsagar. Yes, Mr. Kamar, you had something to say? And there was a prayer for adjournment.
Actually, they will be seeking time, my lord.
Huh.
I have got no issue, my lord, because
Hmm.
his senior counsel is out of pension.
Mm.
No, sir. That's why they are seeking time, my lord. Otherwise, only issue is that, my lord, that this is a criminal petition, there is a connected petition also. I don't know about the particulars of that. I'll find it out, but a date may kindly be given accordingly.
Okay. And you want the other petition also to be tagged?
Oh, yeah, but first I have to find it out, my lord.
You have the number.
She will not mention, my lord.
Okay, I'll just say that there was
Yes.
an analogous and that may be tagged together.
If, yes, we'll approach the registry in that case, Lordship.
And, okay,
Actually, they
the
are
councils
seeking
will approach.
Yes,
Okay,
yes.
Lord.
Okay, heard Mr. Jet Kamar. What is the item number? 15.
1-5.
1-5. Heard Mr. Jet Kamar, learned counsel for the, learned senior counsel assisted by Mr. P. Chaudhary, learned counsel for the petitioner, and Mr. DJ Das. DJ Das, Drupad something, DJ Das, learned counsel for the petition, for the respondent. There is a prayer made for adjournment by the learned counsel appearing for the respondent, and same is allowed. Further, Mr. Kamar, learned senior counsel, submits that there is an analogous petition connected with the instant case, which has been filed before this court. And he prays that the said matter be also be listed along with the present one. It is as such directed that the learned counsels may approach the registry with the number of the same, and both the cases be listed together on the next date. List this matter on
26th of August, Lordship.
26th of August.
26th, no, 24.
26th is Wednesday.
24th, my lord.
24th of August, right, Mr. Rupert?
Lordship, yes.
24th of August, 2026.
That will do, much obliged. Much obliged, Lordship.
Yes.
So in this case, series of FIR had been lost.
Serious series of FIR.
Series.
Acha.
5 numbers of FIR had been lost. So, and then.
One FIR was not enough against you.
No, so I am not in the name.
Any of the FIR?
No.
Acha. So,
So then.
how are you implicated? Why are you apprehending?
So one Dilip Soikia,
Huh.
in page number, his FIR is page number 28,
Okay.
He stated that
28 is in Assamese.
yes, Lordship.
Any English translation?
Yes, Lordship.
Acha. Okay.
26.
Mm.
Lordship.
What is the FIR against you? I mean, you are nowhere named.
Yes, Lord.
And why are you apprehending?
Lordship, for this FIR, Lordship.
Acha.
Annexer 20, page number 26.
What is your name? Bikash Datta.
Yes,
With
Lordship.
I'll read it myself. Wait. With due respect, I make to submit the state that I am a contractor of BSNL. We are engaged in the work of providing internet connections. Okay, those things were stolen, so
Lordship.
you are an employee of the department.
Yes, he is also a contractor and I am also contractor. Lordship.
Ah. Okay.
And I am doing now, Lordship, I am doing with BSNL for installation of BSNL equipment on network within an NRL complex, Lordship. He is also participated in that tender matter, but he fails to do this, and there is a rivalry.
So there was a tender
rivalry
floated.
between this informant and the petitioner, Lordship. So he may be influence the investigating.
He may influence. What is this? Whether there is any apprehension, Mr. Goswami?
I have not found anything, Lordship.
Okay, you have participated in the tender process. You were allotted work in the NRL complex.
NRL.
But then that will not suffice. That will not reach to a conclusion that he will pursue you. He will implicate you. He had simply stated that involvement of departmental personnel
Personnel.
because similar incident had occurred.
Yes.
You are not a department personnel. You are a contractor.
Yes, contractor.
Yes, contractors. He is also contractor, but we are.
Okay, he is also contractor. But then he
we are
said we
maintaining the-
suspect.
We are maintaining the Lordship, maintaining the BSNL network telecom.
But contractors will not be said as departmental personnel. Departmental personnel who are employees of the
The
BSNL.
FIR only, Lordship, para 6 of the petition, Lordship.
Huh.
The petitioner begs to state that in the series of FIR lodged by different officers of BSNL, Bokakhat, neither the name of any accused person nor that of any suspect has been mentioned.
Hmm.
However, in the complaint lodged by Sri Dilip Tamboli, one of the vendors engaged by BSNL as a telecom infrastructure provider, he expressed suspicion against certain persons engaged in BSNL network. What is mean?
Suspected some persons. There is no apprehension.
No
Mr.
apprehension
Counsel.
on this in his part, Lordship.
Lordship,
What is the purpose of wasting the court's time pre-arrest bail?
some protection may be given, and then I will appear before the IO, Lordship.
You don't have to appear. You are not called. You are not an accused.
I am called, Lordship.
You are called. Where is that? That notice under what section is?
Lordship, as per the instruction of the.
No. You file fresh application when some apprehension comes. I'll close this application. Heard Mr. DJ Boro, learned counsel for the petitioner, and Mr. DP Goswami, learned APP for the state. By this application, the petitioner has prayed for pre-arrest bail. You will withdraw or I'll close it. Huh?
I will, Lordship.
You withdraw and you come when proper. If police is in search of you, if police is searching you,
I am maintaining the BSNL network, Lordship. That is why, Lordship.
it's okay. You keep doing your work. If police search, goes to your place in search of you, if any notice is given, then
Yes.
come.
He has no stating.
Learned counsel for the petitioner submits that he has instructions to withdraw the matter. As such, the petition is closed as withdrawn. Huh? Over there. Assam. Yes. Yes, Mr. Hawk. AB,
Page 8 is the affair.
page 8.
My
Wait.
name not in the affair, Lordships, but police searching me, Lordships.
Oh, we have the honor to inform you that on last 8/3 at about 8 p.m., 9 numbers are unopened, the door of my house in 19. So this is theft.
Theft.
310 is what?
It was quite a lot.
Dacoity.
My prayer is that I may not appear before the IO, Lordship.
Police is searching you. Where is the pleading? Heard Mr. M. Hawk, learned counsel for the petitioner, and Mr. DP Goswami, learned APP for the state. By this application, the petitioner has prayed for a pre-arrest bail in connection with Dhula PS case number 37 of 2026, registered under section 310 within bracket 2 of the BNS Act 2023. The FIR in relation to which the petitioner apprehends arrest was lodged on 9/3/2026, wherein it was alleged that some unknown miscreants opened the door of the house of the informant and by entering, showed dagger to his wife and forcibly took the keys of the Godrej and looted various articles therefrom. The police, on receipt of the FIR, registered the same, and during their investigation, and started the investigation. Full stop. The learned counsel for the petitioner submits that the police came to his place, in search of him, in search of the petitioner. And as such, the petitioner apprehends that he will be arrested in connection with the said case. The petitioner has pleaded the said fact at paragraph number
Page 8, Lordship.
huh?
Page 8, Lordship.
28?
8.
8. Has what 8? 8 is a prayer. Where is the pleading where you have stated that police is searching you?
Page 3, Lordships.
The said fact has been, what did I say? In paragraph 4 of the said petition.
Lordship.
Mr. D.P. Goswami, learned counsel for the state, however, submits.
Another case also is being pending before against him, Lordship.
Submits that same of looting.
No, not same, another case, Lordship.
Submits that there is another case wherein the petitioner is arraigned as an accused and the same is pending investigation by the police. Upon consideration of the submissions made by the parties, more so in view of the fact that that there is nothing on record to show the complicity of the petitioner in the offense at hand, this court finds it fit to what interim or
Interim, Lordship, CD may be called for, after president of CD, Lordship will decide.
I mean, these are unknown miscreants.
But
My name not.
because,
He will appear. He will appear.
yes, he will.
Okay, so what did I say? Finds it fit to enlarge the petitioner on pre-arrest bail, on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount, to the satisfaction of the arresting authority under the following conditions. One, the petitioner should appear before the investigating officer within a period of 7 days from the date of receipt of this order without fail. Petitioner will not influence the witnesses connected to the case. Petitioner will not tamper with the evidence available in the instant case. Petitioner will not leave the place of his place of his residence without the permission of the investigating officer.
Cesium, my kind.
Uh-huh.
Cesium.
Investigating officer AB.
Oh, yes, Lord.
Okay, petition is disposed of.
This
You
was
appear.
call for a case, Lordship.
No,
It's a case of Dakaiti, Lordship.
Yes, so he will appear if he does not, without fail. And add one another condition, if he does not appear before the investigating officer within the said prescribed time, the CJM, which place? No, if he does not appear, his bail order will be amenable for rejection. Petition is disposed of.
Item number 21, Your Lordship, I'm requesting that after Your Lordship come may be taken. The urgency in the matter is that Your Lordship, that it's an FIR against a student and semester is going to start from the month of August. It's the quashing of the FIR matter and today it's listed for passing.
Okay, I'll take it up at 2.
Your Lordship, the same matter is going to be listed in court number 7 against the institutional proceedings. So my request is that it may be taken now, Your Lordship.
This is a bail application. Oh, no.
Quashing of FIR.
Quashing of FIR.
Against this
And what is the matter pending before court 7?
Before court 7, institutional proceedings where he has suspended. So we have challenged that order before the writ court.
Okay, I'll take it up.
Obliged, Lord.
After I come back.
They then started abusing his father, mother, and everyone. That is what has been written.
And
His
that is
fathers
what
were
our
been written.
submission, Your Lordship, that it was the heat of the argument, no intention of ragging. It is because of the hostile voting that took place. Your
Let him
Lordship.
take this plea of, my lord, heat of the moment before the trial court, and trial court probably in the.
Whether it is at all a case of ragging
It is
or
a case
it
of
is
ragging.
an
my lord.
election.
There is no
Absolutely ragging.
intention. There is
To
no
disclose
intention.
Private information, Lordship.
It is
You
the
express
absolute
the
case of
rights
ragging, my lord.
To disclose the
No,
information.
you said that there was some election and then he was
That's
asked.
not-
So,
Nothing is disclosed in the
my lord,
FIR
in
also.
the election, he was, after that, he was been called. They started ragging him, they started asking him questions and ragged him totally.
No, what is the definition of ragging? Show me that act.
That act, my lord, is,
Assam Ragging Act or what?
I don't think of my lord.
Lordship, the
Some.
act is not there, but so far as section 4 is
Section-
concerned, Lordship, whoever commits
No.
participates in, abates or propagates ragging in any educational institution shall be
So ragging has to be defined.
is
Yes,
punished
Lordship.
with
Ragging
imprisonment.
is a.
I mean,
Ragging is
what is that act? Name of the act? Assam
Assam, Lordship,
Assam Anti-Ragging Act.
Anti-Ragging Act.
some prohibition of anti.
It is not his submission also, my lord, that he has not ragged him. Let me put it in this way, my
No,
lord.
may
He
not
is
be a
not-
submission. It's my duty to see.
My lord.
Ragging Act,
Then it's
which year?
1999.
1998.
My lord, may see the page number 30, my lord. It will, how this matter has proceeded.
Punishment is up to, which may extend to 6
6
months.
months.
Hmm.
Or fine of rupees 10,000, which may extend to.
And
10,000.
it's actually, my lord, he is also there, no? By the UGC regulation to us, UGC regulation 2009. Let me see the UGC regulation 2009.
Ragging means either display of noisy or disorderly conduct or doing any act which causes or likely to cause social, physical, psychological harm or raise apprehension of fear or shame in any education and includes teasing, abusing, playing practical jokes, asking the student to do any act or perform something and any cause any to do. Okay. So it will come within the definition of
Yes.
ragging.
And moreover, Lordship, the authority of the IIT, they have received a complaint from the student,
Huh.
from the victim himself.
Yes.
Then only the FIR has been lost.
Yes, that I have seen. Yes.
Lord, otherwise the ragging definition has been there, my lord, in the UGC.
Ragging is defined under
defined
this
by-
act. Assam
oh,
Prohibition of
yes,
Ragging
yes.
Act. So it is defined as ragging means either display or noisy. So he has displayed noisy or disorderly conduct or doing any act
Your Lordship.
which causes or likely to cause social, physical, psychological harm or raise apprehension of fear or shame or embarrassment to any student in any educational institution.
That has happened, my lord.
So these,
Your
the
Lordship.
definition will
It's clear.
My
include
voice
the.
may have been
Father.
raised, but there was no intention to rag him. The intention, it was a heat of the argument, Your Lordship, because of the election. That's
No,
what
I'm not,
submitted.
I'm not on the merit of the case. It is there, but then only to
Will be very
save his
difficult.
career.
Yeah.
And what are the other punishment given by the IIT?
That 5 penalties have been imposed upon me. That
5, this is
5
the one.
penalties. I've been expelled from the hostel. I've been asked to not to appear in any of the cultural activities. 5 penalties are there, Your Lordship. Our only request is that, Your Lordship, that criminal proceedings may harm our career. It will definitely affect our placement and our future, Your Lordship. Moreover, attending this trial will be very difficult for me, Your Lordship, to come from the different state.
Okay, Mr. Counsel, he has been punished enough. No longer for the FIR to stay.
My lord,
Because
my lord,
he is,
I'll put in this way, my lord. Let me put in.
I understand, I
I'll
was
put
not
it this way,
willing,
my
but then,
My lord,
see,
he's been only suspended academically, my lord.
no, there are
But-
others,
My lord,
there are other.
this is only, my lord, with regard to that, my lord.
Yes.
My lord, will see this, my lord, that in this case, my lord, most importantly, the victim has not been made party. Let me start from there. If the notices would have been given to the victim, the matter would have come out, what languages have been used, what kind of things has been stated to the victim.
No, I'm
My
considering
lord,
the
my
punishment,
lord,
see.
this is punishment he has not accepted this punishment, my lord. Because
He
this punishment
has
is, he has challenged this punishment before the Gauhati High Court, my lord.
Huh.
This,
the question is not only you either reprobate or probate. You cannot go both ways. If the submission is this, that I accept the criminal proceedings, let the criminal proceeding be dropped, and I will accept the civil consequences, then Your Honor may look into this, my lord. But at this point of time, my lord, this is because there is Supreme Court direction is there, my lord. Let me put it out this way. Supreme Court direction is there and UGC regulation is there, which says that criminal FIR has to be lodged, my lord. I will cite that judgment also, my lord, if the my lord permits me some time, because this argument he is started. I was also not intimated, probably otherwise I would have cited those judgments. Supreme Court has stated that FIR has to be lodged in this kind of cases when the ragging has been there. Apart from that, UGC mandates, my lord, for FIR to be lodged. And if the FIR does not, here, there is no prima facie material has been brought into record. Only the question is arguing, my lord, I am in MP, I will be facing trial. The accused is not required to travel to the court regularly. The advocates are there. They will represent him. So, my lord, this all humanitarian consideration, my lord, can be brought to before the trial court. The trial court date is there, my lord. Let him face the trial. Let him convince the trial court that the charges may be dropped against him. Because this will set a very wrong precedent before by this honorable court, my lord. Because this sort of things, my lord, if this honorable court entertains such kind of a plea, my lord, because there is a discomfort on the part of the accused to attend the trial, his age is less. This will, my lord, the entire educational system of, my lord, then IIT's procedure also will be severely affected, my lord. Let me complete, my lord. I have not interrupted him. My lord, at this stage, my lord, I will say, my lord, will not consider at all for quashing the FIR, my lord. Victim has not been made party. He has not supplied the material. What were the foundings? What were there before the ARC? These are all punishment he has challenged before the writ court. Here he is saying that I am ready to take the civil consequences.
Under adjudication.
That is under adjudication, my lord. Maybe writ court will.
As far as the marriage is concerned, okay. There is. It cannot be quashed by following Bhajan Lal's case. But what I am on is he is 21 years and then he will have his
My lord,
entire
I'll put
future.
it this way, my lord. I'll put it in this way.
Only humanitarian grounds.
Let the charge sheet be filed, my lord, because whether charge sheets are there, the police will see whether the material which are there at the stage of very initial stage, my lord, of the FIR. Only at 21 years age, my lord, age cannot be a ground for quashing FIRs, my lord.
Okay, enough. Heard, Mr. What is your name?
Arpit Lal here, Dr. Arpit Lal.
Dr. A. Lal.
Yes.
A. Lal for the petitioner and Ms. S.H. Bora, learned APP for the state, and Mr.
A.B. De, my lord.
A.B. De, learned counsel appearing for respondent number 5. By this application, the petitioner has, by this application filed under section 528 of the BNSS 2023, the petitioner has prayed for quashing of the first information report. And quashing of first bearing FIR number 1003, FIR number 0036 of 2026 and 27, full stop. The petitioner has also prayed for quashing of the subsequent proceedings. No proceedings. What?
Nothing has been done, my lord. FIR is only registered, my lord.
FIR. For quashing of the FIR, for quashing of the FIR lodged on 19/4/2026.
My lord, on 22/4/2026, my lord.
19/4, I see by the dean.
That was the complaint made.
That was the complaint. Okay. I think that is the FIR. This is the contents of the FIR. FIR dated 19/4/2026.
19/4, my lord.
Registered under sections 127(2), 296, 3 subsection 5, 351 subsection 2 of the BNSS 2023, as well as under section 4 of the Assam Prohibition of Ragging Act 1998. The first information report, which is prayed for quashing, was lodged on 19/4/2026, wherein it was stated by the informant, that is the professor of Indian Institute of Technology, Gauhati, that on the basis of a written complaint. No, no, কি করলো?
Yes, my lord, written complaint, written complaint.
No, that will, huh?
When it was taken by.
That on that that the petitioner had called one junior student who was studying in the first year to the room of a petitioner and others. Petitioner and others had called one junior student who was studying in first year to a room number D-310 at around 2 a.m. on 26/3/2026. And when the said junior student reached the room, petitioner began shouting loudly to the said victim for 2-3 minutes using abusive language. Full stop. It was also alleged that the victim was reportedly kept on, that the victim was made to stand with his head down throughout the entire period, and that the companion of the petitioner had harassed the victim in various ways. Full stop. The informant had given the information to the officer in charge of the North Gauhati police station on the this information will go on the basis of the complaint received from the said victim. Full stop. The informant further stated that the incident was referred to the anti-ragging committee for examination and that the committee had conducted the detailed inquiry on 13/4/2026 and upon upon conclusion of the said inquiry, it was reported that ragging had taken place in violation of the UGC guidelines. Full stop. It is this FIR which was sought to is sought to be quashed by the petitioner. The learned counsel for the petitioner submits that the ingredients of the charged offenses are not available in the instant case. Full stop. He submits that the petitioner was not restrained. What do you say? Remained under, was not restrained.
Yes, Lordship.
That the victim was not restrained by the petitioner and others, and that the room was not locked after he came inside. And also that. What is 296?
Uttering obscene words.
Huh?
Uttering obscene words.
Oh, yes.
Obscene words.
He also submits that the ingredients of other offenses, that is section 296, section 35, as well as section 351(2), are not attracted in the case. He also submits that section 4 of the Assam Prohibition of Ragging Act also is not attracted. He further submits that the petitioner is of 21 years of age and he is studying in the 3rd year of the IIT, and that a parallel proceeding was also instituted against him by the Institute of what? IIT? Institute of Science and Technology. What?
Indian Institute of
Indian Institute of Technology. Full stop. He also submits that punishment has been imposed by the competent authority in the IIT upon the petitioner. He as such submits that the equity be. No, he submits that the petitioner that the present FIR be quashed qua the petitioner in view of the equity, on the ground of equity. On the other hand, Ms. Asaj Bora, learned APP, submits that the offenses registered by the police are well attracted in the instant case, inasmuch as the victim was called to a particular room and he was abused therein and was also made to face trauma by the victim concerned. As such, he submits that the instant FIR is not amenable to quashing. Mr. A.B. Day, learned counsel for respondent number 5, that is the informant, has also submitted that based on the complaint of the victim, the FIR was instituted by said respondent number 5. An inquiry was conducted, and in the said inquiry, it was found that ragging in fact had taken place on the said day upon the victim by the petitioner and others. I have heard the counsel and have gone through the records. It is no res integra that for quashing of an FIR, the main ground that has to be seen is as to whether a cognizable offense is made out in the said of a FIR and the connected documents. It is held by the Honorable Apex Court that if a cognizable offense is made out, no quashing can be ordered by the High Court under its inherent power. The Supreme Court in Bhajan Lal's case, it will be I will give you the para. Bhajan Lal's case, reported in Bhajan Lal versus State of Haryana, reported in 1990 something, so and so versus reported in so and so, it was held as under. I'll give you the paragraph. As such, it is seen. What is the citation? Do you know, Bhajan Lal?
Citation is itu দিলে এই কোড করলে 1992 supplementary 1
One second.
335.
Let me switch it on.
also Niharika infrastructure
Niharika infrastructure is
is also there.
adjustment is also.
Niharika infrastructure is on interim order or
On the
the
quashing.
coercive action.
Question.
On the quashing also.
Quashing also. Okay, Bhajan Lal is.
Original is a landmark that.
Is it basic?
Yes.
Pretty much.
And what,
1992.
Two?
Supplementary 1, SCC 335.
335.
Yes.
Reported in Palato.
11 of
The State of Haryana versus Bhajan Lal. It's the
State of
other way.
Haryana button.
Reported in 1992, supplementary 1 SCC. 1990 supplementary 1 SCC. Where is that? Where is that? Supplementary 335. The Apex Court had held as under. No, DA do you know? Where is that? Cognizable case, which is the paragraph?
I think my lord, 1 minute.
গরম উঠিছে ফেনকো এই ফেনখন অকণ অন কৰি দিয়া না held that, okay, where the allegation is faced by, okay, I'm giving you this, Okay, no. Okay. Share. Okay. What is held as under Prohibitions? It is as such seen that the apex court has held that when the allegations made in the first information report or the complaint is taken at their face value and is accepted in their entirety, makes out a prima facie case constituting any offense, the said FIR cannot be quashed. Full stop. In the instant case, it is stated in clear terms in the said FIR that the petitioner and others had called the victim to the room being room number D-310 at around 2 a.m. on 26/3/2026. Full stop. It is further stated that as per evidence given by the victim, it was the petitioner who had shouted loudly at the victim for 2-3 minutes using abusive language. Full stop. It is the term ragging has been defined under the Assam Prohibition of Ragging Act 1988 as hereunder. Etu di diba, Etu heri nohoy. You'll have to write it from here. Okay. My team etu. Etu tamane etu nohoy. This has been simply put in the internet. Okay, has been defined under the said act as follows. Likhelwa. C, small c within bracket, ragging within inverted comma, means either display of noisy or disorderly conduct or doing of any act which causes or likely to cause social, physical, and psychological harm or raise apprehension of fear or shame or embarrassment to any student in any educational institution and includes Diba 1, Roman 1, teasing, abusing of, comma, playing practical jokes on, or causing hurt to such student. Or Roman 2, asking the teacher to do any act, asking the student to do any act or perform something which such student will not in the ordinary course willingly do. Full stop. In close inverted comma. By a bare perusal of the said definition, it is seen that shouting at a student by using abusive language is comes within the definition thereof. In the instant case, it is stated that the petitioner had shouted loudly on the victim by using abusive language.
Your Lordship, one line to be added that there was no intention to commit. It was a heat of the argument because of the election.
No, intention is writ large. You had called that boy. Yes. Intention means common intention in 3-5.
Yes, Your Lordship.
So common intention will be
3-5 is
seen.
not there in the FIR, Lordship.
No, it's there. 3-5 is there. Common intention. You have not prepared the case properly. 3.5. Common intention will be seen from the conduct. And your conduct shows there was common intention between 5 persons. You try, you come again by after you're not discharged in the framing of charge. We will
Then it is
consider.
better way.
But you should go through something.
My one request is-
No, I'm dictating my order. No more disturbance.
Penalties have already been imposed upon me and my placement is right in front of me, Your Honor.
Ajay, you have challenged that, you see, before the
Only
court.
penalty number 1 I have challenged, that is
My lord,
suspension
this
of
is,
that.
my lord,
Okay.
this is uncalled for, my lord, at this point of time. my lord.
I am doing what the Supreme Court has said. No, I mean, okay. Then? As such, Section 4 of the Assam Prohibition of Ragging Act 1998 is well attracted in the said case. It is full stop. It is also seen that the ingredients of Section 127 sometimes such students commit suicide. This should not be done. And if I again quash it, others will get
No,
the
Your Lordship,
benefit.
because of the FIR and this suspension, I am also facing suicidal tendencies and I've been getting.
And it should be you are teaching a lesson to others. You are doing good to the society. And now 127, right? 2 of Section 127(2) of BNS is also attracted in the instant case, inasmuch as the victim was called to the particular room and he was confined inside the same by the petitioner and others who are much senior to the victim. Further, the ingredients of Section 296 296, which provides for using obscene acts and songs, and which also includes uttering obscene words, is also attracted in the instant case in view of the fact that the petitioner had
Your Lordship,
the
Act says that-
petitioner shouted loudly by using obscene words. Similar is the case of offense under Section 351 2 of the BNSS,
Intimidation.
which provides that whoever threatens another by any means will be charged with criminal intimidation is also well attracted in the instant case. So as provision under Section 3.5 of BNS. Full stop. Section 3.5 of the BNS provides for common intention, and the said common intention has to be gathered from the conduct of the parties. In the full stop. In the instant case, calling the victim to a particular room by the petitioner and others shows the common intention.
At 2 a.m. in the night.
At 2 a.m. shows the common intention shared by petitioner and others. In view of the said findings, this court does not deem it fit to quash the instant FIR under its inherent power, and as such, the petition is dismissed. The council should be careful. They should be careful. You should have moved the other matter there and move it here. You were in such a hurry to move this matter here. If you would have got some order there, maybe I would have changed my order. It was your prayer.
It was the
As of now, I cannot do anything. Okay, next matter. Yes, item number 11. This matter took long. Okay. AB.
AB, my lord.
Huh.
I am not naming the FIR. FIR is page 8, my lord.
Itu sake time lagibo অকমান মাৰোতে Itu sake অকমান time lagibo মাৰোতে এইটো লৈ লো আপোনাকে Yes. FIR is at page
8, my lord.
8. I'll just go to the FIR fast. Wait. What is your name? Sahanur.
Okay.
Respect and humble submission. $23 on an e-rickshaw.
Wrongly.
Oh.
3%.
So I was just saying,
E-rickshaw.
the translation is not proper. But even if I'm an Assamese person, reading Assamese is difficult for me and understanding also. I noticed that 3 persons already on board.
It's also in English.
Oh, it is originally in English?
Oh, she says
Oh.
starting.
It's a handkerchief. What did you write? Handkerchief. I mean, what did the informant write? Handkerchief. So, see, he was made senseless and his card was used for making, and the money loss was 1 lakh. Even if you are arrested, even if you are apprehending arrest on suspicion, no bail.
But on the
Why are you apprehending?
But on the basis of CCTV footage, my lord, the main person has been arrested.
Huh. Then you will also be arrested
No.
soon.
I am no way connected.
Why are you saying that?
Sir, my ATM was used, my lord.
Huh?
By the main accused. That's why my lord,
ATM of the victim was used.
no, ATM of the petitioner was used, my lord, for withdrawing money.
Why his ATM is used?
Why have you given your
It was
ATM
taken by the main accused, my lord.
from you?
Lordship.
Money was taken from you.
No, he has his ATM is used by the main accused. He has,
So,
he has delivered his ATM to use his ATM.
So, how will he use your ATM? He had taken your money.
Lordship.
No, I don't understand. What is your story?
My lord,
ATM is used only to draw money,
Yes.
not to deposit.
no, no.
Now, if his ATM is used, the main person will draw the money from his account. What about drawing of money from the account of the victim?
Victim.
Victim money was taken out
1 lakh
and to an amount of 1,69,000. No, but why are you apprehending?
Apprehending, my lord, the police is searching my house, my lord. And in connection with this case, because, my lord, as per, my lord, information, my lord, the account ATM card of the petitioner, my lord, used in this
He
transaction.
may
my
be the one of the associates.
ATM card of an associate is not required to draw money. I will use my own ATM to get my money.
Some money was, my
Some
lord,
money is my bank
deposited in my account.
Yeah, that money is.
That money was deposited in your
In
account.
Lordship.
Money was deposited.
Lordship.
That is an admitted fact. That is why police were
That-
searching you.
Yes, ma'am.
Yes.
And there, by using my account, my lord,
Okay, let the CD come. No way. Heard Mr. R. Ali, learned counsel for the petitioner, and Mr. D.P. Goswami, learned APP for the state. The petitioner has prayed for pre-arrest bail in connection with Hatigaon PS case number 211 of 2025 under section 61(2), 318(4), 3032, 3082, 307, and 138 of BNS. Call for the case diary. List this matter on 11th of August, right?
Yes.
Lord.
11th of August. Yes.
This is
12 is any.
No,
12 is same.
no, man. This is different.
Okay. AB,
FIR page 10, madam.
page 10.
Page 10.
Abajan Ali. Where are you? You are not there in the FIR?
No.
Acha, allegation is against the second driver or first driver?
Second driver was arrested and subsequently released on bail out.
Only thing is that the other persons involved in the incident are Ikram Hussain, Afzal Ali, Farhad and Saifuddin.
His name is not there.
Abazan Ali.
Abazan Ali, how did you, why are you apprehending?
No.
Why are you apprehending
The
arrest?
police is searching my house, my lord, without issuing any notice also, my lord. All the offences are, my lord, below 7 years conviction.
Okay, they will give you notice. Why are you in a hurry?
I will appear, so my lord, I may be protected. I'll cooperate with the investigation.
How many people were arrested?
Only driver.
Three. Who are these? Bipin Deka, Ikram Hussain and Samsuddin.
Forwarding report page 20, man.
Bipin Deka? Bipin Deka is the driver.
Bipin Deka was driver.
Okay. Heard Mr. R. Ali, learned counsel for the petitioner, and Mr. D.P. Goswami, learned APP for the state. By this application, the petitioner has prayed The petitioner has prayed for bail in connection, pre-arrest bail, in connection with Ajara PS case number 88 of 2026, registered under section 305 small b, 305 small c, 318(4), 316(2), and 35 of BNS 2023. The FIR in connection with which the petitioner is apprehending arrest was lodged by the owner of the truck.
No, he's the transporter.
Lodged by a transporter on
FIR
no date on 8/7/2026 or 6/7. 8/7/2026, stating inter alia that he was working at the Pepsi company, and that on 31/5/2026 at around 10:50. At night on 31/5/2026, he loaded 1,050 numbers of cartons of Pepsi to be delivered to Sintha Services, SINTHA, delivered to Sintha Services, Manipur, in a truck. Full stop. He further stated that the said truck, due to technical fault, halted near Rani Railway Regiment for 8 days, and that subsequently another driver plying another truck contacted him and expressed his desire to carry the said goods to Manipur. Full stop. However, the informant was informed by the Sintha Services, Manipur, that the items had not reached, and as such, he lodged the ejahar for the loss thereof. The police, on receipt of the ejahar, investigated into the case and arrested 3 persons. Full stop. However, the learned counsel for the petitioner submits that the police is searching, police has reached the house of the petitioner in search of him, and that he is apprehending arrest, although he is not involved in any manner with the said offense. Mr. D.P. Goswami, learned APP for the state, submits that the police during investigation has unearthed the names of the accused person, and as such, during investigation, the police had visited the house of the petitioner. Full stop. On consideration of the submissions made by the learned counsels for the petitioners as well as the state, this court, state more so, in view of the fact that the informant had named both the drivers as well as 4 other persons to be involved in the incident, but the name of the petitioner was not stated by the informant, and on this ground and for the same, this court finds it fit to enlarge the petitioner on pre-arrest bail on furnishing of a bail bond of rupees 20,000 with 1 local surety to the satisfaction of the arresting authority under the following condition. There is a charge sheet not submitted, right? Appear before the IO within 7 days from the date of receipt of the order. Okay. Disposed of. Okay, because his name was not there and all, and rest of the matters at 2. Okay, 10. Okay. Heard Mr. P. Sharma, learned counsel for the petitioner, and Ms. R.D. Kakoti, learned counsel appearing for the sole respondent. Mr. Sharma submits that the matter be sent for mediation, and the said submission and the said prayer is also accepted by the learned counsel appearing for the sole respondent. As such, the present case is sent to the Gauhati High Court Mediation Center, who is directed to appoint a mediator. Full stop. The mediator will appoint a mediator who will hear the same, and on conclusion of the said proceeding, the mediator shall file a report, and the same be sent to this court. List this matter after the report is submitted by the mediator.
Oh, blind object.
Huh? 25. Yes, yes. Huh. Case diary is there.
Lordship, case diary was not called for, or perhaps TCR called for.
Or TCR is there.
It's there.
Have you checked?
Yes,
Okay.
I have flag marked the relevant pages, Lordship.
Okay. Take care. What is the case about?
But the allegation of murder is there.
Huh.
But I am not on the merit of the case. My only concern is, Milord, I was arrested on 11/5/2025. As on date, it is 445 days behind the bar. And in the trial proceeding, Milord, already 4 witnesses have been examined. So, Milord, only on that count,
The delay, I mean the prolonged
exactly.
incarceration, all those.
Incarceration.
Acha, those witnesses have said anything against the present petitioner? Have you checked their statements?
Check the LCR, Lordship. Out of 16 witnesses, listed witnesses, 4 has been examined, Lordship.
Only the thing is that the copy of deposition of the prosecution witnesses, that is not found there. Lordship.
That is not there.
That is not there. That may be called for, Lordship.
Sir, what is the offense?
Offense of the 30103, Lordship. Murder.
Only murder.
Yes.
Okay, FIR is page 12.
FIR, two FIRs are there.
Lordship,
The first, your lordship will find at page 12.
Mm.
This is the FIR, it is lodged by the mother of the victim. Victim is a
Acha.
10 years old boy.
10-year-old boy.
10 years.
yes, Lordship.
The mother says the boy was missing from his tuition classes. And ultimately, another FIR was lodged.
When his body was found.
Yes.
Yes, Lordship.
After the body was found.
Where is that FIR?
At page 17. There's an FIR, annexure to FIR dated 11/5/2025. The father of the boy logged this FIR.
Who is this? Jitumoni Haloi?
Present
This is-
petitioner,
this is
Lordship.
the
Acha, ha. That means she is the paramour of the wife of the wife of the informant.
Yes, Lordship.
Wife of, not informant. Informant is the mother.
There are two
Early-
FIRs, Lordship.
Second FIR is filed by the
By the
divorced
father.
husband.
Father of the
Father of the boy.
Father.
boy, yes, Lordship.
Mother will not instigate. Mother will
Lordship,
not
the
abate
story is
the.
very, very pathetic. Lordship, kindly see the judicial confession statement of the accused, Lordship.
Oh, he has
Yes,
confessed.
confessed, Lordship, before the magistrate, Lordship. I have flagged mark.
He has retracted. Oh, that stage has not come.
Not come, Lordship, because the copies of deposition of the witnesses are not received, Lordship. Lordship, kindly see the scene of circumstances, Lordship.
Acha, give me the, yes.
Confession statement of the
Hare Krishna.
petitioner, Lordship. Dada,
Hare Krishna. File to do. He will, of course, retract perhaps, but then let me see his confession.
yes, Lordship. Kindly go through it.
Have you marked? Yes.
Yes, Lordship, I have marked.
What does the PM report say?
The viscera, that is, the cause of death is, that is awaited because of the viscera.
Oh,
Otherwise-
no strangulation and all.
Otherwise, strangulation on the neck, that is there, Lordship. Injury
Acha.
marks there on neck and skull.
But strangulation, was it mentioned by the doctor?
Lordship, because the deposition part is yet to come, Lordship.
No, in the PM report?
Postmortem report, only the abrasions are found in the neck. Lordship.
Abrasions are there.
Yes, that is true.
FSL what? No poison.
No poison, Lordship. It's a clear-cut planned murder, Lordship.
183. Where is that? You have not, progress report.
Progress report, Lordship.
Where is that? A
May I,
statement?
Lordship, the magistrate, that will be statement.
I
May I
just-
see, Lordship?
Will it be in this bunch or the, I
Yes.
don't know.
Dada, do you know?
Huh?
I'll show you, Lordship.
उनको दो तो ओह क्या बोल records ओ ये ले
तो
रहा
पहले दे दी वो more silent.
नहीं He's paying bail only on the ground of prolonged incarceration and
Because Lordship, investigation is going on, Lordship, trial is going on. Out of 16 listed witnesses, 4 has been examined. But only the thing is a copy of deposition is not there. That may be called for, Lordship.
whose deposition?
The prosecution witnesses deposition also.
Acha, those depositions.
Yes, Lordship. The long one, Lordship.
It's in Assamese.
Yes, Lordship.
Okay, I'll read it fast. Give me.
Yes. It starts from the pink flash.
Okay.
And the relevant pages.
What happened to the mother of the victim?
She's also arrested.
She's also an accused. Charges are framed. Trial is also against her.
Yes,
Yes, Lordship.
same charge.
Not readable also.
It's there, Lordship.
Which part can you point out?
Yes, Lordship. May I read, Lordship? Otherwise. Oh, Lordship, may I read
Okay,
that part, Lordship. You just turn
Second
it.
page.
Yes, turn it down.
Third page.
Yes, the front, yes. The last paragraph, the second paragraph, Lordship. The relevant portion.
Who's Dipali? Dipali is the
Dipali,
wife.
mother of the deceased.
He said that মই দীপালি আৰু তাইৰ পুত্ৰক হত্যা কৰিবলৈ আমাৰ আলোচনাৰ বিষয়ে ভাবি আছিলো. So he wanted to kill even the mother.
No, no, no. Dipali and the present petitioner, Lordship.
No,
Dipali happens to be the mother of the deceased, Lordship.
Huh?
They are planning to kill their child, Lordship.
No, he said he went to somebody else's place, right?
Yes, yes.
কিছু সময় অতিবাহিত কৰি আৰু তেওঁৰ ঘৰত চাহ খাইছিলো.
Yes.
দুপৰীয়া ইমানমান বজাত মই তেওঁৰ ঘৰৰ পৰা ওলাই গৈছিলো.
হয়.
যেতিয়া মই তেওঁৰ ঘৰৰ পৰা ওলাই গৈছিলো, মই দীপালি আৰু তাইৰ পুত্ৰক হত্যা কৰিবলৈ আমাৰ আলোচনাৰ বিষয়ে ভাবি আছিলো.
Yes.
He wanted to kill even the mother.
No.
No. His paramour.
No, no. Only the son.
But then why this statement?
Lordship, again, please.
আশিস কুমাৰ গুপ্তাৰ ঘৰৰ পৰা ওলাই যোৱাৰ পিছত মই মোৰ এজন ক্ষেত্ৰ বিষয়া ফোন কৰিছিলো আৰু সেই ঠাইত বাস কৰে তেওঁ কৈছিলো যে মই তেওঁৰ ঘৰৰ ওচৰত থকাৰ বাবে so many statements.
Yes, it's a long one.
Irrelevant. Acha,
May I read, Lordship?
please give it to her. You read this portion that I have marked in
Yes,
marked by pencil. So even if there is delay, you have been inside for long, but your confession will of course be seen,
Yes.
whether it is reliable or not.
It
Just
always
think, where is that portion that he had killed?
Yes. মই তেওঁৰ ঘৰৰ পৰা ওলাই গৈছিলো যেতিয়া মই তেওঁৰ ঘৰৰ পৰা ওলাই গৈছিলো মই দীপালি আৰু তাইৰ পুত্ৰক হত্যা কৰিবলৈ আমাৰ বিষয়ে ভাবি আছো. It's a wrongly translated.
Acha.
He and Dipali, they have planned to.
This is what you have said, but then
Yes.
the statement shows
Yes.
different. Okay, heard Mr. M. Chaudhary. You take out and let me know.
So
I'm
quick
Chaudhary,
case of-
learned counsel for the petitioner, as well as Ms. S.H. Bora, learned APP for the state. Yes,
May I read the relevant portion?
only 1-2 lines.
Yes, Lordship. মই দুপৰীয়া আহাৰ গ্ৰহণ কৰাৰ পিছত মই দীপালীক ফোন কৰিছিলো আৰু তাইক সুধিছিলো বাবু ক'ত আছে আৰু তাই মোক কৈছিল যে বাবু টিউচনলৈ গৈছিল। তাৰপিছত মই মোৰ মোবাইল ফোনত বেলতলা তিনিআলিত আছিল। দীপালীয়ে মোক ইতিমধ্যে মোৰ মোবাইলৰ ফোনত ঘৰত ৰাখিবলৈ কৈছিল যাতে কোনেও মোক সন্দেহ কৰিব নোৱাৰে বা মোক ট্ৰেক কৰিব নোৱাৰে। মই সন্ধিয়া প্ৰায় 6:30 to 7 বজাত মৃন্ময় টিউচনৰ চেণ্টাৰত উপস্থিত হৈছিলো। যেতিয়া মৃন্ময় মোক টিউচন চেণ্টাৰৰ বাহিৰত দেখিছিল তেতিয়া তেওঁ মোৰ ফালে দৌৰি আহিছিল। তেতিয়া মই তেওঁক মোৰ বাইকত লৈ গৈছিলো আৰু তেওঁক সুধিছিলো তেওঁ কি খাব বিচাৰে। তেওঁ মোক কৈছে তেওঁ ষ্টিং খাব বিচাৰে, যে কোল্ড ড্ৰিংক। সেয়েহে ওচৰৰ AG বাছ ষ্টেণ্ডৰ ওচৰত ৰখাও। মই তেওঁক এটা ঠাণ্ডা পানী দিছিলো। তাৰপিছত মই তেওঁক ভেটাপাৰাত মোৰ ঘৰৰ বাহিৰত লৈ গৈছিলো আৰু তেওঁ মোৰ ঘৰৰ বাহিৰত অপেক্ষা কৰিছিল। তাৰপিছত মই মোৰ কোঠাৰ পৰা ট্ৰলি বেগ এটা লৈ বাহিৰলৈ গৈ মৃন্ময়ক ট্ৰলিখন ধৰিবলৈ ক'লো আৰু আমি মোৰ বাইকখনত লৈ বশিষ্ঠ টেম্পলৰ ফালে আহিলো। এবাৰ দীপালীয়ে মোক কৈছিল যে তেওঁৰ পুত্ৰক হত্যা কৰাৰ পিছত মৃতদেহটো এটা মোনাত ৰাখিব লাগে যাতে মৃতদেহটোৰ বিষয়ে কোনো সন্দেহ কৰিব নোৱাৰে। তাৰপিছত মই মৃন্ময়ৰ সৈতে নিশা প্ৰায় 8:30 মান বজাত বশিষ্ঠ মন্দিৰৰ ওচৰত এটা জংঘল এলেকাত উপস্থিত হৈছিলো। তাতে এটা ফৰেষ্ট অফিচ আছিল আৰু বাহিৰত প্ৰচণ্ড বৰষুণ আছিল। তেতিয়া মই মৃন্ময়ক বাইকৰ পৰা নামিবলৈ কৈছিলো। ময়ো বাইকৰ পৰা নামিছিলো আৰু তাৰপিছত মই এখন হাতেৰে মৃন্ময়ক পিছফালৰ পৰা ধৰি ৰাখিছিলো আৰু আনখন হাতেৰে মই তেওঁক মুখ আৰু নাক ধৰিছিলো যাতে তেওঁ উশাহ ল'ব নোৱাৰে। কেইমিনিটমানৰ পিছত তেওঁ জ্ঞান হেৰুৱাই মাটিত পৰি যায় আৰু উশাহৰ অভাৱত তেওঁ ঘটনাস্থলীতে মৃত্যুবৰণ কৰে। তেতিয়া মই তেওঁক ট্ৰলিৰ ভিতৰত পেক কৰিছিলো, কিন্তু তেওঁৰ ভৰিবোৰ ওলাই আছে আৰু মই বেগটোৰ জিপটো বন্ধ কৰিব নোৱাৰো। যিহেতু মই কঁপি আছিলো আৰু ভয় খাইছিলো, এই মৃতদেহটোৰ সৈতে ট্ৰলি বেগটো জংঘলত পেলাই দিছিলো। তাৰপিছত মই তেওঁৰ স্লিপাৰ্ছ আৰু স্কুল বেগটো জংঘলত পেলাই দিছিলো। That has been also recovered from the place of occurrence led by the accused person also, as per the season case.
But there are abrasions on his neck and all. That, of
Yes.
course, is not
That's it,
explained.
because he has been strangulated, Lordship.
Strangulation is one hand is on something, one hand
Yes,
is on
yes,
the
yes.
nose.
But
Because of
his materials also-
asphyxia, he died.
Yes, because he's a 10 years old boy, Lordship.
But asphyxia is not mentioned in the postmortem report, right?
Lordship. মই বাইকৰ পৰা নামিছিলো আৰু তাৰপিছত মই এখন হাতেৰে মৃন্ময়ক পিছফালৰ পৰা ধৰি ৰাখিছিলো আৰু আনখন হাতেৰে মই তেওঁৰ মুখ আৰু নাক ধৰিছিলো যাতে তেওঁ উশাহ ল'ব নোৱাৰে। কেইমিনিটমানৰ পিছত তেওঁ জ্ঞান হেৰুৱাই মাটিত পৰি যায়। He's a small boy of 10 years old. মৃত্যুবৰণ কৰে। আৰু পিছত মই স্লিপাৰ, তাৰপিছত মই মোৰ ঘৰৰ মোৰ পেণ্ট আৰু গেঞ্জি সলনি কৰিলো। তাৰপিছত মই দীপালীক ফোন কৰিলো, মই শুই আছো। তাৰপিছত মোক কৈছিল যে বাবু,
Let the trial go on, but then
yes, Lordship.
no, let the trial go on, but then
But Lordship,
if he is somehow acquitted, then his entire year, I mean, his
Lordship, kindly, my only prayer is this: let the deposition of the relevant witnesses come, Lordship. That may be called for. That is not found on the record.
no,
Whether they
yes,
have implicated or not.
that is to be considered by the trial court.
Lordship, let the deposition at this stage, Lordship, because it's a
Because-
heinous crime committed brutally.
Because-
A minor child is brutally murdered.
But who has killed him? That is the question.
He himself confessed, Lordship.
That you know,
But
confession
Lordship,
will not be only reliable,
Lordship,
cannot be relied only.
There are only supporting other witnesses, Lordship.
Hmm.
Because there's chain of circumstances, that is a complete chain of circumstances. By other witnesses also, before the occurrence, they have seen this persons, that he went to the petrol pump. So a lot of statements are there.
These things may be there, Miller, but
183 statement, Lordship, I'm also
Okay,
reading.
Kulunat. By this application, the petitioner has prayed for bail in connection with Sessions case number 185 of 2025, pending in the court of additional session judge number 2, Kamrup, Gauhati, corresponding to Dispur PS case number 414 of 2025, registered under section 143, 120B, small b, 1031, 238, small a and b, two beleg bracket, 61, 2, small a within bracket, and 35 of the BNS 2023. The learned counsel for the petitioner submits. Oh, no, it don't like. It is noticed in the instant case that the FIR has been lodged. That two numbers of FIRs are lodged in the instant case. It has been noticed in the present case that two numbers of FIRs are lodged. One, when the when the deceased had, when the deceased was missing after he went to his tuition classes. Full stop. the said FIR was lodged by the mother of the victim, stating that the victim was not traceable. And thereafter, when the body of the victim was recovered,
Ma'am, kindly go through this.
body of the victim was recovered, another FIR was lodged by the father of the victim, stating inter alia that his 10-year-old child went for tuition and that he did not return after that, and his body was found. Body was found, full stop. The informant further stated that his son was killed by the petitioner, being on the instigation of the mother of the child. Full stop. The police, after completion of the investigation, had submitted charge sheet against both the petitioner and the mother of the child. Full stop. On completion of necessary formalities, the trial started, and it has been stated that 4 numbers of witnesses were already examined. Full stop. Learned counsel for the petitioner submits that the petitioner was arrested on 11/5/2025, and till date he is inside the jail. And he further submits that there are a total number of 16 witnesses to be examined during the trial. And out of the said 16, only 4 has been examined, and another 12 witnesses are yet to be examined. And as such, he submits that the petitioner has been inside the jail for long and his bail prayer be accepted by this court. On the other hand, Ms. S.H. Bora, Learned Counsel for the state, submits that there are enough materials against the petitioner, being the perpetrator of the offense. Full stop. She submitted the confessional statement given by the petitioner under section 183 of the BNSS 2023, wherein he had stated in details as to how he had killed the deceased.
And 183 statement of another witness.
Of the?
Another witness, independent
Acha.
witness, not true. Kindly go through the statement. Just prior to the occurrence, he has seen the boy along with the petitioner lordship. The last scene theory lordship, that will come.
She works in the energy station, and she will know he or she will know the petitioner by his name.
Yes, lordship. It's not a fit case of granting bail at this stage, lordship. Not at all. I'm vehemently upset, lordship.
What was the day of occurrence? 10/5.
10/5, lordship.
They have not given the date in the FIR.
Lordship, I kindly come to page 21, you'll get the date of
11/5, the FIR was lodged, right?
Yes, that is by
10/5.
the father, next day. But on the first day, that is on 10/5, mother has filed a
7 p.m.
fire adoption before the police station. On 10/5 itself. actually.
She further relied on the statement recorded under section 183 BNSS of one of the witnesses, wherein the witness had stated that she had seen the deceased along with the petitioner on the night of 10/5/2025. Upon consideration of the submissions made by the learned counsels for the parties, these are all 183 such statement, but and it is for the trial court to decide. But he is more than 1 year in the.
No, see, that cannot be a ground because after 2 years also, lordship, there are a lot of judgments. Of the Supreme Court.
It is there,
It's
but
there, lordship.
uh,
1.5 years, lordship. There are a lot of judgments. Otherwise, all the prima facie materials are
it's
against.
okay, Gika, yeah, on the more so in view of the fact that the petitioner has been inside the jail for more than a year, and there are at least and there are 12 witnesses to be examined by the trial court. This court deems it fit to enlarge the petitioner on bail on furnishing of a bail bond of rupees 30,000 with one local surety of the like amount to the satisfaction of the session judge.
Kamrup Metro. Lordship.
Kamrup Metros on the following grounds, on the following conditions. Nikita Ditiba, the petitioner will have to appear before the trial court as and when called for. Petitioner will not leave the place of his residence without the permission of the session judge. Petitioner will not influence the witnesses. Last or Diba, if the petitioner is found, if the petitioner does not appear before the trial court, even on one single day, the said bail order is amenable to cancellation by the learned trial court.
Obliged.
Petition is disposed of.
I'm deeply obliged.
What's it? 20?
No, bless you.
9. Yes, 29.
The PRS
Case diary is there?
It was called for.
Not there. Okay.
Around interim.
Miss S.H. Bora, learned APP for the state, submits that the case diary has not been received and as such has prayed for another date for placing the same. Prayer is allowed. List this matter on
Lordship, 19th, Lordship.
19th of August 2026. Interim order passed earlier shall continue until the next returnable date.
Obliged.
Let's read the law.
30 and 31 together, why?
They're arising out of same affair.
Same FIR,
And
two different accused.
31 Lordship, the petitioner is on interim bail.
Acha.
30 Lordship, petitioner is not in-
Interim bail, statement recorded? Okay, I'll make it up.
30 Lordship, petitioner is not on interim.
Uh-huh,
In item number 30, if the petitioner is not on interim. bail,
not on interim. Okay,
The entire, if your Lordship go through the affair, the
Hmm.
entire allegation made against the accused number 1.
okay, 31. Same, there's a petitioners are similarly placed.
Yes, similarly placed. Similarly.
The allegation is lodged.
Why is interim not allowed in case of attempt 30? Acha, so, okay, show me 30. Where is the FIR?
Page 8, Lord.
Okay, I'll read it myself. Wait. What is his name? Ashikul Ullah. Ashikullah.
Ashikullah. Accused
And
number,
what is the name of the other one? Allah.
other one,
Aklak.
Aklak Hussain.
Aklak Hussain.
Aklak is not an accused here in the FIR?
Bubbling, number 2. Elias Bubbling.
Oh,
Accused
Elias
number 2.
Bubbling.
Yes.
Bapre. Elias Bubbling. Okay. So the owners have beaten up the inmates of the
Yes.
rehab center.
Yes. Here, the allegation is, the main allegation against the accused number one. Has
But then,
already been arrested. Our petitioner is a trustee also, is a, the rehab center against which the allegation has been made, Lordship, is a trust, Lordship, public charitable trust. And the petitioner.
no, he is running the rehab center.
Is a, one of the trustee. And petitioner in item number 31 also one of the trustee. There are three number of trustees. Lordship.
So it is owned by Abu Jamal,
Yes.
accused number 1.
Yes.
And the petitioner is the trustee.
Trustee.
But then the allegations are also against accused. Moreover, accused had also assaulted. What?
Against accused number one. Page nine.
Others, the other persons are also owners.
Owners.
Yesterday night,
Honors means they are one of the trustees, that is why
Trustees, they
they
are the
refer to as honor law. The petitioner in item number 31 and the petitioner in this case, Lordship, they are the one of the trustees. And the main allegation is accused number 1. He beaten up the, Lordship, the son of the informant. Against beating.
heard Mr. B. Haldar, learned counsel for the petitioner, and Mr. B. Sharma, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Juria PS case number 137 of 2026 under section 318, subsection 2/127 to 308 to 118 to 35 of the BNS 2023. The FIR in connection with which the petitioner was arraigned as an accused person was lodged by the father of a victim, stating inter alia that his son was in the rehab center owned by, rehab center, and that accused number 1 had beaten up his son and had caused grievous hurt on his person. Full stop. It was also stated in the FIR that other persons wherein the name of the petitioner figured is also the owner of the said rehab center. Full stop. However, the learned counsel for the petitioner submits that the allegation were mainly against accused number 1 in the said FIR, and that the petitioner was a trustee of the said rehab center, and no allegation is made against the petitioner in the FIR. Mr. B. Sharma, learned APP for the state, submits that although accused number 1 is the main perpetrator of the offense, but petitioner, who is also stated to be co-owner of the said rehab center, has also contributed to the said offense. And common intention on the part of all the accused person was framed by the, was seen in the instant case. On consideration of the submissions made by the parties, more so in view of the fact that no overt act is attributed to the petitioner, this court, overt act is attributed to the petitioner in respect of the offense at hand. This court deems it fit to enlarge the petitioner on interim, on pre-arrest bail, on furnishing of a bail bond of so-and-so, to the satisfaction of the arresting authority. He will appear within 7 days from the date of the order. Are it pre-arrest bail, bottom line too. And second one, oh yes, you are there. Heard Mr. B. Doctor, learned counsel for the petitioner, and also heard Mr. B. Sharma, learned APP for the state, Hey, the first paragraph to eke hobo. Okay. First paragraph will be same. It is noticed that the petitioner was enlarged on interim pre-arrest bail by order dated 25/6/2026 on the condition, amongst others, that he should appear, that he shall cooperate with the investigation. And the learned counsel for the state submits that pursuant to the said interim pre-arrest order, the petitioner had appeared before the investigating officer and his statement was recorded. As such, this court deems it fit to make the order dated 25/6/2026 absolute, and the petitioner is allowed to remain on pre-arrest bail. Petition is disposed of.
As you said, Lordship.
32.
So, matter may be taken up to some time, Lordship. Taken up to some time, Lordship.
Okay. After some time. A case diary is there.
Yes.
Yes.
This
Case
is,
diary is there. Report.
this is a non-FIR case, Lordship.
Report not.
So the report is there.
Not received, Lordship. From Lala PS.
The last occasion also, Lordship, he has not received. Father of the petitioner, Lordship, was apprehended under the similar situation, Lordship. That bail application was disposed after getting the report, Lordship.
So FIR is lodged against the father.
No, no FIR, Lordship, is yet filed that has been reflected.
So how can the father arrested?
My lord, father was picked up on the ground that his son is not available.
Oh,
And father also approached before this honorable court. My lord, in that event, Lordship, the
so
report-
if the father is picked up in absence of the son, that there has to be some FIR.
No, that has already been recorded in the order, Lordship. Report was called for and that report was received. After that, Lordship, this order was. filed.
Report received that there is no FIR.
No,
In the case of the father,
no, neither the father nor the Lordship, son.
show me that.
Yes, yes. There is some protection, Lordship, no coercive action may be taken, that may be given till then, Lordship. With the same allegation, Lordship, father approached.
So FIR is there.
No, Lordship, kindly say,
What?
some
A
of-
report has been received from the police station that an FIR was lodged
but
against the petitioner and his son with allegations of inducing the complainant to invest an amount of 78 lakhs in a business transaction, and therefore the entire amount invested was misappropriated. Is innocent and is apprehending arrest against his son. Already appeared before the IU and no case has been raised against me. There is no apprehension or arrest. So FIR is
Yes,
against
sir,
his son.
so FIR was there,
Yes.
but the FIR has not been registered because otherwise, Lordship, the allegation.
Inquiry is
as
still
reflected in the
proceeding. I
order,
could not forward any
These
case
are
diary
giving
as
this
no
up.
case has been against the present. No, present petitioner FIR is not registered, but in case of son,
Yes.
No,
he is
that
the son here.
Yes, son,
So son, there is a case.
but FIR has not been registered.
You read the order properly.
Lordship.
It is said inquiry is still proceeding and the IO could not forward any case diary as no case has been registered
Yes.
against the present petitioner,
Yes.
but against his father.
Well, again, the son also, Lordship.
No. But FIR was lodged against the petitioner and his FIR was lodged against the petitioner and his son with allegation of inducing the complainant to invest 78 lakhs.
Anyway, your Lordship may call for the report until then, Lordship, at least, Lordship, no coercive action may be taken against the.
No. I don't pass order, no
Because
coercive.
something-
That's a misnomer.
Well, not al-
By
al-
Friday I will produce the order.
Okay, by Friday he will bring the report and on that
Yes, Friday.
day AB will be considered. Okay, heard learned counsels for both the sides. Report as called for has not been received. Mr. B. Sharma, however, submits that he will collect the report by Friday and will place the same. Prayer is allowed. List this matter on 31st of July. It can take this back. Yes, Ms. Begum.
Charge submitted, Lordship.
Charge sheet submitted.
Yes.
You will apply it there. Heard Ms. M. Begum. R. Begum, learned counsel for the petitioner, and Mr. B. Sharma, learned APP for the state. Mr. B. Sharma submits that the charge sheet has been submitted in the instant case. Why charge sheet number?
183, dated 25/7/26.
25/7/26.
Yes.
As such, the learned counsel appearing for the petitioner submits that she be allowed to move the appropriate application before the concerned court. Prayer is allowed. Matter is closed.
He is in interim bail.
Oh, interim. It is further seen that the petitioner is on interim bail, and as such, the said order dated 2/7/2026 is extended for another 15 days for enabling the petitioner to file the appropriate application as stated above. Petition is disposed of. It's closed, disposed of.
What is it? CD not received, Lordship.
Yes,
CD not received.
interim is there.
My lord, interim is there, but as per my instruction, she has submitted, and after that, PRC is also registered. And PRC case next date speaks on 4/8, my lord, September 4. So, my lord, kindly, I'm paying for the absolute, and on the next date, I will appear before the trial. She has submitted to receive.
Charge sheet is submitted, he is saying.
PRC also registered.
PRC
I have the
registered.
PRC case number.
Let them appear also within 10 days.
Next,
I'll extend the interim order, you appear and take the bail there,
Yeah.
right?
but otherwise, your lordship can also make it absolute, I think.
No, that will have to be based.
But without the,
records.
you don't have the record.
No. that's-
Without the records, how can I say that he appeared before the IO and
Yes.
it was registered?
That
He's- He is cooperating. So I'll extend it for another 15 days, you take it.
Next date, yes.
Heard Mr. AK
Next
Azad,
date,
learned
Next date is 4/8, Lordship.
4/8.
4/8.
Yes.
4/8.
4/8.
So let them appear on 4/8.
So I'll extend it 4/8. So I'll extend it by 1 week, 10 days.
Or Lordship
15
can,
days, my lord. 15
Lordship
days.
can mention the date also, Lordship, no issue in that.
Yes.
Yeah.
Okay. Till 4th, it will be, this one will, I'll extend this interim order till 4th and you file an application.
Well,
Okay. Heard Mr. AK Azad, learned counsel for
10
the,
days, 15 days, it will, I think, not mentioning date, but
no,
Fourth.
you said it is, next date is on 4th. Okay. And Mr. B. Sharma, learned APP for the state. Mr. The learned counsel for the petitioner submits that the petitioner is on interim bail protection and that in the meantime, the charge sheet has been submitted in the instant case and that the PRC case has also been registered.
PRC case number 64/26.
Being PRC case number 64/26. He further submits that the next date of the case is fixed on 4th of August 2026.
For repair.
Full stop, para. It is noticed that the petitioner is on interim protection by order dated 2/7/2026 and the learned counsel for the petitioner submits that he be allowed to move the appropriate application before the concerned court. The prayer is allowed. Further, it is seen that the petitioner is on interim protection by order dated 2/7/2026 and the said interim protection is directed to be extended by another extended till 4th of August 2026 for enabling the petitioner to move the appropriate application before the concerned court. Petition is as such closed.
Undeclared.
37 Lordship, CD.
Enlarged till 4th, move the application within the set time frame. Yes.
CD not received, Lordship.
CD not received. You are interim? Okay. Heard Mr. SW. S. Nawaz, learned counsel for the petitioner and Mr. B. Sharma, learned APP for the state. Mr. B. Sharma submits that the Case diary has not been received and has prayed for a date for placing of the same. The prayer is allowed. List this matter on 14th of August 2026. The interim order passed earlier shall continue until the next returnable date.
Slightly longer date, 14.
Okay. 21st?
21st.
21st of August, huh?
Deep look.
32 case diary is there.
Yes.
Lordship, find FIR at page 9.
Page 9. Saidul Islam.
The case of kidnapping, Lordship.
So the petitioner is also not in his house. She is also not in his house, in her house. So they must have eloped.
Brother-in-law of the victim, Lordship.
Brother-in-law is the petitioner.
Petitioner.
Brother-in-law of the victim. Her sister's husband.
Sister, sir.
So it's not a pure case of love affair.
Might not be, but she went to the house of petitioner. Lordship.
Her 183 statement.
Yes. He went with him.
আচ্ছা
That
বয়স 17 বছর 17
yes.
She eloped with her brother-in-law.
Yes.
Sister's husband.
Yes.
But she is minor. 17 years. So what are your grounds for bail?
My ground would have mentioned that she of her own losses, own volition went with the petition.
She is minor, otherwise she has stated that she on her own volition they had an affair and she went.
Otherwise 17 years.
17 years.
But POCSO is not yet. added
So her
to-
consent will not matter. He should not have taken her.
But POCSO is not yet added.
Huh?
POCSO is also not added as of now.
What is not there?
POCSO is not added as of now. Lordship.
It will be added later.
Um,
Now only 87, kidnapping.
Only kidnapping.
Only kidney. Everything.
Had it been a boy, unmarried boy, I would have understood. He is a married person. He will also know her age.
Might be in confusion, 17 years, that's why.
From 2 years, she said that they were having a relationship. He will definitely know her age and that she was minor. He is the brother-in-law.
No,
No AB.
I will give you the just minor.
Okay, you appear before the IO as and when called. Heard Mr. Heard Mr.
MK Hussain.
M.K. Hussain, learned counsel for the petitioner, and Mr. B. Sharma, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Pragjyotishpur, PS case number 53 of 2026, registered under section 87 BNS 2023. The FIR dated 3/5/2026 was lodged by the mother of the victim or father?
Mother of the
Mother of the victim, wherein it was stated inter alia that her daughter was found missing from her home at about 3 p.m. No, missing from her home. And even on searches being made, her daughter could not be found. It is full stop. It is also stated that the mobile phone of her daughter is also found to be switched off. And on suspicion, it was stated that the petitioner is involved in the said case. The learned counsel for the petitioner submits that the petitioner and the daughter of the informant had a love relationship, and that the daughter of the informant had herself gone to the house of the petitioner and as such she was found missing. Mr. B. Sharma, learned APP, however, has placed the statement of the victim recorded under section 183 of BNSS, wherein she stated that she was in relationship with the petitioner for the past 2 years and that she had left her house on her own volition and went with the petitioner. Full stop. She also stated that she initially stayed in the house of the petitioner's sister after eloping with him, and thereafter she came to the petitioner's house and started living with the petitioner in the said house. Full stop. On consideration of the submissions made, and more so due to the statement given by the victim, and nalage more so. Upon consideration of the submissions made by the learned counsels, this court finds the following. The petitioner is the brother-in-law of the victim, and that it is also found that the petitioner was having a love relationship with the victim. And although the age of the victim was not reflected in the FIR, but she in her statement before the magistrate had stated that she was 17 years of age. But at the same time, she revealed that she was having relationship with the petitioner, and she on her own volition had gone to him, and that she stayed with him at various places. Although the consent of the petitioner, if she is a minor, is not relevant in the instant, will not be relevant. But seeing her statement and her age not being reflected in the FIR, this court finds it fit to enlarge the petitioner on pre-arrest bail on furnishing of a bail bond of 20,000. Baki ki nahi ki. To the satisfaction of arresting authority. Under the following conditions. Of this first.
May I please, your lordship? In this case, my lord, the accused party, the informant party, all are cousin brothers. And lordship, when I moved this case, out of 4 petitioners, 2 granted bail and 2 denied. And thereafter, now the case is between interim party and non-interim party.
Acha, those who are released are not.
two persons are getting.
They are all similarly situated.
So all are similarly, all are cousin brothers, my lord. Informant party, firstly, the case was between informant party and accused party.
And you have moved for all the four petitioners.
I moved the petition on behalf of four petitioners. Two are two are on interim protection and two are denied.
Why? What is the ground for
Ground
reasonable
for denial,
classification?
denial of the interim, my lord. What happened? Some allegations were serious against the one and two.
Acha.
Now, lordship, the case is between the interim party and non-interim party.
Acha.
So, lordship, may I pray that we may also be granted the interim.
So case diary is there.
Lordship, I'm appearing on behalf of the informant.
You want cancellation of the rest of the bail also, interim. Or what?
Lordship, as far as I have checked, lordship, nothing overt was, no act was essentially said against the accused number 3 and 4, but accused number 2 and 1 definitely were involved in it. And they essentially said that there was some altercation, but that could not have resulted in somebody, in me getting hit with a rod, lordship. In my brother.
What is the injury?
And lordship,
Injury is grievous.
injury is grievous, lordship. There is a frontoparietal lobe laceration, which is around
Okay,
18
that-
centimeter, square centimeter.
So, according to him, I think as far as 3 and 4, it can be made absolute,
We can.
but
just
not
make
1
that
and 2.
compensation, chief.
but not 1 and 2.
Not 1 and 2, lord. Because 1 and 2 lordship were directly involved because then I believe lordship.
Okay, let me make,
directly attacked.
let the 3 and 4 bail be absolute, but not in case of 1 and 2. What are your grounds for 1 and 2? 3 and 4 had appeared before the IO.
Yes.
So 3 and 4, no problem much, but 1 and 2?
Although lordship, their involvement is there, but I will not press on 3 and 4. But at least 1 and 2 lordship should be rejected because lordship, if lordship kindly comes to the FIR, page 11.
Page 11.
Yes, that is the translated one. Lordship will kindly see specifically mentioned that 1 and 2, the victim with rod on his head. That is specifically mentioned. There is no doubt about it. And in the CD part, lordship, the IO has collected several witnesses who have examined, who have witnessed the crime, and they have also stated the same thing. 1 and 2 hit the victim with iron rod. Now, as far as the medical report is concerned, lordship can kindly peruse. This is the injury report from Bongaigaon Hospital, lordship. There it is, several fractures are there in the head, lordship, and he has suffered brain injury, grievous hurt, and he was referred to better treatment for GMCH, lordship. These are the reports. So, in respect to 1 and 2, I'm paying for.
Actually, section 3.5 is also there. Other two are also implicated.
Yes, they are also.
So they had shared the common intention.
And lordship, his statement could not be recorded till death because he is not in a state.
1 and 2.
No, lordship,
No.
the victim.
Oh,
He has
victim.
suffered severe brain injury, lordship.
He is still under treatment.
Yes, so that is why, lordship, even though I'm not pressing, but lordship, they are also involved, 3 and 4. And the statement of the other witnesses are also there, lordship. Lordship is well aware, lordship, hitting the vital part of the body, lordship. The intention is there. Several fracture and brain injuries there, grievous nature, all has been mentioned, lordship. He was referred to GMCH, lordship.
And the witnesses have stated about 1 and 2, 3 and 4 also.
3 and 4 also, lordship.
That they have all
Yeah, all
attacked him.
collectively attacked that one person, lordship.
So common intention is there, but then okay, 3 and 4 are were on interim bail and they have cooperated.
Yes.
But 1 and 2, no chance.
It is up to your lordship.
Okay.
I'm not pressing any.
Also, one should not take the law in his own hands. And serious, very serious, the boy is.
Serious.
He is, of course, 40 years of
paid
age.
Only because all our cousin brothers, that's why I'm paying that they may also. get.
At this stage, okay, when the informant is, his statement is recorded, you can again come, okay?
Yes.
Heard in item number, oh, same. Heard Mr. G. Chomua, learned counsel for the petitioner, and Mr. B. Sharma, learned APP for the state, and Mr. A. Talukdar, learned Tarafdar, learned counsel appearing for the informant. By this application, the petitioners, being 4 in numbers, had prayed for bail in connection with Gulabganj PS case number 146 of 2026 under section 61 to 117 to 109 35 of BNS 2023. This court, by order dated 13/7/2026, had enlarged applicant number or had enlarged petitioner number 3 and 4 on interim pre-arrest bail on one of the condition that the petitioner number 3 and 4 should appear before the investigating officer within a period of 10 days. And in pursuance to the said order, petitioner number 3 and 4 had appeared before the investigating officer and their statements were recorded. As could be seen from the case diary. So as far as petitioner number 3 and 4 is concerned, the order dated 13/7/2026 is made absolute, and the said petitioners be enlarged on. The said petitioners are given the liberty. Said petitioners are allowed to remain on pre-arrest bail. Full stop. Para. However, as far as the petitioners number 1 and 2 are concerned, the allegations found against them in the FIR is that when the brother of the informant was returning back from his relative's house, accused number 2, the petitioner number 2 was heard speaking ill about him, and when the brother of the informant confronted the said petitioner about the same, petitioner number 1 attacked him with an iron rod and assaulted him. Full stop. It is also stated that petitioner number 2, who was also present, threatened to kill the brother, and he too assaulted on the head and other parts of the body. The learned counsel for the petitioner, however, submits that the fight had taken place between the petitioners as well as the informant's brother, and that they are all related to each other. Informant is also related.
Yes.
Each other. He submits that there was no intention on the part of the petitioners to commit the offense, but at the spur of the moment, the same had happened. The learned counsel for the state, however, has placed the medical report of the informant's brother, wherein it is reflected that there are many injuries, grievous in nature, on the body of the victim. The learned counsel for the informant has also submitted that his brother was severely injured by the petitioners, for which his brother is still under treatment. In view of the same, this court does not find it fit to enlarge the petitioners, being petitioner number 1 and 2, on pre-arrest bail. As such, the prayer made by petition number 1 and 2 are rejected at this stage. Petition is disposed of. Bail hearing नहीं bail hearing है item.
May I please worship?
Yes.
Is your lordship?
1 second, I'll just take out the 18.
Matter will be taken after some.
18.
Yes, lordship.
This is 8. Oh. No. Okay, 16 first.
Sorry.
Yes, 16, petition. Yes, Mr. Nawaz.
I appear for the respondent, my lord.
Okay. This is quashing of FIR or what?
Quashing of a proceeding, my lord. Yes,
Petitioner side is not there.
this I was there, my lord. I was outside.
No, last
Yes,
time?
please come, my lord.
Huh?
Please come.
Oh, yes. Yes, you are there for item 16.
Yes, ma'am.
So what is to be done here?
This with my junior, my lord. I can see.
Okay, after some time,
Fine.
you collect it. 17 cured. Who's it? Oh, okay.
Lordship, I am for the respondent.
Huh.
Eventually, this revision is not maintainable. So for section 19 of Family Code Act. Because the-
Okay.
because the-
Against any maintenance order?
Yes, a judgment passed by the
It will be before the division bench?
division bench, Lordship. And we have already preferred appeal. The wife already filed preferred appeal, and appeal is sub judice before the division bench. And
Okay, let this be also tagged along with,
Taken after some time, lordship. My senior is coming, lordship. Sir?
okay, after some time, he might have something to say.
Yes.
Hello, Pisat.
If you-
Yes, 20. Okay, I think 19, 16 has got the file. Okay, come, 16.
May I please vote? Lordship, in the matter of what happened, my lord?
16. Yes. Hmm.
The daughter, my lord.
Uh-huh.
The daughter lodged the affair against the mother, my lord.
Hmm.
Yes.
Daughter against mother?
Daughter against my.
Okay.
Fight between daughter and mother, my lord. Basically, this is ego problem, my lord.
So you are praying for quashing of FIR?
My lord.
Show me the FIR.
My lord, after the page number, my lord, 12, my lord. The criminal petition.
Hmm. Okay, wait, I'll read it myself. Who is the petitioner here? Arabjan Nessa. Arabjan Nessa and who's the other one? Dilwar.
Dilwar.
Hussain.
How are they related?
My lord, Dilwar Hussain and the informant is cousin, my lord.
Achha. Otherwise, two accused persons are not related.
My lord,
Accused persons are not related.
accused person related, my lord.
Son-in-law.
Son-in-law, my lord.
Whose son-in-law? Dilwar is son-in-law of Arabjan.
Son-in-law can you get?
Yeah, but, yeah.
Huh?
Take only 10 minutes.
Okay, I'll read the FIR and I'll.
But the lordship will read the FIR, get an idea.
Who stayed there about 2 months back. My own mother, Arabjan Nessa. Dilwar is the son-in-law.
As per the affair, my lord.
Acha.
Yes,
As per the FIR, even you're disputing the marriage.
My lord,
Okay, I'll read. Let me read it. Okay. My marriage with accused forcibly, although I did not attend my license stayed with my family and forcibly established physical me and family physical and mental harassment to me on 27/7. Acha. Okay. Strange.
what happened? Respondent number 3 and respondent number 4 were in a love relation, my lord. And
Wait. Who is respondent number
respondent
3 and
the
4?
informant, my lord.
Acha.
The daughter.
If my learned friends permits, I'll just give a brief fact so that you should understand. In this case, respondent number 4, he is otherwise a stranger to this particular case which my learned friend is trying to watch. And respondent number 3 happens to be the daughter of Arabjan Nessa. So now Arabjan, this daughter, respondent number 3 and the respondent number 4 were in a relationship. So initially, the mother lodged an FIR. The respondent number 3 and respondent number 4 had eloped together. Had eloped together. So at that time, the respondent number 3 was a minor. So accordingly, an FIR was registered, charge sheet was submitted, and the respondent number 4, which is me, I am facing trial for that case. That time, the victim was a minor. Thereafter, after the victim was recovered, now here this FIR comes in, the respondent number 3 lodges an FIR saying that after she was recovered, Arabjan Nessa got her forcibly married to Dilwar Hussain. And Dilwar, that is the allegation. I'll come to the veracity later on, just giving the allegation. Got married to Dilwar Hussain. But at that time, because this respondent number 3 was a minor, and she lost the FIR, so the FIR was registered under the Prohibition of Child Marriage Act and POCSO Act. Subsequently, my lord, this victim, this respondent number 3 was recovered, and she spent almost 1.5 years till she attained majority in a children's home. After she attained majority, now respondent number 3 and respondent number 4 have gotten married, and they are living together, my lord, as husband and wife.
Now respondent number 3 and 4 are husband and wife.
Husband and wife, and they are living together. Now the grievance of the respondent number 3, why she had filed the FIR against the petitioners, was that when she was a minor, after lodging the case against me, she was forcibly married by Arabjan Nessa to Dilwar Hussain, and because she was a minor at the time, so Child Marriage Act and POCSO Act comes in. Now, in that case also, subsequently charge sheet was submitted and the trial had commenced. Now, I believe there is a stay order also, my lord.
So charge sheet is submitted here.
Charge sheet is submitted, ma'am.
Under child prohibition and POCSO.
And POCSO, ma'am.
So why don't you reach to a settlement, both the parties, right?
Because now another thing
I'm a
is that-
minor.
yes, that minor part is there, but again, that is something which can be, my lord, tackled with if it is done tactfully, my lord. The apprehension respondent number 3 is here, perhaps he can submit on that effect, is because this is still a case against him, which has been lodged by the petitioner number 1. That case still survives. But now obviously they have got married and maybe that case will not reach any conclusion. But the grievance remains perhaps for this extent that because she was a minor and despite knowing of this relationship, she was married off and she had to stay in the children home for a considerable long amount of time.
Minor means she must be around 17 years,
16,
right?
17.
Now that you are married.
We are married now. Now she's around 20, 21, my lord.
Now both of you are married
We are
to each
living
other. And the case is going on against you.
Against me, the case is going on. I'm still facing trial.
For kidnapping the minor daughter.
For kidnapping the minor daughter. As far as they are concerned,
You are on bail.
I'm on bail, my lord. I got bail immediately thereafter.
And
One.
my problem, what happened that, my lord, Arabjan Nasa, who lives alone in home, my lord, and she has various suffering from various illness, my lord, like sugar, diabetes, and hypertension, my lord. And at this stage, my lord, it is not possible for her to go and.
But as far as quashing of the FIR, this is allegations are established because she was minor and she was given in marriage forcefully with Dilwar. And then she was also subjected to physical relationship. And of course, they were married by then. And Dilwar threatened to kill me with a dao. Those are exaggerations.
My lord,
Those will be exaggerations, okay? But
at initial stage, my lord, the murder against the both of them, my lord. So
mother was against both the daughter and the respondent number
respond
4.
for my lord.
And now, after she was brought back from respondent number 4, she was given in marriage with Dilwar.
My lord.
So what to do? I mean, what are your grounds for quashing?
My lord, our ground of quashing, my lord,
You both have a talk with each other, reach to a settlement. These are all family members. Of course, Dilwar, I don't know whether he will enter into a settlement because he married the accused number 3, respondent number 3. And now he is known where there. Right. Mother, daughter, son-in-law, they can enter into a settlement.
that will suit
But
my-
Dilwar Hussain, I have my doubts. He is A third person rather now.
Third person.
So on what basis can I quash it? There is no basis for quashing. You enter, I'll give you some time.
My lord.
Speak amongst yourselves. Both the cases can be settled.
Both the cases, yes.
Well, that is something which I had proposed, that the informant in that case, other than Nessa's evidence has not yet been recorded, has been pending for a considerable amount of time. Summons have been issued to her. Because I am still at peril because the case against me is still subsisting. So in that, if some sort of an understanding can be reached, in that case, now we are married. So there's no point in pursuing that case against me. If that case can be settled, in that case, perhaps the respondent number 3 may be in a position to make some sort of a concession for Arabjan Nessa. But for Dilwar, perhaps.
Dilwar, it will be difficult, okay. Somehow bring him to the settlement table.
My lord.
Okay, on the request made by the learned counsels for all the parties, list this matter on 20th of August.
Longer date because this will take some time.
So almost 1 month I'm giving. List this matter on 7th of September,
My lord,
2026.
Lower court proceeding may be stayed, my lord. Till date, my lord, lower court proceeding may be stayed, my lord. As we have stay order got earlier, my lord.
Achha.
There is
IA criminal 359 of the 2026. My lord.
only regarding a warrant of arrest that has been kept at effect.
My lord.
But if a stay is granted, then again these things may get derailed, my lord, the settlement process.
It will be finally disposed of. You have a talk.
My lord.
No stay.
My lord.
You appear before the trial court and say this, that we are in the verge of doing something. Okay, revision petition. Oh, not maintainable, he's saying?
No, my lord.
This is against the family court's order?
No, Lord. Lordship kindly see 19.2, my lord.
Huh?
Section 19.2, my lord.
Acha, do you have some family court act? Dada, family court act.
It will lock.
Oh, here we go.
I think it took.
For me, one.
Section
19.2.
19, my lord, deals with appeal, my lord. Section 19.2
Yes.
regarding maintenance proceeding.
No appeal shall lie from a decree or order passed by the family court with the consent of the parties or from an order passed under Chapter 9 of the CRPC.
9 deals with, my lord, proceeding relating maintenance. 125 to 128.
So,
Revision is maintained.
this is what?
Revision, my lord.
No, this is what? Against what?
Against order granting maintenance.
Passed by family court, not the magistrate. So, Lordship, Chapter 19, 9 deal with
CRPC.
magistrate,
CRPC.
not the principal judge.
Or you can give it back. Can did you? CRPC can do so.
So, section,
No appeal,
section,
no
section
appeal
19,
shall be filed, Lordship, from the decree or order passed by the family court.
With the consent of the parties.
consent of the party.
No, next, my lord, or from the order, or from the order passed under Chapter 9 of CRPC. So this is order under Chapter 9 of CRPC.
Where it is.
Then there will be no appeal. Then revision.
We have filed a revision, my lord.
No, my lord.
No, there is something more, I remember.
Chapter, this judgment, final order, not passed under Chapter 9. It is passed, Your Honor, by principal judge family court, not by magistrate. Chapter 9 deals with the magistrate. When the area, that's principal judge not sitting, then judicial magistrate also can pass the maintenance order. Therefore saying, then when magistrate pass the order
One
under
second,
the
let
Chapter
me
9,
have a look into
then
it.
appeal does.
Wait, I'll just look into it. Chapter 19, right?
Chapter 9, my lord.
9.
Chapter 9,
9.
orders for maintenance of wife, children and parents.
So 125 to 128.
Yes, ma'am.
So appeal will not lie
Yes, ma'am.
against the order passed under Chapter 9.
Chapter 9.
Okay. So here, what have you challenged?
I have challenged the order of granting maintenance to the wife
By the
by the family court.
family court. But he is saying that chapter 9 by the magistrate.
No, no, my lord, rule, section 19(2) clear, my lord. Passed by the family court. And where family court exists, my lord, no magistrate is functioning. Section, my lord,
Family court with consent of the parties, that is one consented, then appeal not lies.
He has filed revision.
Yes. But here, the case in hand, this is not a consented. If consented, then revision lies.
now jurisdiction
And
of,
where judgment passed or final order passed by the principal judge family court, appeal lies. And this if revision, then division bench
No,
will.
if you're confusing. This is
Now
this is the bar to an appeal,
lordship come.
not revision.
Impugn order, that is final order 10/11/2025. Kindly have a look. Who passed the order? Whether it follows chapter 9 of the Code of.
But subsection 5, you see, except as aforesaid, no appeal or revision shall lie to any court from any judgment, order, decree of a family court. What about subsection 5?
except the as aforesaid.
Huh. Except as aforesaid.
Yes.
So where is that aforesaid?
So 1 to 4, my lord.
That revision is maintainable.
Yes, first 19(1) is regarding appeal, my lord.
The entire section is regarding appeal. Section 19. So save as provided notwithstanding anything contained in CRA and in the code of any law in appeal shall lie from any judgment, order not being an interlocutory of a family court or to the high court, both on facts and law. No appeal shall lie from a decree or order passed by the family court with the consent of the parties, or from an order passed under chapter 9 of the Code of Criminal Procedure.
So under subsection
Provide
2, my
nothing
lord,
else shall apply to
revision
any
is made.
appeal pending for chapter 9 before commencement. No shall be preferred within a period. The High Court may in its own call for example. Proceeding regulate the family court to whether they will.
Now, lordship, so far this impugn order.
One second, I have not finished reading.
And this is this revision file for quashing.
What about subsection 4? The High Court may in its own motion or otherwise call for or examine the record of any proceeding in which family court situated within its jurisdiction.
So motor power.
Yes. Passed an order under chapter 9. Here, family court has passed an order under chapter 9 in your case. Chapter 9 of the is here for the purpose of satisfying itself. This is suo motu part. But appeal, but where is the provision that revision will lie
So when
against the order of the family court?
the appeal is not maintainable, then revision will lie, man. Because appeal is,
No,
Any judgment to that effect? It is the other way out, you are saying. Because appeal will not lie against an order passed under chapter 9 or by family court where it is passed on consent of the parties. So here it's an order passed under chapter 9 by the family court. And where no appeal lies. So when no appeal lies, you will file a revision in the guise of an appeal. whether that will be permissible.
Then in this point, I will satisfy your lordship regarding judgment.
You bring some judgments and all.
Lordship,
Whether appeal or revision.
respondent, my lord.
When a particular procedure is not allowed, if it is revision is not allowed, you'll file appeal. If appeal is not allowed, you'll file revision. This is not the way out. Of course, revision is on a limited campus.
For
Under
correctness,
401.
for correctness. For
Under
correction or
397 and 401 perhaps.
But here,
Bring some judgment that revision lies.
husband-wife relationship that is not denied. So how can be quash maintainable, quashing petition maintainable? Under
No, here he has come against the maintenance order passed by the family court.
Yes, lordship.
Under chapter 9.
But chapter 9, this imposing judgment saying 10/11/2020, kindly have a look, page 40.
It's okay. Let him
Whether
bring the
it is
judgment.
passed under chapter 9, whether it is passed under, that is to be looking into account. It is passed by the family court, principal judge of family court. And
Where it is? Where it is?
page 40. This subsection says that if consented and
No, if
pass-
it is by consent of the parties, then appeal will not lie.
yes, it is not like
He's
that.
again saying that revision will lie. But in the garb of appeal, you will file a revision. Right.
And
Showing both facts and law.
the respondent, the wife, already filed appeal.
Okay, you
There
bring
is-
some
there is-
judgments to bank on
there is
your.
no division.
Okay. Heard Mr. R. Ali, learned counsel for the petitioner, and Mr. Chaudhary and Mr. K. Bhuiya, learned counsel for the sole respondent. Mr. R. Chaudhary submits that he will bring some judgments to substantiate his argument and has prayed for some time. Prayer is allowed. List this matter. Noor Naha Rubul Ahmed, right? Yes. List this matter on which date?
After 27.
List this matter on 19th of August, 2026. Okay. The interim order is there.
I have filed objection.
Okay, let it be. Have you filed a petition for vacating?
Not.
Or not?
But objection file
Okay.
preliminary issue that.
Interim order
that is
passed earlier.
Regarding non-maintained.
Not maintained.
Okay, interim order passed earlier shall continue until the next returnable date.
My submission is to be recorded, the objection file so far section 19 of Family Code Act. is
Mr.
concerned.
K. Bhuiya has raised the issue that the instant petition is not maintainable under the law in view of the act, in view of the fact that
Sector.
appeal is barred under section 19(2) of the Family Courts Act, and revision as such is also not maintainable.
19(1).
Full stop. Further, he submits that he has filed his objection to the interim order granted by this court. The said issues will be dealt on the next date fixed. And as of now, Nilikiba, the interim order passed earlier shall continue until the next returnable date.
I look.
Yes, Mr. Ahmed.
This matter is wrongly listed in admission column. This ought to have been listed in motion.
Hmm?
This matter is wrongly listed in admission column.
It should have been?
Should have been listed in motion column. On first day also I took time and this topic
Oh.
was not listed.
Okay.
So sensitive
Okay.
matters can copy of TCF.
What is this matter about?
I'm praying for crossing of the charge sheet as well as lordship that a criminal proceeding. That FIR your lordship will find page 14.
Where is the FIR?
Page 14.
Hmm. No, wait, notices are not issued.
Not issued. Because lordship, the trial is proceeding, therefore I'm praying for staying that proceeding lordship. This
Acha.
will go that I'm not.
Who is the respondent?
Our respondent is the father of the girl lordship. Who
No,
committed
Srimati Rita Pegu,
mother.
mother of the girl.
Mother of the.
Okay, let's see. FIR 14. Wait, I'll read it myself. Rita Pegu, complainant. She had written a note accusing you.
Has not been relied upon by the investigating officer. That your lordship will find page 28. That was the part of last part of the chart, which documents they are relied. no whisper about what is written there in the start sheet. And in fact, the suicide note is also not relied on by the prosecution.
Doesn't
That is-
matter, it is there for me
Lordship,
to
kindly come
foresee.
to page,
That is why I am praying, Lordship, that Lordship will examine the issues, Lordship, that stay may be granted, records may be called for. I have
After
no
this stage
restriction on
also.
that. Because
No,
there
no.
has to be some material to show that I have abetted or instigated the girl to commit suicide. Mere Lordship, broken relationship, or Lordship that that dispute between the parties, that will not amount to. I am having some suggestion, I will place before your Lordship.
No, not at this
Acha,
stage.
what is the allegation against the petitioner?
That,
In the
accused-
FIR, it is not mentioned only that there was a note
There
Yes,
was-
the
where
accused has
accused person name was mentioned.
Yes.
Okay, one by one, I'll come back to you.
Learned friend is objecting, my learned friend can place from the charge sheet that where it is written, then in that suicide note, it is written that I have instigated or I have abetted the, where is that part? That has to be there in the charge sheet if it is there. Lord.
Hmm.
Because
There is nothing in the FIR, only that his name is
Charge
written.
sheet also nothing is there. In
Now,
fact,
show
your
me
Lordship
from-
may kindly see
Hmm.
page 27, Lordship,
Hmm.
brief of the case, may I read, Lordship?
Hmm.
Brief paragraph 16, I am reading, Lordship. The brief of the case is that the complainant, Shri Rita Pegu, is it so lodged an FIR at this PS to the effect that on 1/7/2025 at evening, her daughter, namely Monica Pegu, is it so has committed suicide by hanging inside her rented room at ward number 2, Aradhal, and one suicide note recovered from her room. When she was written the name of the FIR name accused person, Shri Krishna Dole. That is the petitioner before your Lordship. She died by committing suicide by hanging for abet commit to suicide by FIR named accused person. Hence this case. So how I am connected, that is not there in the FIR. Now from the, during what they have found during investigation, that Lordship may kindly see. Charge I am skipping, Lordship, that is the same. Now, after that, your Lordship find during the course of investigation of the case, she is deceased, one mobile phone, Redmi black color, so-and-so notebook with suicide note, Sadar white color, green flower.
Okay, you can
So,
skip that.
During
During
investigation of the
investigation.
case, deceased victim was sent to DMJ Civil Hospital for postmortem examination and collected postmortem report of deceased victim. The postmortem examination report of victim is given by Dr. Franco of Hemaji Civil Hospital. On examination of victim, doctor opined that, in my opinion, the cause of death is due to asphyxia following
So hanging.
hanging.
Then,
During investigation, sent deceased victim suicide note, pro SP office, crime branch, Dhemaji. So it is sent to FSL. It is found that it is her writing. There is no dispute. I am not denying that part. So then your Lordship will find person who wrote the blue endorsed writing and mark A1 red enclosed writing similarly stamped. So that is they have confirmed. During investigation of the case, accused was interrogated and given bail bond as per order. So what is there in the suicide note? They have not written anything. Nor the informant who has lost the affair. That is only mentioning the name will not do. There has to be abatement to
during interrogation, accused not admitted
Not
his crime.
So there has to be some material. I'm relying on some citations, Lordship. Just Lordship may kindly have a look that Honorable Apex would quash those cases, Lordship.
No, that is okay. That is a subtle position that in case of abatement to suicide, every minute details has to be proved.
Yes.
Otherwise,
There has to
simply
be-
saying will not do.
There has to be instigation that you commit suicide. Merely that I have rebuked someone or I have broken a relationship or denied to marry someone, that will not do, Lordship.
So now
That is
the
not
charge sheet is against you
Yes, Lordship.
He's the
and the
Right.
trial is on.
Yes.
Yes.
Cognizance taken.
Cognizance taken, that is at his appearance stage, Lordship.
Lordship,
right,
at this stage, I am praying for calling the TCR, Lordship.
Yes, I am
What
also
is
not-
there in the suicide note? And what are the materials against the petitioner on the basis of which the charge sheet has been filed, Lordship? Let us call for.
You
the
have
TCR.
prayed for quashing of the proceedings.
Charge
Said
sheet,
this
charge
charge
sheet
sheet.
as well as criminal proceeding.
That is not
That is not
possible
possible.
because see,
Prima facie case is
at
made.
least some new suicide note was left with the name of the petitioner.
Yes.
Nothing further.
Yes.
We accepted there is nothing further.
Yes.
She had simply written your name. But then it is for the trial court to
That
see.
will not
Yes.
be a suicide, treated as suicide, Your Lordship. What my case is before your Lordship is that she may have written my name, but in what manner she has written, that has to be there, Lordship. if she says that I was
See,
having.
this is not a trial court that I will prove the case beyond reasonable doubt.
Yes.
It is only that I will see the FIR if
That
any
is why
case is met out.
Involving inquiry of the-
Where
not
Honorable
required.
Apex Court was the criminal proceeding, because Lordship, there was no mention of instigation by the accused persons.
No,
Because of
see,
that, it was.
criminal case is all with its own
So those
facts.
criminal cases are, Lordship, your Lordship knows that, when Lordship, a person faces a criminal trial, it is not only that, how agony he feels, right, because during the trial, if there are material, he will face the trial. But if it is not there, if there are no material, why he will be subjected to that rigorous trial, Lordship? Because he is an employee, he has to come from Gauhati to Dhemaji to attend the court each and every day. If there is material, he will no doubt he has to face the trial. But if it is not there, how police can file charge sheet? Because in the charge sheet, they have not mentioned what is written.
Okay, okay, I'll call for the
FIR,
suicide
there's
note.
provocation part is there.
Yeah.
And so far as Lordship suicide note along with their mobile handset.
Provocation part I don't see
Yes.
anywhere.
Lordship, the suicide note will say.
No, suicide note.
They are
Whether
not relying on the
Mansuri
charge
is
sheet.
there
They
on
are
the
not
part of the
relying.
petitioner, Lordship, whether Mansuri is there on the part of the petitioner, that will reveal. So
No,
Lordship,
that
at
we
this
can,
stage-
because Supreme Court is clear in saying that
Yes.
abatement, there has to be clear-cut evidence.
Clear-cut evidence.
What,
Otherwise-
there is nothing on record to show that whether what was contained,
Yes.
what is there in the
Because
suicide note.
his name is mentioned in the suicide note, and her handwriting has been resemblance.
Okay, that is her writing,
proof.
that is
There
not
no
disputed.
Yes.
But a person who has simply an affair with a woman and
Yes.
she committed
No, Lordship,
suicide.
At this stage, I'm just praying for the calling of the TCR, Lordship, along with the suicide note. And thereafter, Lordship may decide, Lordship, whether he is
Until
material
then,
is against
Lordship,
him or not.
proceeding may be
Mansuri will reveal from the TCR, Lordship, from the suicide note itself. I'm just praying for the.
That way we can see the abatement, whether there is
Yes,
at all
yes,
any
Lordship,
abatement.
That much I'm.
Nothing is written in the suicide note.
Lordship, as a-
That
as
much
a-
I'm praying later, Lordship may examine the suicide note, thereafter Lordship may consider.
Okay, heard Mr. A. Ahmed, learned counsel for the petitioner, and Ms. S.H. Bora, learned APP for the state. By this application, the petitioner has prayed for quashing of the charge sheet, being charge sheet number 110 of 2025, submitted on 23/8/2025, as well as the criminal proceeding instituted thereafter. The case of the petitioner is that one FIR was lodged by the mother of the victim, stating inter alia that in the evening of 1/7/2025, her daughter committed suicide in her rented room, and that her daughter had written a note prior to committing suicide, wherein the name of the petitioner finds place. Full stop. The informant therefore stated that it was the petitioner who had abated her daughter to commit suicide. In pursuance to the lodging of the said FIR, the police investigated the case and submitted charge sheet as mentioned above. Full stop. Para. The learned counsel for the petitioner, however, submits that the charge sheet was submitted against the petitioner without any basis. Full stop. He further submits that it was nowhere written in the charge sheet as to the contents of the said note left by the deceased.
That suicide note is also not relied on by the prosecution, that list.
He further submits that while submitting the charge sheet, the police have not relied on the said note left by the deceased. Ms. S.H. Bora, learned APP, however, submits that the victim, while committing suicide, had at least left the name of the petitioner in a note which shows that there is abatement on the part of the petitioner. issue notice. Petitioner to take steps for service of notice upon respondent number 2 by speed post with AD or by usual process. Call for the scanned copy of the trial court records, which should contain the note left by the deceased before committing suicide. Para. Since it is seen that there are no averments made against the petitioner, that he has abated the suicide of the victim, this court in the interim deems it fit to stay the further proceeding of
Sessions case number.
sessions case number
Uh,
T2
not.
within bracket T-2 number 56 of 2025 till the next date of listing. List this matter on 12th of June, 12th of August.
Also, along with the case diary.
Okay, it is a course, okay, along with the case diary, huh?
Offline.
Offline.
Yes, Miss Som?
Lordship here. And I.
There is a stay operating.
Yes, stay operating after considering all aspects. The fact was an NI proceeding, an act proceeding was initiated, alleging that 40 lakh something. Thereafter, Lordship, after the commencement of the proceeding, there was an arrangement like that. There will be 34 or 5 lakh. I'm not on record, just giving idea. So that has to be paid in 4 equal installment. So accordingly, petitioner has paid a substantial amount. In between, what is happened, because of his ill health and other compelling circumstances, he was not in a position, and because of acute financial constraint, he was not in a position to complete his undertaking as was made. So there was lapses, and even lapse of his appearance also. Thereafter, he approached this honorable court again, and this honorable court, after considering, set aside the NBW which was issued, and thereafter directed him to appear before the court. Accordingly, he appeared before the honorable court with a application that by this moment we have paid this much amount. Now this I'm willing to pay further because of my financial constraint. Let this matter be sent to mediation for giving me a scope of accommodation of 6 months, 6 installment. So that was the basic grievance. So the Lanet Trial Court rejected that application. Against that application, we have approached this honorable court with a limited prayer, Lordship, that since the substantial amount has been paid, and by rejecting my prayer, the court has ordered for cross-examination PW1. If it goes back to again PW1, then my money, which I have already paid, and that is not a small amount. Out of 35 lakhs, I have already paid 24 lakhs something. That was the situation. So
in between the trial, you had reached to that settlement. That in installment basis.
That was arrangement. That was arrangement.
What happened to mediation?
No, that is why we are before this honorable court. We filed an application before the trial court. Since this amount, this out of the settled amount, this much of amount has already been paid. So instead of placing it for cross-examination, let this matter go to mediation for a settlement of how
that was rejected.
And that has been rejected. And that is why, Lordship, we have approached this honorable court.
So you have come in between the trial proceedings?
Yes, in between the trial proceeding, and we are on with a limited prayer sent back to mediation, because now
Why was mediation rejected? He did not agree.
That was not exactly his.
So what has to be done today?
Lordship, my.
I'll again
specific,
send it to mediation.
No, Lordship, I am just, let her finish, Lordship.
Because by this movement, Lordship, out of the agreed amount, that has been duly agreed.
Okay, you have paid substantial amount of the.
Substantial amount, and if it is again going back to cross, so that my amount is.
No, your amount will not get vanished. It will be there. You have paid. Rest of the amount you should pay. And the trial will continue with regard to that amount.
No, that is not, that will be done, not, the trial will proceed according to the initial amount of 40 lakhs, that as per the issuance of the check, Lord.
How can you say that your paid amount will not be taken care of?
That is the.
Yes, Mr.
legality,
Poddar,
Yes,
what you
Lordship,
say?
may I draw your kind attention to para 4 of their petition, Lordship.
4 of their petition.
One thing in the law is their abuse of process. This is the exact case, Lordship.
Which paragraph?
Para 4, Lordship, their petition.
Hmm.
During pendency of the trial, complainant and the petitioner entered into a mutual understanding and settlement to resolve the entire dispute for a total sum of rupees 35 lakhs. To be paid in 4 installments.
That she had said.
So what left for mediation? They have paid 3 installments. Now last installment is to be paid. That was in 2024. And they have to pay the last installment. Subsequently, they failed to appear. Warrant issued. They have come before High Court. I have relying on 2 orders, Lordship.
Okay, High Court had allowed her to go back.
Again failed. Again come to High Court. Again chance was given to them. Okay, clear the installments. Lordship, just go through these 2 orders. One is criminal petition 84/26, Court 226. Learned counsel for the petition submitted till now, the petitioner has already paid 24,50,850. That should be 950. Remains to be paid out of the total. I have considered the submission since the petitioner interested in facing the trial should be given adequate opportunity to that effect. Thereafter, they have appeared, non-bailable warrant was quashed. Neither they are paying, non-facing the trial. So what happens? Court will fix the cross-examination, let them cross-examine, let them go for DW. In the meantime, if they pay, the trial will remain for 950 only, while sentencing, if at all.
So how, that is what I'm saying, this, your
Mediation
paid
for
money
what?
will not vanish.
Mediation for what?
Lordship, no, Lordship, if the cross-examination will happen at this point after payment of the substantial amount of
24 lakhs, you have
24
paid.
lakhs, yes, 50,000 out of 35 lakhs. So now according to him, I'm to pay 9,50,000. Now, what we sought, Lordship, we sought for little accommodation of giving us, considering, because something we cannot predict that this will happen tomorrow. At the moment when MOU has been prepared, that was a different circumstance, and the other day it was a different circumstance. Compelling circumstance.
You take a reasonable time from the trial court for payment of the 9 lakh.
That is not given, Lordship. That is not given.
They are going for that hours referred to mediation.
No, perhaps on grounds because you have not appeared.
Lordship, this is a compoundable case and since substantial amount has been, let their mediator may decide it for 2 installment, 3 installment, whatever. Lordship, that was our limited prayer.
No,
we are not asking we are not escaping from our liability.
No, mediation is correct in saying what will be the purpose of mediation. Mediation is done with impliedly. You have agreed. You have come to a settlement that you will pay it in 4 installments. Now, if you want more installments to pay the rest of the amount, you tell it to the court. The court will give you.
The court has not given. They rejected my application being rejected, Lordship.
Their appeal sent the matter to mediation. What
That
the
is
mediator
why
will do, Lordship?
we requested the.
Now, what have you challenged here? What have you challenged here?
That rejection has been challenged.
Page?
That has been impugned in this application.
29.4. Where is that 29.4 order?
Yes, that is at page 49, Lordship. Complaint in steps so and so. That has been that.
Wait, let me go through 49.
Yes. May I read, Lordship?
No, I'll read it myself. It's okay.
Yes. Lordship,
Who is
I-
PW1, the complainant?
Complainant, Lordship, I would like to place one.
Only that your or request for mediation is rejected.
Lordship.
But it is
And
rightly done so
Lordship,
because
going back to cross-examining complainant, that means coming back
Why
to
are you-
proceeding again, Lordship.
why
Instead
are you
of
scared of PW1's cross-examination? He will not say something different. He will say that 9,50,000 is due.
No, the Lordship, the problem
Right.
is Lordship, that
Complainant has to get money,
Lordship,
right?
that
No, we are
problem-
not challenging that part. We have received the amount. We are ready to.
No, you are yet to receive 9,50,000.
Yes, 9,50,000 Lordship, as per the compromise.
As per the compromise.
But
So
they are not honoring the compromise.
Lordship, my
Either
respect
paying
is-
nor honoring.
PW1 is you.
Not that,
Yes,
it's
Lord.
not that. Under certain compelling circumstances, that has not been paid. Had it been a case that they will not pay anything, a single penny, Lordship.
No,
Will
they
I
have
challenge-
Once they are
will I-
admitted their liability, once they have signed the petition for compromise.
Okay, what I can say is I will direct the lower court to consider the prayer of the petitioner to
Time
give
for
the
time being only, limited
to
time.
give the amount in 2 or 3 installments.
6 installment, it is about now because of this.
Why do you want to go for mediation? Mediation is already done.
It's not done,
It's
Lordship.
done impliedly. You have entered into a settlement 4 times installment and you will pay it.
Lordship,
What will mediation do?
That the none of the orders is whispering a single that we have paid this amount. Now, I'm very fortunate that he is honestly making his submission. That is the
That is on the
honest.
court
that
records,
is-
Lordship.
that
They have
is-
paid in court.
they-
Court
Think
records
not
are
a
there.
single
How I can
order
deny?
That is there in the
whisper
evidence.
That whisper that accept my application, that whisper that this much of amount is already being paid by the accused person. Nowhere it is.
Okay, I'll reflect that in the order. Heard Ms. T. Som, learned counsel for the petitioner, and Mr. Poddar, learned counsel for the respondent. Respondent number 2, and Mr. D.P. Goswami, learned counsel, learned APP for the state. By this application, the petitioner has, by this application filed under section 528 of the BNSS 2023, the petitioner has challenged the impugn order dated 29/4/2026, passed by the learned judicial magistrate first class, Borpeta, in NI case number 114 of 2024. Full stop. The petitioner has, by the said order, full stop, by the said order dated 29/4/2026, the petition filed by the petitioner, that is the accused person, for referring the case for mediation has been dismissed by the learned court of Judicial Magistrate First Class, Borpeta. The learned counsel for the petitioner submits that the petitioner was supposed to pay rupees. Where was that?
35 lakhs.
Where was that? Where did I read those? 35, 9,50,000. Oh, in the order. Was supposed to pay.
Lordship, give me 1 minute time, Lordship, just amount to confirm the amount, Lordship, just 1 minute time.
It's already recorded in the court's order.
Lordship, it is in the court's order, Lordship, in the
35
84.
lakhs. Para 10, Lordship.
Para for 34 lakhs.
34 lakhs, yes.
By which, okay, he was supposed to pay rupees 34 lakhs to the respondent number 2. And it has been,
According to us, it is 35 lakhs, Lordship.
okay, you see,
It is in the petition, Lordship, their petition, Lordship.
35 lakhs.
35 lakhs, Lordship.
35
In
lakhs.
the order somehow.
Okay, 35 lakhs. That is why this is 8,50,000. It should be 9,50,000, right? 35 lakhs to the respondent number 2. And she further states that out of the said amount of money, 24,50,000 was already paid to the
1050,
respondent number
according to
2.
This amount 1050. 1050 due. 10,50,000.
24,50,000 was paid.
35 lakh is the total amount.
Huh.
Lordship. So 10,50,000 is due.
35. So, a 9,50,000.
9 lakh.
No, 24,500, 50,
calculation
24 lakh,
is-
according to them, they have paid 24,500.
24 lakh 50,000.
So 10,50,000 remains according to them.
Hmm? 35 lakhs. So three.
1050, Lordship.
Huh?
10,50,000, according to their claim.
10,50,000 will be what?
Due, according to them, Lordship.
Then 35 lakhs.
Yeah.
Okay, 10,50,000, Miss Som.
Let them face the cross-examination, and during that part,
Lordship, in that case, cross-examination
they are before your 528
will get
petition.
back to the zero position, Lordship.
Okay, forget about cross-examination. Just tell me
Lordship,
how
after
much.
paying this much of amount,
So,
no?
yes, so 0 to 10,50,000.
Yes.
You have to pay 10,50,000. Out of, what did I say? Out of the said amount? Last one. 24 lakhs 50,000. 24 lakhs 50,000 was already paid to respondent number 2. And that the remaining amount, that is 10 lakh 50,000, is to be paid to respondent number 2. She further submits that during the proceeding of the trial, the settlement was entered into between the petitioner and respondent number 2, that the entire amount would be paid in 4 installments. And that till date,
Settled amount.
Should not be, Lordship, for
Settled
installment,
amount.
because already 24, since 24, they are not paying,
it
Lordship.
is recorded in the court's order. Why? It
Lordship.
is said that it was to be paid in 4 installments.
No, originally it was 4 installment, Lordship.
Huh.
35 lakh will be in 4 installment, that too monthly installment. That was in
Okay,
the.
in
long
installment basis, huh? In installment basis. But she states that till now, the said 24 lakhs 50,000 has been paid. The learned counsel further submits that she has the petitioner has apprehension that during the trial, they said payment of 24 lakhs 50,000 would be not considered, and as such, she has prayed before this court that in installment basis, the rest of the amount should be ordered to be paid. Mr. Poddar, learned counsel for the respondent number 2, admits that 10 lakh 50,000 amount is yet to be paid by the petitioner.
May
to
take
the-
1 minute instruction, Lordship,
Okay.
just amount, confirming the amount.
Huh,
Lordship.
okay. Wait, I'll dictate it and I'll change. You go and get the instructions.
Lordship.
To be paid to the respondent number 2. And he further submits that the instant case initiated by the respondent number 2 was only to get back his money. In the said facts and circumstances, it is therefore directed that the learned trial court, or that the learned court of judicial magistrate, the learned court of judicial magistrate first class Borpeta, who is in seas of the matter, should consider the said aspect of payment of the rest of the money to respondent number 2 by the petitioner in installment basis. Okay, you file an application before the court with the said prayer. The petitioner is given liberty to file an application before the said court for payment of the remaining amount to respondent number 2, and the learned court would consider giving time to the petitioner to make the said payment.
in case suppose rejects my application, then there will be again. we have
No, I've said they will consider and give you time to pay the money. Okay?
Let it be in the direct way lordship, let it be in 3 or 4
Direct way only I'm giving direction.
for installment lordship, because they will also, so
In how
because-
many installments you want to give? 4.
4.
Another 4.
Another 4 lordship, because extremely worst off.
Acha, you give in installments, please, in 4 installments. The learned court would give enough time.
Perhaps let Mr. Poddar come.
He will come. I'm here. Give enough time to the petitioner to make the said payment to respondent number 2. That is in 4 installments. That is the amount of rupees 10,50,000 in 4 installments.
One more submission may be considered that he is facing acute financial crisis and constraint.
Everyone makes that.
is-
It's okay. That is for the trial court to consider. Okay, let him come back. You be here. If there is any change, I'll do it. With the above direction, the petition is disposed of. If you be here, let him come back. I'll take up the next matter.
Lordship,
You be in the court.
lordship.
Okay. Ekhino head of DDM. 23.
So this is a washing of charge sheet and the order dated 2/2/2026. Here, Mallas, and case was registered against the accused, Sadiqul Islam. The vehicle which was driven by the accused person, I'm the owner. And I'm being the owner, the police official has investigated on 2/2/2026. They have filed an application. The application is at page number.
Acha, this is for what purpose? You have challenged the proceedings.
Washing of a charge sheet.
Washing of charge sheet as well as the order dated 2/2/2026.
Oh, this is NDPS.
So,
Charge sheet.
on
Order 22 is what? Taking
it's an
cognizance.
application filed by the police authority to the session code that the petitioner, that the police official had went to her home in search of that person, but she was absent on that ground. On that ground, they have stated that she's deliberately absconding, and that's why on the next page.
The accused person is absconding.
Yes, the petitioner is absconding. I'm the vehicle owner. I'm the accused person is in jail, madam. Now on 2/2/2020, which is page number 36, and NBW was issued, madam.
Against the owner.
Against the owner. I want to
Your
accuse-
vehicle was used by the petitioner.
My vehicle was used by the accused person.
Yes. Accused person.
Yes. And when
In transporting the illicit contrabands.
the accused person was transporting the illicit contraband of heroin, sure.
So you are also made an accused there.
I was also made an accused afterward in the charge sheet, madam. So on 2/2/26, madam, then NBW was issued the order is at page number 36, madam.
Show me that. Acha, first of all, show me the FIR where you are not the accused person.
The accused person.
First of
So
all,
that's why I'm not bothered.
one thing I have to confirm, we have TCR received, Lordship, but we have to go to the TCR also. Lordship, make submission. We have to not go through the TCR yet, Lordship. We have received the
Okay,
TCR.
let's go to the TCR then.
My lord, my only submission, I am ready to appear, my lord. Till that time, the NBW issued maybe state, and once I appear
Acha, NBW is issued against you.
against me.
So you have challenged that.
Yes, my lord.
Where is 22/6?
Lordship,
Show me.
I want to point.
On page number
Page number?
36. My lord, may I have it?
Yes.
Case record is put up to date. SI Monda Dole, IO of the case is present and file a petition stating that he had tried to apprehend the accused person, namely so-and-so, 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 and the accused is hiding, evading the police arrest. He has also annexed house search memos along with the prayer. IO had attempted to arrest the accused by searching her house on so-and-so, so-and-so.
Acha, 1 second. Yes, Mr. Poddar, did you get the instruction? So 10,50,000. She wants 4 installments.
3 years.
Yes, Miss Som. She wants 4 installment because he is facing financial constraints.
One monthly installment.
Okay, let her pay in 4 installments. We have money, don't worry. And if she does not, the petitioner does not follow that, then adverse orders will follow.
Then, order should follow from the
Huh.
Not from the waiting for.
No, what I have said is the trial court will consider giving time so that she makes the payment to you.
Let it be 3 months. Let us clear 10 lakh 50,000.
Next date fixed by the trial court.
3 installments of 3.5 each. 10.5 will be clear. If on the first pay, let her cross-examine our thing. And every it is a compoundable offense. At every stage it can be compounded.
Acha,
We
you
are
do.
admitting that yes, we have received.
No, she'll have to file an application for payment of the amount in installments.
Yes.
Okay, I have given her liberty to file an application before the court. Court will give enough time to give her to enable her to make the payment. And she had said that it should be given in 3 installments. So you want a date?
Yes, sir.
Within 3 months?
Monthly installment. No problem.
3 installments in 3 months' time?
Yes, sir.
No, Lordship. That will be on 4 months, Lordship.
Okay, 4 installments in 4 months' time.
Okay.
Okay, you write that, huh? In 4 installments. In 4 months' time, starting from the date, no, commencing from the date on which she files the application.
Lordship.
And if the same is not done,
A date should be fixed, Lordship, for
Huh.
appearance.
no, it is for them to file an application.
No, date should, because the trial court matter has been stayed there. Stay was granted.
So what is the next date before the trial court? When did she fix for examination of PW1?
On failure, Lordship.
Next date to the question, if she will file an application, liberty to file an application on.
No, date was fixed, Lordship. It was better because stay granted by High Court, Lordship. It was last.
That the fund also accumulate the fund also in the meantime.
That is an unlimited period, Lordship.
No, no,
Accumulation of
I'll
events.
give you a date. No, you will file an application before the trial court on 10th of August. Okay?
Okay.
10th of August.
Okay.
10th of August, there is enough days now. There are 15 days. 10th of August 2026, the date will be transferred and enable her enough time to file it to questioner. And within a period of 4 months, 4 installments in 4 months period.
Yes, Lordship.
Okay. And if and if the petitioner fails to file the said application within the stipulated time or fails to pay the installment in the 4 months time, the court will be at liberty to proceed with cross-examination of PW1
As per law, Lordship.
from the expiry of the 4 months period from 10th of August
Okay.
2026.
Obliged, Lordship.
He has taken to, he has to pay.
Because they have got enough time, Lordship. After
Let
compromise.
this all things be completed within a period of 6 months, Lordship.
No, Lordship.
4 months, 4 months.
Then
Then it will not be
Lordship.
possible for me to consider. Lordship.
All ways admitted, all Lordship has given him the privilege. This much only, Lordship. This all
6
I'm
months.
sorry, 6
No, it will be
months, Lordship.
too long, Lordship.
Not
It will be too long
Lordship.
because they are
It is
taking
okay.
2 years. After that,
Lordship,
they have come
Trial
twice
court
before
is
the High
fixing
Court, Lordship.
it after 6 months, 6 months. That is the condition, Lordship. Had it been a normal court, it will be the date will be
Okay,
fixed in the
okay,
month
make
of
it 5
November.
months. 5 months? 5 months. From the date of filing of the application, that is on 10th of August 2026.
Obliged.
So
Petition is disposed of. Huh?
Yeah, like,
Obliged.
Okay, okay. Come to the next case. Yes.
Bye.
And so, no, here you have challenged the charge sheet.
I'm challenging the charges as
Along
per
with
the
the
order,
NBS of
as per the order of
Hmm.
2 to 26 months.
So, here, he tried to apprehend the main accused. You are not the one.
I'm not meaning,
the vehicle
Yeah.
order.
I'm the vehicle owner.
Manjila Begum. Okay, fine. Then,
Manjula Begum, so and so, but the accused is hiding, evading the police arrest. He has also annexed house arrest memo, so and so. IO has attempted to arrest the accused by searching her house on so and so dates. Hence, he prayed for issuance of non-bailable warrant of arrest against the accused person.
Mm.
Peruse the case that in the case record, I have gone through the report of the IO. It transpired the accused person is avoiding the arrest and hiding to delay the investigation. In the background and considering the nature of offense, there is an incriminating materials against the accused. I deem fit to allow the prayer of IO issue non.
Acha, you are Manjila Begum.
Yes, I'm the member.
So, Manjila Begum is the owner of the vehicle.
Owner of the vehicle.
So, Lordship, I pray for
So, okay, I will keep this in abeyance and you
Lordship,
go and appear on the next
Yes,
date.
madam.
Lordship,
It's
page
in the
47.
paper.
Huh?
The search sheet, page 47, Lordship.
47. But why did you challenge the charge sheet?
Because on the charge sheet, it's written that I have been absconding, my lord.
Absconded.
Yes, that's correct.
Without following the procedure of section 84 and 85 of the BNSS, my lord.
Sir, 47 Lordship.
Okay, that is you are not declared absconder. You are just named as, you are just,
Intention is that I was having a medical treatment in Naga and I was living with some relative. I have
Okay.
annexed the medical documents as well, my lord.
okay, 47, what do you want to show?
Lordship, 47, page 47 Lordship, in the search sheet Lordship. May I read the from the bottom? Further requisitions were submitted for call details records and customer application forms. The seized mobile phone SIM numbers so and so, along with certain suspected numbers. The CDR and CF was collected and analyzed. Also, certificate under section 64 subsection C of the Bharatiya Saksha Adhiniyam BSA, which party certificate CDR and CF was collected. Upon analysis of CDR, it was revealed that the arrested accused had traveled to Manipur prior to his apprehension. He had frequent telephonic contact with the vehicle owner, Manzila Begum. He had previously visited Manipur on earlier occasions. In the light of these findings, a petition was filed before the Honorable Court seeking permission for jail interrogation of the accused. The Honorable Court granted permission accordingly. Pursuant to the court's order, jail interrogation of the accused Sadiqul Islam was conducted and his statement under section 67C NDPS Act was recorded. Initially, he denied visiting Manipur. However, when confronted with the CDR analysis report, he admitted that the vehicle owner Manzila Begum had handed over the seized vehicle to him for smuggling narcotic drugs. He had
This is the conclusion of the police.
But Lordship, the secret chamber was recovered from the contraband of secret chamber of the vehicle. He is the owner of the vehicle. So secret chambers were the vehicle in, she was well aware of the fact.
Who were arrested? The person
The
who
driver who
driver,
of the vehicle.
The accused person was arrested.
only the driver.
Yeah, the driver who was taking the contraband items and was traveling. My lord, my prayer is that they in the charge sheet, the police official without following the section 8, because the proclamation has to be given with the judicial office.
No, police cannot declare you.
Yeah, police in here, they have stated, I am responding, my lord, initiation of proclamation.
No. In the charge sheet, show me where he has. He can mention that you are an absconder, but no declaration can be done by the court.
Yes, my lord, that is what, my lord.
So where is that, Mr. Where is that where you have been shown as an absconder?
Yes, my lord. On the same page number 47, my lord.
Yes.
From the above facts and circumstances, my lord, if my lord may have it, my lord.
No. Show me the respective line. Don't keep on reading.
Then the house search was conducted at the residence, but she was found to be absent. Repeated efforts were made to secure her parents' house searches were conducted.
She is intentionally absconding to avoid arrest. Considering the gravity and so and so,
Well times in house was first.
okay. Okay, fine. She was mentioned as an absconder, not declaring. You are saying how court will declare an absconder.
There is one judgment of this honorable court, which similar nature of case, my lord. Similar nature, my lord of cases.
Okay, now you want what? To appear on the next date?
Yes, I'm ready to appear.
Okay, let him appear. Let her appear.
NBW issue may be, my lord.
Maybe will be kept in abeyance. Okay. Heard, Mr.
A.R. Borwa.
A.R. Borwa, Learned Counsel for the petitioner, and Mr. D.P. Goswami, Learned APP for the state, by this application filed under section 528 of the BNSS 2023. The petitioner has challenged the charge sheet being submitted in the instant case on 27/2/2026 and the order dated 2/2/2026 passed by the special judge Diffu in NDPS case number 27 of 2026, by which the petitioner was shown as an absconder by the police in the charge sheet, in the above charge sheet, and NBW was issued by the court of special judge NDPS Diffu by the said order dated 2/2/2026 respectively. The Learned Counsel for the petitioner submits that the petitioner is the owner of the vehicle which was used and from which was allegedly used and from which contrabands were allegedly found to have been seized and from which contrabands allegedly has been found. The Learned Counsel further submits that the petitioner was at her house, but at no point of time the police had visited her house, and as such, there is no question of petitioner being absconding evading the arrest by the police. He submits that the petitioner will appear before the trial court on the next date fixed without fail to face the trial. Mr. D.P. Goswami, learned APP for the state, submits that it is not a case where the petitioner was declared as an absconder, but she was mentioned as an absconder by the police in the charge sheet. He submits that the declaration of an absconder can be done only by the court of law. He, however, submits that the NBW issued by the court of law is not incorrect in view of the provision entailed in section 87 of CRPC, where on the first day itself it can be done. Which is entailed in the provision under 87 or what? Where is CRPC? Dada, CRPC kan nete ase. Entailed under section 87 of the CRPC. Ah, 87. Full stop.
I think BNSS, section 90 of BNSS.
Oh, it within bracket diva 90 of BNSS 2023. In view of the submissions made by the learned counsel of the petitioner, that the petitioner would without fail appear before the learned court of session judge, NDPS, learned court of session judge, NDPS, Diffu, in special NDPS case number 27 of 2026, on the next date, this court directs the petitioner to appear before the said court on next date is what? Don't have. Within a period of 10 days from the date of receipt of this order. Appear before the court within a period of 10 days. Or on the next date fixed, whichever is earlier. Full stop. It is further directed that till the appearance, till the set date fixed, the NBWA issued against the petitioner be kept in abeyance.
Shall not be executed.
Abeyance may not be. These are mincing of words, shall not be, should be kept in abeyance. However, if the petitioner does not appear on the said stipulated dates, the learned court would be at liberty to revalidate the order of to revalidate the non-bailable warrant of arrest issued earlier. If you don't appear. Issued by order dated 2/2/2026.
2026.
2/2/2026.
Should of the order dated ended up 2/26.
Yes. Petition is disposed of. Until except 52. Yes, 52 is what?
Appeal against acquittal. Appeal against acquittal.
Okay.
And now, my lord, the
TCR has been received.
TCR has been received.
And what about service?
This, my lord, acceptance shown.
Issue notice, accepted notice on one. What about notice? You have sent steps, you have taken steps for service of the accused person. Accused person, you are the informant. So 2, 3, 4, 5 has to be served. 1 to 5.
But there is no any indication regarding the subject. It's not saying only the acceptance.
Further, an acceptance notice has been received. What is this acceptance notice? And wait. No. Acceptance notice by the state.
It has received.
So service report is waiting, as no indication on the office.
So let us await for some more time because notice had gone only on 9/7. Okay.
Waiting.
Okay. Heard Mr. K. Bhuya, learned counsel for the appellant, and Mr. D.P. Goswami, learned APP for the state. The office note reflects that the steps for service of notice was taken on 9/7/2026. Until date, the service has not been complete. However, it is seen that the steps were taken recently, and as such, this court deems it fit to await for some more time with regard to the said service. Accordingly, list this matter on 17th of August, right? 17th of August, 2026.
Hello. So this petition is against the order of discharge. Where the
Oh, an order of discharge.
not discharge, but the discharge petition was filed that was rejected by the learned session. The offense, my lord,
Oh, against framing of charge.
against my lord, the
Rejection of
the
discharge.
rejection of the discharge.
Same framing of charge. You have challenged the framing of.
Charge is yet to be framed because on the last occasion, my lord, this discharge petition was heard and decided and rejected.
Charge is yet to be framed.
Yet to be framed. So charges FIR is basically on the allegation of false promise of marriage. My contention, because FIR itself is not maintainable, we have challenged in the separate criminal petition, which is pending. And this.
You have also challenged the quashing. You have prayed for quashing. And here you have challenged the rejection of
The order passed by the learned court of session rejecting my application to discharge the accused from the charge frame under section 169 of the BNS.
Acha, wait. You have not got any stay order here. So maybe the charge has been framed?
No, the last occasion, the Korean Bank of this honorable court has allowed us to take adjournment. So accordingly, adjournment was taken. The next date is fixed on 3rd of August.
So 3rd of August, the charges will be framed if nothing, if you don't get any order.
I am in a need for there is a need for stay the possibility. Because in the discharge application, in the order passed by the learned court, if I may take your lordship to the discharge orders, rejection order.
Where is
there was
that?
no reference. Page 37. I highlighted the statement of the.
Actually, during the framing of charge, accused person has not much to say, I think. Framing of charge stage, the accused person have nothing much to say. He was not given any defense. He cannot give any defense evidence.
No,
Only
I have not laid any evidence. Whatever I have argued on the documents, materials available on record. That is 161 statement and 164 statement, the FIR itself. When the FIR itself, my lord, it's not, my lord, doesn't disclose any commission of any offense as contemplated under section 69.
but whether you should be given an opportunity to. Where is the rejection order? Show me.
Page 37.
Do you have any judgment, Mr. Dave, showing as to what procedure should be there while framing of charge?
If grave suspicion is there, Lordship.
Huh?
If grave suspicion is there, the trial court will proceed.
What submission is there?
If grave suspicion is there, if FIR inspires some confidence.
No. The role of the accused person during framing of charge.
Nothing, Lordship.
There is a provision 250 of the BNS.
Yeah, he has not
Earlier it
taken
was
the-
227. Where there is a provision for filing discharge application. If prima facie from the available materials on record, my lord, if the court comes to a finding that no charge can be framed on the basis of the allegation.
That is 227, okay. Then he will discharge.
Is 250. So I have filed a discharge application before the court. I have argued the matter on the point, my lord, the FIR itself doesn't disclose commission of any offense as contemplated under section 69.
Acha, show me that order.
Page 37
Page
onwards.
37.
He is appealing from the informant side, but informant is not implicated.
No, there is no necessity to implicate the informant in the case under section 69, my lord, unless it is a case of POCSO and 376.
That is right.
As prescribed by notification of Deepak Nayak.
376 AB.
Yes, my lord. But
Okay. Now show me first of all, let me see the order. I'll think about this part later.
my lord, they start from page 37. The finding of the learned court after, my lord, perusing all the judgments I have relied on, but page 6 is the relevant portion.
Page?
6, paragraph 16.
Page 6, page 37.
Page 42, internal page 6. Paragraph 16.
Acha, before I go into all this, you bring judgment on the part of accused person during framing of charge, the role of accused person. Because I don't remember, but I have seen judgment where what is the part that the accused person can play during the framing of charge? Because framing of charge is based on the 173 materials.
But the court was exercising power under section 250, discharge application. So
Where is 250 of BNSS?
yes, ma'am. Accused has the right to file an application under section 250. Earlier it was 227.
227 did not provide for filing of discharge application.
It says about the discharge of an accused, if prima facie the FIR and the materials on record doesn't disclose a commission of any offense.
This is only on the basis of prosecution evidence.
No, my lord. The discharge application has to be filed. The accused, but prosecution will not pay for discharge. Prosecution will pay
No,
for framing.
Hare, prosecution will not pay for, but the prosecution materials will be seen.
Yes.
And if the case is not found strong in view of the prosecution, then they will discharge. But
My lord, that's why at the time of framing of charge, the accused is heard. If he has-
accused is heard.
that's why, my
After
lord, I
hearing
was-
and consideration, where is the truth?
For this reason, my lord, I was also heard.
And
I
but
have
then
placed-
your filing an application, if upon consideration of the record of the case, that means the 173 case materials and the documents submitted therewith, and after hearing the submissions of the accused and the prosecution in this behalf, the judge considers. So only your submissions will be there. Filing an application, giving evidence.
Lordship may then refer to the Asim Sharif judgment. This is
Acha.
2019 7 SSC 148.
Give me that judgment. What is so? I want to see those judgments on role of the accused person.
Well, at the stage, well, if I may read, my lord. At the stage of framing of charge under section 228 CRPC, or while considering the discharge petition.
While considering the discharge petition.
While under section 2.
What is that? Is Supreme Court judgment?
Supreme Court judgment. Well, there are as many as, my lord, I have relied on 5 judgments.
Acha.
There has to be a petition, my lord, from the accused, which would entail the discharge of the person. If he can show before the court that prima facie there is no materials available on record to frame charge.
One second, wait.
Asif Sharif, 2019 7 SSC 148.
NIA.
And I am a 227 file goes here.
No, so then I.
No, IPC is well.
So here it is said that at the charge framing stage, the role of accused is strictly limited to making submissions based only on prosecution's police report and documents seeking a discharge if a prima facie case is absent, rather than producing new defense material or conducting a mini trial.
Exactly. I did not produce any, my lord,
Defense material.
evidence. I was relying on the FIR 161 statement and the 164 statement recorded by the London magistrate.
Acha, so what did the magistrate say? Paragraph 16.
Paragraph 16.
I'll read it myself. Wait. Okay, it was not considered. Hmm.
161 and 164
He made a difference, the court made a difference between promise to marry and not being able to marry later. So he said that this is a matter of trial, so we will not go into it. So
I relied on the statement recorded under 161, 164, where there is no allegation regarding false promise of marriage. Plus, the Suryavan judgment is very much clear. The false promise of marriage must be of a immediate relevance or to bear a direct nexus to the woman's consent to my lord enter into a physical relationship. He must have been deceived. This is the purpose of section 69. Otherwise, every boy now and then will be arrested when there is a breakup between in the relationship. But the purpose of the legislature to bring my lord is 69 is something different.
actually records are here, that was called.
Record copy was
Records not available.
TCR has been called, not yet received. Additional affidavit filed on behalf of the petitioner. Okay, let the records come.
In the meantime, my lord, the
3rd of August.
I am not seeking to set aside the order at this stage, my lord. Your lordship will peruse the record, and by an affidavit, I have brought on record the 161, 164. Nothing more is available.
But on the first day itself, you should have prayed for an interim.
My lord,
Prayer will be considered on the next returnable
my lord, I
date.
have prayed, and the court was learned. Court was, my lord, was inclined to say my lord, stay order, but there was an objection from the side of learned PP, my lord, for some reason. The court also thought my lord, that TCR may be called for. In the meantime, my lord, by an additional affidavit, I have brought on record the 161, 164 statement. In the TCR, your lordship will not find any other document except the 161, 164. In the 161, 164 statement, the statement of the victim is very much clear. There is no whisper regarding false promise. Even in the FIR, if I read the FIR for a moment, your lordship will find there is no allegation that the promise was false. There is no allegation that I have refused to marry. But to constitute an offense under section 69, there must be a refusal from the party, my lord. Unless
that was taken care of by the learned court.
No, my lord. The Suryavan judgment is very much clear. I have relied on the Suryavan
No,
judgment.
that learned trial court has said that there is a difference between giving false promise and not marrying at
Where
the
is
end.
the false promise? Where is the allegation of false promise, my lord? In the
Okay,
FIR,
since the next date is on 3rd, let me stay this and then we will consider it on the next date.
limited term.
That is
Okay.
the fixed on 31st July, Lordship. In the meantime, record to keep reach. Then
That's
Lordship will
not
consider.
possible.
He is appealing for the informal side.
It's okay, stay till the next returnable date, okay? And on an examination of the trial court records, we will finally pass the order.
He may implicate.
Heard Mr. S. Biswas, learned counsel for the petitioner, and Mr. D.P. Goswami, learned APP for the state, by this application filed under section 438 of the BNSS 2023, the petitioner has challenged the order dated 16/6/2026, passed by the learned court of additional district and session judge, number 4, Kamrup at Gauhati, in miscellaneous case number 84 of 2026, by which the petition filed by the petitioner under section 250 of the BNSS 2023 for discharge of the accused person was rejected. The learned counsel for the petitioner submits that the FIR which was lodged by the victim does not reflect commission of offense by the petitioner under section 69 of the BNS 2023. He submits that there was no false promise of marriage and that the petitioner had committed physical relationship with the victim on the basis of the said false promise and on the basis of any false promise. He submits that he had filed an application for discharge of the petitioner from the said charges before the trial court, but the trial court had rejected the application on the ground that the question of seeing the initial promise, seeing the initial promise seeing the initial promise made, seeing the initial, the key will call the on the ground that the ingredients of section 69 would be properly examined by the trial court during the trial. And only on the basis of the allegations made in the FIR, the said charge was, or the said discharge application was rejected. The learned counsel has placed reliance on the additional affidavit filed by the petitioner, wherein the statement of the victim as well as other witnesses were annexed.
Only the victim. Other
Only the
witnesses were
victim.
not examined.
Acha, so how could you get the statement of the victim?
Only the copy was supplied, my lord, under section 207.
161 is given,
Yes, ma'am. We have applied also.
wherein the statement of the victim girl was annexed. And the same shows that there was no false promise to marry on the part of the petitioner from the initial stage. Mr. D.P. Goswami, learned APP, however, submits that based on the police papers and statement of witnesses, the discharge application was rejected by the trial court. And the same, you are not made a party, right? You are just appearing. Not required. PP is there, you can assist. It is seen that the trial courts have been called for in the instant case, and the same has not been received by the office till date. Full stop, para. However, the learned counsel for the petitioner submits that the next date fixed by the trial court is on 3rd of August 2026. And that if the charges are framed against the petitioner, the instant application will become infructuous. In view of the same, the proceedings before the learned trial court is hereby stayed till the next returnable date. Okay? List this matter on 17th of August.
Well, Lordship mentioned session case number for clarity.
Okay. In the trial court, connected with
Session
the
case
sessions case number
94 of 26.
94 of 2026 is stayed till the next return. Lordship,
Your Lordship, I am sorry to interrupt.
Your
Lordship, last section 55, there's a review
Huh.
along with the IA for
Okay.
implement. I am only paying for implement, Your Lordship.
You have filed your application for implement. Okay, I'll take up the orders matters first. Wait. Call up. Orders. Yes, 40. This is petition orders. Why it has come up for orders?
Okay, here, my lord, in this case, the petitioner, he has purchased a vehicle.
No. Why it has come? Additional affidavit?
Additional affidavit, this is paper publications. This vehicle, the person from whom we have purchased the vehicle, subsequently he lost an FIR. And the vehicle was seized by the police and handed over to the registered owner. Now, we had already purchased the vehicle. He had sold it to somebody else from whom that person we had purchased. So we were not hurt. Okay. And the vehicle was granted to the informant. So we filed an application challenging that order that we should have been heard for the Zimma order.
The Zimma of the vehicle is given to the owner.
But the owner had, our contention is that the owner had already sold us the vehicle.
Acha.
So now that owner is not traceable, we have been issuing notices to him for the last 2 years. He has not come. On the last occasion, there was an order for paper publication. That has also been done, and we filed an additional affidavit. If you kindly have at page 42. Contains 7, no?
So now the owner, the vehicle, all missing.
All missing.
And you have also done the paper publication and then
Till then nobody has come.
nobody has come.
Madam,
So, okay, let me appoint an amicus
amicus
then.
may be appointed for
Okay.
2 other.
Heard Mr. S. Nawaz, learned counsel for the petitioner, and Mr. D.P. Goswami, learned APP for the state. It is seen that the service of notice is not complete upon respondent number 2, 2 and 3. And as such, by the order of this court, a paper publication was also done. And till date, no representation on behalf of respondent number 2 and 3 has been done. In view of the said facts and circumstances, for the ends of justice, this court deems it fit to appoint an amicus curiae to defend the cause of respondent number 2 and 3. But what will happen? Can the vehicle be brought back even if some?
Perhaps, my lord, if your lordship, after your lordship examines it and finds that there is some, because we are not seeking for the order per se to get passed here. You'll only be seeking for the matter to be remanded back to the trial court. If it goes back to the trial court will also have access to the IO. Since the IO had given the vehicle by taking it.
Then that can be done even in absence of amicus, right?
Tomorrow again, they may come up and say that they were not heard.
Okay.
Okay,
Amicus to defend the cause of respondent number 2 and 3. Accordingly, Mr. Nimish Mahajan, learned counsel, is appointed as the amicus curiae. Learned counsel for the petitioner would serve the necessary copies upon the learned amicus curiae at the earliest. List this matter for further consideration on 12th of August 2026. Yes. No more substantial orders, huh? I'll just see what are these orders for. Yes, 21, 41?
We'll take up IA 118 of 26.
Uh-huh.
IA criminal 118 of 26, my lord. My lord, during sentence of the criminal revision petition, my lord, challenging, my lord.
What is this IA for?
Lordship. IA for lordship NBW, my lord, it was issued against me, my lord, for non-payment of maintenance amount, my lord.
No, not
So
41, 41.
41, let me complete. Then, my lord, what happened? Criminal revision petition was filed, and almost 1 year it is pending before this honorable court, my lord. Record was called for, not received, and during this pendency, my lord, this, my lord, NBW was issued, my lord, which was sentenced under this IA 118 of 26, my lord.
So you go and appear on the next date?
My lord, I
we
will
had-
appear,
copy
but
has not been
there is-
furnished to
there
us,
is some
lordship.
problems, my lord. Please let me.
Okay, IA is not given to you.
Yes, Lordship.
That IA was filed, my lord, and copy also served, my lord. Earlier,
No, we have
they are
received the,
They are changing advocates, my lord, frequently.
we have
Earlier,
received the
one-
copy of IA 802, Lordship. Today even in the cause list most probably.
It is 118.
Second part, maintainability point, Lordship. Second part, Lordship. They have challenged the order of family court, Lordship.
Expert
Yes.
judgment, my lord.
Let me just say, I'm raising a maintainability point.
Mm.
As per the notification number 30, date of 22nd May 2024, all orders coming out of family court, Lordship, should be heard by division bench, Lordship.
No, there is,
That
the
is a
section
circular
19
note.
only provides.
Circular only, Lordship.
Section 19.
Lordship.
This is an appeal will lie before the division bench.
No, even criminal revision petitions, Lordship. All orders, it reads in partial modification, Lordship. Matrimonial appeals matter arising from the orders and judgments of the family courts.
Okay, so other
Matters
than family
arising
courts,
from
it
the
will be before so and so.
Other than family court?
So this is a family court order.
Yes,
Under 125, matter is that, my lord, criminal revision petition was filed, my lord, last year, my lord, almost 1 year back. What happened, my lord? It was expertise judgment, my lord. I was not given opportunity to appear. I was not summoned, my lord.
So, but all matrimonial matters, okay, registry to find out and list the matter accordingly.
No, they are listing it before the division bench, Lordship.
Okay, heard, Mr. Heard, learned.
Otherwise, my lord, NBW is issued, my lord, I will be taken in custody, my lord. If I am not protected, when it will be listed? Who knows,
But
my lord?
there is a notification, everything has to be listed before the division bench.
Otherwise, I is before your lordship and matter is pending since last year, my lord.
They are not paying a single penny to us, Lordship.
How
I
can I
want-
pay, my lord, whereas I was not even given opportunity to appear in the case. I was not known what was going on there, my lord.
Whatever it is, this is a matrimonial issues. And that has to be listed before special division bench. So let the registry put it up. See the application. You should have, why? It is your fault. You should have appeared before that court. You have not got summons or what?
No, my lord. Yes, my lord. I was not served any summon, my lord. Then, my lord, when I came to know, my lord, when
So it
execution
is
was
almost 5. I cannot keep on hearing everything. So you do one thing, Liz, the learned counsel, both sides are represented. Learned counsel for the respondent has placed a notification dated 22nd of May 2024, by which it was notified that all the matrimonial appeals as well as matters arising out of orders and judgments of the family court would lie before the Honorable Special Division Bench. The registry is directed to examine the matter and place this matter before the appropriate bench.
Date may be fixed. Otherwise, then next date is fixed on 3rd August. I will be taken into custody, my lord, because of this NBW, my lord. Date, my lord, I understand that Lordship is referring to.
They may mention it tomorrow, Lordship. Where is the bar? They may mention it tomorrow, Lordship.
My lord, Friday.
But
on
the
Friday, my lord.
registry has
The
to.
matter on Friday, my lord.
No, I cannot fix because registry has to see whether this is a matter of matrimonial issue, the IA and all. Then they will place it. Okay.
My lord, mention me.
You mentioned
Oh, I
it.
mentioned.
You mentioned before the trial court also.
Item number 42 and 43 already fixed for hearing by order dated 25/6/2026.
Huh. Hearing, so it has come up for orders mistakenly.
It is wrongly listed.
No,
It is already.
Okay, you're right. Both sides are represented. The matter was supposed to be listed for hearing, but it has come up for orders. Registry to list the matter for hearing.
Fixed for hearing, my lord, by order dated 25.
Ah, so
Yes.
that is I've said. For hearing on 13th of August.
Lordship, kindly see, Lordship, IA is there. Kindly see the IA order, Lordship, 36/2025, Lordship.
IA is not there. There are two criminal appeals.
Lordship, IA is there, Lordship, the suspension of sentence, Lordship.
Huh.
That's because there is a 2 cases, Lordship, here. The second matter, 43.
Hmm.
I am the, Lordship, there I am for appellant, Lordship. And Lordship, he was convicted, Lordship, for 7 years.
In which matter?
43, Lordship. 42 and
43.
43, Lordship, same matter.
There is an IA for suspension of
Yes,
sentence.
Lordship, yes.
So that was not, that should have been considered on the very first day itself.
Lordship, kindly see, there is an order, Lordship.
What order?
Lordship, on 3/6/2026, Lordship. As because why this matter I has not been considered as because Lordship.
List the matter, let the matter be listed for consideration. Nothing else in
Yes.
636 order.
Lordship, on that day, Lordship, what happened? That subsequent appeal filed by this informant. So that's why, Lordship, on that day, I was not, notice was not served. So that's why the court was advised that on the next day, your IA will be considered.
Hmm.
So that's why, Lordship, my IA may be considered today, Lordship.
There is no time today to consider.
Lordship,
Since the
And I have no stamina also.
Lordship,
There is a limit.
Lordship,
Okay, so I'll consider your IA on the next date.
Lordship, then
Both the matters can be heard and disposed of. I fixed the matters
Yes.
on 12.
Already fixed for hearing, my lord. TCR has come, my lord.
TCR has come. I will also be considered
Yes,
that
my
time.
Lord-
If at all, if we do not dispose it of, then the IA will be
Lordship,
considered.
in this case, Lordship, my on Lordship 3/6, since 3/6, that same incidence is arises, Lordship. Then the hearing has not been taken place. That's why, Lordship, my case is very prima facie case, Lordship. There is a fair acquittal, Lordship, and now 8 months is going to complete, Lordship. So
This is an appeal against acquittal.
My lord.
one acquittal.
Okay, we will hear it on the next day.
Yes, my lord.
Lordship, kindly given a date, Lord. Or if day
I've
day after
given
tomorrow,
date,
day
I'm
after
giving
tomorrow,
the-
Lordship, Friday, Lordship, kindly.
Huh?
No,
13th of August.
Lordship.
I've given the date.
Highly appreciate.
My lord.
There is a delay. We will hear it on some other day. There is a delay of how many days?
No delay, Lordship, carrying leave of this honorable court to file a criminal appeal.
There is a delay of how many days?
No, not delay, Lord.
What is this IA about?
Application for carrying leave of this honorable court to file a criminal appeal against the.
Leave.
Yes.
There is no delay.
No delay.
Only leave. Yes.
Lordship, regarding this, I want to bring your lordship's attention to certain dates, lordship. The
regarding
judgment-
facts of the case.
Yes, the judgment was passed on 16/6/2025. They applied for the certified copy on 24/6/2025. There was a 8 days of grace period. And considering the limitation period, which is of 60 days, apuni-
They believe of the liable court to file a criminal appeal
Exactly.
against the acquitted.
The section must have done it. There is no delay.
But there is a limitation of 60 days, Lordship, for this leave appeal.
Mm.
This leave application, for this, there is a 60 days of limitation period, and that is beyond. They have filed 23 days beyond the limitation period, Lordship.
But then the section should have seen it. The filing section has not found any delay.
They should have filed the condemnation of delay first, Lordship. For that application was necessary.
No, whenever an appeal is filed, the section will see whether there is any delay, but then there is no such delay, it seems.
There is a delay, Lordship.
No,
Okay, you examine on the delay, and if there is any delay, then file an application.
no. They have 90 days for
90 days, yes.
90 days.
90 days for filing of an appeal against conviction.
Acquittal.
Acquittal, Lordship, a special for the leave application, the limitation period is 60 days. If you see section 419 of clause 5 of BNSS.
I file along with the.
No, limitation is provided under the Limitation Act. You will not get it in the CRPC. Limitation Act, what I remember is 90 days. When we state files an appeal, we know that it is a 90 days against conviction. Against acquittal, you are saying. You are filing an application against acquittal. Acha, examine the case properly and can come. On the prayer made by the learned counsels for all the parties, you bring the Limitation Act and all. It is not provided in CRPC. List this matter on 11th of on 10th no on 12th of August 2026.
Service not complete, Lordship. Service not complete.
Service not complete. POCSO.
First Lordship. I have taken a step on this one number 2 on last 19/6/26.
Yes, Miss, what POCSO matter, right?
Yes.
Okay, Miss Bora, you have to bring the service report, the instruction.
Yes, Lord. Item number 45.
Heard Mr.
A.K. Ahmed.
A.K. Ahmed, learned counsel for the appellant, also heard Miss S.H. Bora. It is seen that the service upon respondent number 2 is not complete, and as such, Miss S.H. Bora is directed to get the instruction regarding service of notice upon respondent number 2. List this matter. List this matter on, you just get the instruction, Mrs.
Lordship.
List this matter on 7th of August.
Lordship.
Lordship,
Again, there is a delay.
Yes, my lords.
The steps of notice upon respondent. So respondent, you are appearing.
Respondent 1, 2, 3, and 5.
What about 4?
4? No.
Heard Mr.
M. Burman.
M. Borman, learned counsel for the petitioner. Miss,
Lordship, for the respondent number 5, the name is actually the Rabindra Das, but in the petition it has written as Rabi Das.
it's okay, you appear. Miss,
Lordship, actually, the workaround number will not be accepted. They have signed.
Her grievance is that because there is a name discrepancy, the worker number would not be accepted. But my lords, if my lord may make an observation to that effect, my lords.
you file an application correcting the name.
I can do it, but the only thing is that the lady is from a very poor background and she stays in Kokrajhar.
Mm.
So communication is little difficult, my lords. Otherwise, it's not been problem. I understand, my lords.
Okay, you miss.
D. Goswami.
D. Goswami, learned counsel appears for respondent number 1, 2, 3, and 5. Miss Counsel also submits that the name mentioned as respondent number 5 is not correct. And she submits that Filing wakalatnama for the said respondent would be a difficulty. As such, the learned counsel for the petitioner, for the applicant, for the petitioner as applicant, what is this? Applicant is permitted to correct the name of the respondent by hand in the said petition for the ends of justice. List this matter. However, steps for service of notice upon respondent number 4 is not complete.
Respondent number 4, no, not completed.
Respondent number
Yep, no.
4 is not complete. The petitioner is directed to take fresh steps for service of notice upon respondent number 4. Is this a POCSO matter? No.
No, my lords, it is an appeal against the revision against the DV appeal, my lords.
4. List this matter on 17th of August 2026.
Oblige, my lords.
Yes, 47.
Fine. And my lord,
Okay. Heard, Mr.
here, sir.
P.R. Sharma, learned counsel for the petitioner. The office note reflects that the service upon the sole respondent. No, service upon respondent number 2 is awaited. List this matter again for further consideration on.
My lord, TCR may also be called.
TCR has not been called.
TCR has not been called for.
This is for what?
For quashing of a proceeding, my lord, NI proceeding, NI case. My lord, it actually arises from a contractual dispute, my lord. It is of a civil nature.
But whether it is required, TCR will be required.
My lord, perhaps because, my lord, in this case, my lord, till now, my lord, we have not appeared. But, my lord, the petition will itself show, my lord, certain facts. So perhaps TCR.
Further, okay, further on the prayer, further, the scanned copy of the TCR be called for. List this matter on 17th of August.
So obliged.
48, yes, Miss L. Devi. See, criminal, what, jail appeal?
Jail appeal law.
What is the offense?
Section 6 of the clause.
POCSO. So let the notice go. Heard Miss L. Devi, learned legal aid counsel appearing for the appellant. For the applicant, For the applicant. This is an application for condoning the delay of 315 days in preferring the connected criminal appeal. Issue notice to the respondent number. Issue notice to, there are 3 petitioners. Issue notice to respondent number 2. Petitioner to take steps for service of notice upon respondent number 2 through the office of the registry. Office of the public prosecutor. Miss S.H. Bora appears for respondent number 1. List this matter on 11th of August. Only notice required, nothing more than that. You take these steps so that I can appoint amicus and condone the delay.
Not.
Yes, 49. None appears on call for the petitioner. However, Miss S.H. Oh, you're there. Yes. What has? Okay. Notice has been issued. Heard, Miss?
He does.
He does, learned counsel for the petitioner and Miss S.H. Bora. The office note reflects that the service of notice upon respondent number 2 is awaited. List this matter for further consideration on 19th of August. 50.
The matter may be transferred further.
Okay, on the prayer made by the learned counsel for the petitioner, list this matter after 2 weeks. List this matter after 2 weeks on a date to be fixed by the registry. Yes, 55. Yes, Mr. Counsel.
I'm sorry to keep your lordship waiting.
No, I just wanted to finish the list.
Your lordship, I have filed an IA. To your lordship.
In the Goa, I was a party, the school managing committee has not been made leader here.
But how come this school management thing is before me? My order.
Yes, in the petition, the petitioner has not made us party. That's why we have filed a review. But before the review can be taken, we have to be.
But you were not made party respondent.
Yes, yes.
But perhaps no relief was claimed against you.
No, because we as a school managing committee, the petitioner was allowed to function as in charge principal of the school year.
Where is the order?
Order is in the review. Your Lordship, can you see page 20? Page 20 of the review petition. Relevant
Page 20.
20. Relevant portion page 26. 27, Your Lordship. What happened, Your Lordship? In this, the writ petitioner was allowed to function as in-charge principal of the school. But subsequently, there was complaint from various sectors, and there
I'll
are
have to
persons.
see this.
Yeah.
Okay, let me list it in some other date.
Only I am just, that's why I am not paying for the review petition. I am just paying for implement of the IA. That can be done, Your Lordship. Thereafter, review will be taken, Your Lordship. Without our implement, I cannot, the review petition cannot be taken. So, only implement.
No, implement.
Because you are the school managing committee, there's many facts which are known to the school managing committee has not been brought to the notice of this honorable court. That's why this order has been passed, Your Lordship. So, school managing committee is a necessary party in the writ petition.
Review you have filed.
So I have filed a review. Without our implement review, I cannot appear in the review.
Why? Affected party can file an appeal or review without it. You have made yourself a review petitioner now.
Yes.
So implement why it is required.
If Your Lordship think that our implement not necessary.
Not necessary, because now you are a review petitioner. You were not made a party during writ proceedings.
Yes.
Okay, but you are an affected party.
Yes.
And then we will see the maintainability also while seeing the review petition. Implement as such will not be not necessary.
Okay.
Okay.
Only
So you are
one thing,
withdrawing
Your
this
Lordship.
I?
Only one thing. In the review petition, then I have to, post title has to be corrected, Your Lordship.
Post title in what manner?
Post title, the writ petition on Your Lordship. In the review applicant.
Review applicant, review applicant is school management committee represented by its
Yes,
members.
yes.
Oh,
The writ
okay,
petition-
sometimes what happen? An appeal is disposed of without somebody being made a party. And if that party is affected, he can come and file a appeal before the division bench. There is no bar.
So post title.
So in similar way, you are affected by the order. So you have filed a review application, or you can have filed an appeal also before the division
That
bench.
is not necessary because only some modification is required after hearing this.
So it's okay, impleading yourself
No,
in
no.
the petition.
In review petition, the writ petition has to be made party in the post title, Your Lordship.
Writ petition is disposed of.
No, writ petition has to be included. That we will correct, Your Lordship.
Writ petitioner definitely has to be there in review petition.
Yes. So there is a left in the first cost.
Acha. Okay, in the cost
Can we be
item.
allowed to?
Okay, as far as I is concerned, you can withdraw this. You right, the learned counsel appearing for the petitioner submits that he has instructions to withdraw the instant IA, matter is closed.
Since that the same is not required.
If this not required, you want to implead whom in the review petition?
Myself, in the IA.
Not required. It's okay. You file your review petition. We will hear it. Okay.
Review has already been.
In review petition, you write that the learned counsel appearing for the review petitioner seeks to correct the cost title of the same. As such, the petitioner is allowed to file an application correcting the cost title. Cost title.
Review may come any day on the.
Let the matter be listed on a date fixed by the registry.
Any day, Your Lordship will be.
Okay, let the matter be listed on, will you say 10th of August?
As per Your Lordship only.
Now I'm taking up criminal matters. So, okay,
Yes.
after 1 week, 12th of August 2026.
20.
12th of August.
Mark with it, mark with it.
Okay. Jai Hind. Okay.
I am sorry, Your Lordship.
No, no, not at all. It's okay. This is my duty.